Good morning, everybody. Bright and early. Welcome back. We are really exploring the outer limits of what makeup and lighting and camera lenses can accomplish this morning, because it is an early one. But hey, here we are. We are ready to get back to this trial. We're going to have Trooper Bukhenik back on the stand for more cross-examination. But first, we got this motion hearing. That we heard about at the end of the day on Thursday, the last time we were in court. And so I promised you guys I'd go ahead and take a look at that and let you know what I thought before we get into that hearing this morning. So I did. I was able to find it. It was pretty much all over Twitter as soon as the live stream ended. So it wasn't very difficult. And it turns out that this is a discovery motion. It's a discovery dispute. The Commonwealth doesn't like the way that the defense has disclosed a number of their experts, the accident reconstructionists, and there was one other one as well, where they're essentially asking the court to say, make them give us, the Chris Van E., the expert in biomedical and mechanical engineering. So the Commonwealth is saying the defense hasn't properly disclosed their opinions, what they're going to say, the basis for it, and things like that. So they're trying to compel the defense to have to produce more information about those particular witnesses and exactly what they're going to say. But then there is Dr. Marie Russell, who apparently is a late disclosed witness by the defense. She is a forensic pathologist and an emergency room physician. And so she was first disclosed by providing her CV on May 21st. So not that long ago, well after the trial had already started. And then on May 30th, a synopsis of her testimony was provided. And it says she's reviewed the autopsy photos, grand jury testimony of Dr. Scordy Bello, who is the medical examiner, the entirety of the autopsy report, all reports associated with Chloe's prior bite history, photographs of the items and evidence, and the UC Davis DNA testing results and evidence submission forms. What this makes clear is that she's relied on stuff that the Commonwealth has now put into evidence, right? The UC Davis DNA stuff, and then obviously the medical examiner stuff that we know is coming, the bite history, and then photographs of the items and evidence. So her opinion is based on stuff that has been presented to the jury since the trial started. What the timeline of that is in terms of when that was produced to the defense, when the Commonwealth made it clear they were going to rely on those things, that's a little bit still up in the air. We haven't yet seen Mr. Jackson's response, at least I haven't, and that's not surprising because it probably wouldn't be uploaded to court over the weekend. Judge Bev had basically said, just email it to me, so that's likely what's happened. It'll pop up on the docket at some point, likely later today. But we'll already presumably know the outcome from the hearing at that point. So continuing, this doctor is expected to be called with focused testimony related to the right arm injuries sustained by Mr. O'Keefe. Dr. Russell will testify that the wounds and injuries on Mr. O'Keefe's right arm are consistent with an animal attack, namely teeth or claw marks, or a combination of both from an animal. She will also testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. She will base her opinions and conclusions in part on having treated hundreds of patients in the ER with injuries sustained from animal attacks, including dogs. No written reports or opinions from Dr. Russell were provided. So the nature of the Commonwealth's opposition here is they're saying it's too late. You're too late to disclose this. The rules say that there's a timeline for when these things have to be disclosed. You didn't comply with the timeline, and we're prejudiced by that. So they've cited quite a bit of case law, a number of cases dealing with these discovery standards, and particularly how they interact with the defendant's right to present a defense. Jury trials aren't supposed to be about gamesmanship, right? It's not supposed to be just who can outmaneuver the other one when it comes to presenting evidence. There's supposed to be determinations on the merits. And so because of that, if the defendant has material evidence in their possession that relates, to guilt or innocence that would tend to have a significant effect on the outcome, then there's a very, very strong presumption in favor of allowing that to come in. And there have to be some pretty egregious violations in order to justify just completely excluding that from trial. And in part, that's because they can impose lesser sanctions if they are concerned that the attorney has, acted in bad faith, has, tried to engage in gamesmanship rather than just forthright, exchange of information and so forth. There's typically other things they can do. If your problem's the attorney, find the attorney. But you don't punish the defendant by not allowing them to present material evidence in order to support that. So what I found fascinating was that of the main cases, there are 3 main cases that the Commonwealth relied on in their motion. And in every single one of them, excluding the evidence was overturned. It was an error. It was found to not be basically good cause to justify overcoming the defendant's right to present evidence. So there is a test. This test is laid out pretty specifically in all of this case law, sets out these factors that the trial court is required to consider before they're going to allow evidence to be excluded. So they're supposed to look at prevention of surprise, if the evidence is in bad faith, if it causes prejudice to the other party, if there's less severe sanctions that would be effective, and then the materiality of the statements to the outcome of the case. So let's just look at this real quickly ourselves. First off, materiality, dog bite evidence. Yeah, no question. If they have a witness who's going to say this is a dog bite and the person is qualified to render that testimony, which, a forensic pathologist is going to be, then that's pretty material, because how do you get his arm bit by a dog while he's getting hit by a car? And this is not real consistent with the Commonwealth's theory of the case. Prevention of surprise. This is the one that Lally is really leaning on, surprise and prejudice, because apparently, according to him, late disclosure means that they aren't going to be able to effectively combat it. But here's the problem. I've been looking back since I didn't follow the pretrial stuff in this case. I don't remember when the dog bite first came up. I don't know. I know I had heard about it before. I'd heard about it before trial, certainly. So I can't see that this is a big surprise to the Commonwealth. But funny enough, when I go back to actually look at it, I find this news report on CBS News. It does a timeline of the case, and they have the first time that this dog bite theory gets brought up in court is over a year ago. It's May 3rd of 2023. So I don't know how you're saying you're surprised by something the defense has pointed out for over a year. You knew that this was a possible theory. And as far as prejudice, this is a forensic pathologist. You have a forensic pathologist on your witness list. I think there might even be 2, because there's an initial medical examiner and then another doctor from the medical examiner's office. So it's very typical in the case of experts that while an expert is testifying, your own expert is there present in the courtroom listening to what they have to say. They tend to get exempted from that exclusion order. So they get to hear what the witnesses have to say, and then they're able to respond to that. And that's how you can have a meaningful exchange of expert opinions on these types of issues. So interview, go ahead and interview this witness, set that up. Still got a couple weeks left before we're going to even get to the defense case, right? We're not going to be in session tomorrow. We're not going to be in session over the weekends. Don't know yet what next week's schedule is going to look like. But, hello, there's been time. And there was time before this. We had a lot of time off last week when this could have been accomplished. You already had the curriculum vitae. So you knew that this was an issue, could have potentially been arranged to handle that. So interview the witness, have your expert sit in on the witness's testimony so that you can call them in your rebuttal case if they're going to respond to it. This is just not really to me, a particularly compelling argument for the Commonwealth being real hard done by here. I don't know the explanation for why is this witness late disclosed. The counterpoint to it being out there in the case for over a year is that, well, then you would think that the defense would have had a witness. They would have had an expert already opine about that. They would already know, they would be able to disclose that. And so I don't know what the explanation is for why they haven't. Sometimes people retire, they become unavailable. You got to replace them on short notice. Things like that can definitely happen. So we'll just have to see what Mr. Jackson's response to that is. But the bottom line is that absent a finding of bad faith by the attorney, and quite frankly, even with a finding of bad faith, like in at least one of these cases, there was a finding of bad faith. Like the attorney explicitly admitted, yeah, I did this for gamesmanship reasons. I did it to be strategic, to not disclose this person until the 11th hour. And even in that case, these other factors overcame that particular consideration, namely the fact that you can nearly always find an alternative sanction that is going to address whatever problem you have with the lawyers, but not penalize the defendant's ability to defend herself, to be able to put out facts that would say, yeah, this is a kind of important thing that the jury should know. These are decisions the jury is supposed to make, not the judge sitting on the stand, not the judges up at the appellate court level. It should go to the jury, and they should be making that determination. So based on all that, it seems like from a legal standpoint, this should not be excluded. Pretty much regardless of the reason for why it's late disclosed. I'm sure we're going to hear, Mr. Jackson or Mr. Yannetti, whoever handles the motion, is going to explain whatever the circumstances were that caused the late disclosure. If she hasn't disclosed a report, it's often they don't write a report. Okay, and sometimes that can be a gamesmanship issue. You do that on purpose with your experts a lot of the time. You just have telephone conversations with them about what they're going to say and what their opinions are going to be. So you don't have a written report that needs to be disclosed, because then, of course, they can go over it with a fine-tooth comb, nitpick it, and so forth. So that is particularly, that can be gamesmanship, but it's common and it's permitted under the rules. There's nothing that says an expert has to write a report in any particular case. So the bottom line here, as I see it, is just that they have a forensic pathologist who's going to disagree with the conclusions of the forensic pathologist that the Commonwealth is planning to call. And this should not come as a surprise. The forensic pathologist, I would think, should already be prepared for this, because a year ago, the defense brought up, we're going to be arguing that this is a dog bite. So did you not ask the medical examiner about that way back when? It's part of your trial prep. Did you, you knew it was coming. You knew it was coming. So legally speaking, they probably should not be excluding this. That said, this is Judge Bev. We don't know what she's going to do. She will, under this case law, really need to make some pretty specific findings about the basis, those factors that we talked about supporting her ruling. So we'll see if she does that. But there's this funny language in all of these cases that I just love, because I hear it in that Boston accent. It says the preclusive sanction should be reserved for hardcore transgressions. Hardcore. It's just funny to see that in a legal opinion. I'm totally in favor of plain language legal writing, by the way. I don't think it's necessarily adding anything when the court is using all these flowery terms and things like that. Just say what you want to say what you mean it. So if you need a hardcore transgression, then just go ahead and put that in the legal opinion and make that the standard. So anyway, that's going to be the question. Is this a hardcore transgression based on these factors, or is it just a fairly mild and insignificant thing? So we'll see. That's what we'll get first. And then we will get back to Trooper Bukhenik. And boy, has there been a lot of stuff over the weekend just flying around. If you did not see my Substack, I did get a piece out about the tail light. Remember last week I was kind of thinking out loud, okay, all these different searches for all these pieces of tail light. What does that actually mean? Like, which of these pieces actually ended up fitting in with the tail light? Was there like a ton of leftover plastic? Because the timing of that search is the one that is critical in my opinion, because if we assume, and we're just assuming at this point, based on what's in evidence and the kind of challenges that have been raised, if we assume that the Sallyport video timestamp is correct, and Karen's car didn't make it back to Canton until about 5:30 in the evening, but we have CERT already starting to arrive on the scene a little bit before 5 o'clock is when Lieutenant O'Hara gets there. And then people are continuing to arrive over time, and it's about 5:45 then when they start their search. So it's a pretty narrow window for when that crime scene is still completely unattended. It's not that, it's impossible for something to be planted after the CERT team starts to arrive, but it's harder to sell as a theory, in my opinion, because you have to explain then, well, why didn't anybody see it? Are all these people in on the conspiracy too? That type of thing. And I totally grant, yeah, there's 3 mystery unidentified police officers at the scene. O'Hara didn't seem that interested in knowing who they were. I mean, the integrity of your scene during this search, you got people there that you don't even know who they are. But he's just going to assume, well, they're law enforcement officers, so they're going to be okay. I recognize, yeah, these are all openings that the conspiracy could have occurred. There could have been evidence planted during that time frame, but it just becomes a much harder argument for the defense to make. Whereas if it's completely unsecured, it's easier to argue that, Trooper Proctor, Trooper Bukhenik, or somebody like that ran some taillight pieces over there from Karen's SUV, planted them, and then left them there for the CERT team to discover. But as it turns out, when you go back and you look through the testimony of Ashley Valier, the one who did that whole reconstruction with the taillight, she goes through and they have the evidence bags for all of the pieces that were submitted for her examination. And the peculiar thing about it is not a single one of those bags is dated as in terms of logged into the evidence system and sealed, initialed on the evidence tape, signed, initialed by DMD, which I believe is going to be Trooper David Deccio, until February the 4th. February the 4th is the earliest date that any of this was put into evidence. So this to me is a big old problem. Okay, this is a big problem with your chain of custody, because we don't know then what happened to these pieces that, according to Lieutenant O'Hara, Sergeant Tully was in charge, or Lieutenant Tully was in charge of. He was in charge of that search. He was the one that was responsible for the evidence, maintaining the log, the documentation, and so forth. It was on Tully. So why on earth didn't Tully book what he recovered on January 29th into evidence on January 29th? Why is, at best, okay, the best case scenario is that for the Commonwealth, to be consistent with this theory, the best case scenario is that he gave it to Trooper Deccio, and Trooper Deccio hung on to it for 6 days and then sealed it up and logged it into evidence. I mean, how does this make sense at all? Because the alternative is, yeah, he booked it in himself, but it wasn't included in either what went to the crime lab or what was used in this match analysis. So the best case scenario for the Commonwealth here is yet another just massive discrepancy, a huge problem in the evidence handling procedures. In the case that is the one case, the fallen police officer, a dead police officer, where you would think, we are going to do everything clean by the book so that we can nail whoever it is that got this person, so that we give them no ammunition whatsoever to be able to raise issues at trial. You would think that's what they would do, but no, sloppy decision after decision after decision that's messing this case up. And this is not just rookie mistakes, okay? This is not just a guy who happened to be out at the scene, but maybe doesn't really do a lot of this type of work. Maybe it's his first time at a crime scene or something like that. No, this is nothing like that. These are the supervising officers, okay? These are like the top people. They have the most training in all of this. They are the most responsible for all of this. They're the ones who should be overseeing the entire crew and making sure everything is done by the book. And yet they're the ones that are causing these problems. So it's just a very, very peculiar set of circumstances where the Commonwealth has to either argue that this is the sloppiest investigation that they have ever conducted, or see, there's grounds to believe
22117 Commonwealth versus Karen Reed. Counsel and Your Honor, just for your information, at this very second, FTR is not running. Ms. King is the official anyways, and she is on the record.
Okay. All right. Good morning. So we're here on the Commonwealth's renewed motion. Can we turn off one of those air conditioners, please? The Commonwealth's renewed motion for reciprocal discovery and the motion to exclude the defendant's newly provided expert, Dr. Marie Russell. I will hear you on your motion, Mr. Lally.
Morning, Your Honor.
Oh, I'll hear you, Ms. McLaughlin.
Essentially, the Commonwealth is just seeking that the defendant produce what the Commonwealth is entitled to under Rule 14 and what every criminal defendant in the Commonwealth of Massachusetts must produce to the prosecution. It was not until the day prior to trial on April 15, 2024, that the defendant provided notice of all their experts. During jury empanelment, the Commonwealth filed a renewed motion for reciprocal discovery, and the defendant was ordered within a week to produce the expert opinion testimony that the Commonwealth is entitled to. We are now entering, I believe, week 8 of the trial. The Commonwealth has not received any intended expert opinions, anything that those experts, any written reports, opinions, or anything that those experts have based their opinions on. Essentially, the defendant's strategic decisions not to retain their own expert, but rather rely on the U.S. Attorney's Office investigation does not alleviate them or relieve them from their Rule 14 obligations. As it pertains to Dr. Marie Russell, the Commonwealth did not receive notice that she's an intended expert until about week 6 of the trial on May 21st. And it wasn't until May 30th that the defendant provided a brief synopsis of what her expected testimony would be. Essentially, and looking at the balancing tests set forth by the case law, the Commonwealth was extremely surprised by this disclosure. And further, the Commonwealth would put that the defendant's delayed decisions to produce reciprocal discovery is in bad faith. It is intended to ambush the Commonwealth and conduct a trial by surprise. We are still receiving reciprocal discovery. Over the weekend, we received additional photographs that the defendant intends to use. The Commonwealth is extremely prejudiced by these delayed disclosures. So looking at all the balancing factors, exclusion of Dr. Russell is really the only remedy that's appropriate.
Oh, is it? Why don't you argue some other ones?
Week 8 of the trial, the Commonwealth cannot seek a continuance.
There's other factors
here. The Commonwealth is has their hands tied with how to effectively prepare for cross-examination of that witness as well as all the other witnesses. We don't have any materials. We don't know what the experts' precise opinions are and what they were testified to. And it's essentially, it is in bad faith and there's no less severe sanction. So the Commonwealth would move to exclude Dr. Russell. And at this point, we're essentially just seeking the reciprocal discovery that the Commonwealth is entitled to be able to effectively prepare cross-examination of these witnesses so late in the game. Thank you very much.
All right, who's arguing this for the defendant?
There's no mic at
Yannetti.
council, so I'm going to go to the podium with the court's permission. We need to be heard on this.
That's why we're here, Mr. Yannetti.
Thank you. I'd like to start with the most outrageous and false assertion that the Commonwealth made in its motion.
Can I just ask you, there's no jury here. Can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay.
tops.
Because I don't need.
How
the
long is this
hyper-
gonna take?
I need to make my argument in the way that I think is most effective for my client.
Yeah, he
I will
needs to
keep
make
this
his
brief and
record,
succinct,
Bev.
But I have points to make that I need to put on record.
Okay, and I'm the person you are trying to convince,
Understand.
correct?
I understand that. The
Wow.
Commonwealth, in a public filing, wrote the following on page 3 of its motion. Quote, during a pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is false. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm
and
sorry?
I don't have that in my motion.
It's on page 3, Your Honor.
I have the Commonwealth's renewed motion for reciprocal discovery, a motion to exclude defendant's expert, Dr. Marie Russell.
Yeah, it's there. We saw it.
I don't see your name at all, Mr. Yannetti.
It says the defense. It doesn't say Mr. Yannetti, Bev. Don't play
I'm on
this.
page 3.
Deliberately dumb game.
My apologies. My name is right there on page 4. It says exactly what I just argued to the court. It's about the 5th line down. It starts during a final pretrial hearing on February 15th, exactly
Okay.
as I said.
Okay?
All right? We pulled the tape from that February 15th hearing. Here is what was actually said. This court asked me the following, quote, while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that? I replied, no, I think this is the only outstanding DNA issue. The court then replied, okay, so all right, we're not dealing with canine DNA. And I said, no. There is nothing in there, contrary to what the Commonwealth has represented to this court in a public filing, that I said there was no canine involvement. There is nothing in there, contrary to what the canine represented to this court and to the public, that the defense was not pursuing such a claim. Can you imagine the nerve of the Commonwealth to spin that into...
This is the hyperbole I don't need. Could you please get to the point?
Your Honor,
We've got a jury coming in 15
He needs to make
minutes.
I
his
understand,
record.
but this is my integrity has been attacked. There have been allegations of bad faith that has been attacked, and I need to defend myself and my client. We
Exactly.
were only discussing at that time whether canine DNA was still outstanding, and I succinctly replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our right to argue that John O'Keefe's arm injuries were consistent with a dog attack. And I ask you, have they no shame?
Have they no
I'm sure it's
shame?
not lost on this court that this false filing by the Commonwealth comes on the heels of their nefarious attempt to pass off an inverted video, a false video, before this good jury hearing this case. Never once during the direct examination of Sergeant Bukhenik did they inquire or mention the fact that the video...
Can we please, all right, I'm going to stop you. Please direct your comments to Rule 14 and the reciprocal discovery obligations that the defense has. That's what this motion is. I know you have a speech you want to make, Mr.
It's
Yannetti.
not a, Your Honor, it's most respectfully, it's not a speech.
Speech.
Okay,
It's
so-
a defense of being alleged to have committed bad faith.
So you've moved on from that. So please just focus on Rule 14 and let's do it in 2 separate parts. So you've changed, you're not calling Frank Sheridan,
No,
right?
we are calling Frank Sheridan.
All right. So you've got a new medical, Dr. Russell. We'll do that part of it separately. Tell me about what you've provided the Commonwealth on Chris Van E.
They've gotten his CV and they've gotten the substance of his opinion from us. And they've had that for a long time. And the court, I believe, has already suggested that voir dire will be done prior to his testimony.
All right, so it's starting to look like we might need a whole day of voir dire, and I'm trying to avoid that. So is the Commonwealth satisfied that when did you provide anything recently since the filing of the Commonwealth's motion, Mr. Yannetti?
Not on Mr. Vanny, no.
What does the Commonwealth have on Mr. Vanny?
On Mr. Vanny, all the Commonwealth has is what's contained, the synopsis on page 2, the first full paragraph. We do not know what his opinions are. It says he'll testify regarding his opinions and conclusions about reconstruction and EDR data obtained in connection with this case. He'll testify to chronological data derived from the EDR, including key cycles and triggering events from the time period in question. I have no understanding or information about what chronological data he's going to testify to, what his ultimate opinions are, anything beyond that relatively vague synopsis that does not comply with Rule 14.
Okay.
Similarly, what's outlined in the rest of the motion, that's all the expert evidence the Commonwealth has received from the defense is contained within the Commonwealth's motion.
Okay. So the defense needs to provide, I'd suggest you listen, the defense needs to provide what chronological data Mr. Vanny relied upon and exactly what his opinion is. All right, by the close of business tomorrow.
That's fine.
All right. Now, regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial. So
I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
that's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor. We can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for a voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER doc. Is she an ER doc? I haven't seen her. She's not a pathologist,
Well,
correct?
she's a pathologist, but she has a lot of experience in an ER, which is why she has the experience of having seen dog scratches and dog bites and dog attacks.
All right. So this is not somebody that was involved in the federal investigation, correct?
Correct.
All right. So you need to provide immediately. I want a voir dire of her this week. So we can get her here Wednesday. And we want the other folks up here from Pennsylvania this week as well.
Okay. Well, we'll make those calls.
So we need to pick a day. How long do you expect the voir dire of each of these witnesses? If in fact the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect the voir dire of each of these witnesses to take? I went and told the jury last week, excuse me,
I'm sorry.
last week that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah.
Yes.
At least with regard to the, of course, at least with regard to the ARCO witnesses, that's my co-counsel's bailiwick. He anticipates that unless there are, a substantial number of objections during the voir dire, he anticipates being able to accomplish that between 45 minutes to an hour with each of those three. With regard to Dr. Russell, we anticipate a half hour.
Only two from us.
Oh, I'm sorry, there's only two from Martha, that's right.
You're only calling two? Which two? Are you calling the two that are certified as accident reconstructionists?
Doctors Rentschler and Wolf. Yes.
Did we just lose the sound? Yeah, seems like we did. I don't know what's going on here. I'll see if one of the other channels still has it. Does NBC 10 have it? Nope, theirs is silent too. This is annoying. So, oh no, they have to do some voir dire and it might cost a day in all of this. After all of this time the Commonwealth has wasted. And we're going to make a big thing about the day for the defense, because the Commonwealth wouldn't contact these people ahead of time. I mean, apparently we can't. The Fed witnesses, but Chris Van E, you didn't just interview him. Really hope they fix the sound pretty quick here. Hello, I know it's early. Court feed runner, but please get this fixed. Yeah, I checked the other news channel, NBC 10, and they're quiet too. So we're going back to the fan. Back to the fan. Somebody said Boston 25. I'll pull it up and see if they had any sound from that. They did not either. Yeah, I think the whole feed went down, guys. So nobody had it, and they're probably not going to be able to reconstruct it. So that's a bit annoying. Don't know what's going to happen there. Well, the whole lecturing Yannetti like that does not sit well with me. It does not sit well with me. He gets to make his record. And yeah, for them to impugn his integrity after the crap that they have pulled already in this case, yeah, he gets to call that out. That is perfectly appropriate. This whole implication, oh, he's just performing for the cameras. You're making your argument to me, right? I wish he would have said, yeah, and the reviewing court, should it get there. Making it for them maybe more than you, because we already know where your mind is at. Oh, man. That is just something else. That is just something else. And none of this lecturing to the Commonwealth. I mean, he's right. They've known about this. They know the dog bite didn't get taken off the table. It did not surprise them that the defense is arguing that the arm injuries are caused by a dog bite. This is not a surprise. Oh, man. It's bad. It's bad. I would be pretty annoyed being in front of this judge. Pretty annoyed. Well, since we're just waiting for the jury to come back in, it looks like, she made all that stink about the time, but then went ahead and finished early. Let's go ahead and look at some of the early chats here. Not your mama's cornbread. At April motion and limine hearing, Yannetti said dog DNA, not dog bite issue. That's what Lally is trying to spin. Yeah, I mean, that's basically what I remembered it. And I understand that to mean defense is not challenging the admission of the DNA evidence on discovery types of grounds. It doesn't mean that they are accepting that evidence is true or like stipulating to that evidence or anything like that at all. So the spin is just, really, really kind of over the top here. John O'Rourke, it's 7 a.m. I'm so surprised you are live, but give flowers for the effort. Great works. Thank you so much. Yeah, it's sure early here. I mean, we're finally starting to get some light color in the sky, but it was going to be a real test for how fast can my brain, wake up in the morning. Fortunately, I'm one of those people that can usually like wake right up and kind of often energized and have a lot of my creative energy going first thing in the morning. So hopefully haven't just been talking through a little bit of a coma here. I did wake up in the middle of my dream cycle though, which is always a little bit disorienting for me. I was looking for my car and I couldn't find my car in a parking garage. And then there was this other car that kind of looked like my car, but it wasn't. It was just some Honda. And there was like a bunch of people around that car because the valets had parked it and they had messed up the muffler. And so the owner was there and the valet people, and they were very upset. So that's, that was what was going on in my mind when I woke up first thing in the morning. What does that mean when my dream, I'm always dreaming about looking for stuff. I'm always looking for something in my dreams. Tell me what that means psychologically. If anybody knows in the chat, I don't know what that says about me, but that's what I dream about all the time. Mike, but none of the 129 pieces were put in evidence. Yeah, the problem is we don't know if they were or not. We don't know if they were or not because we don't know which ones they were. They weren't. They were supposed to be secured by Lieutenant Tully and booked into evidence by Lieutenant Tully. If he didn't do it, what did he do with it and why? Why didn't he maintain a secure chain of custody of those items? It just is beyond my ability to comprehend why it's this particular case when they have chosen to cut all of these corners and do all of this sloppy stuff, bend all of these rules. The Canton Police Department was only recused for interviews. I'm having a hard time believing that Trooper Bukhenik actually said that. He actually did say that. Only for interviews like that. It's nonsense. It makes no sense at all. It makes no sense at all. There's no partial recusal for interviews. I don't know. John Duncan gifted some memberships. Thank you. Thank you so much. Very generous and really appreciate that. Charles Argo, they could have broken the light on the tow truck. You can't see the right-hand side of the car in the Sally port, the second camera not working. I mean, there's a lot of possibilities, right? But the issue is turning something that is possible into turning something that probably happened, right? The more you can show this probably happened, or at least there is a good argument that this happened, the more likely you're going to be able to pitch it to the jury. Certainly, you can always argue possibilities. Some jurors may find possibilities to be enough to be reasonable doubt. But others are going to require, a little bit more. They're going to want to just have some reason to conclude that's more likely than the alternative. So the best evidence, the better the showing you can make that this is what actually happened, the better. And so in this particular case, my understanding is the tow truck driver is on the defense witness list. So whatever he has to say, that's going to be informative. I would tend to assume because tow drivers are dispatched, and they have their own logs and time reports, and he's going to have his own independent record of the time that they arrived in Canton. And somebody's coughing in the courtroom right now. We're still not open yet, but I'll go ahead and mute that. The tow driver is going to be there, so he should be able to establish independently when did they arrive at the Canton Police Department, and that's what I'm interested in. Is that going to line up with that timeline, that timestamp that's on the video, the Sallyport video? Because look, the Sallyport video is already unreliable. Okay, it's been mirrored and nobody disclosed that. And we saw the jumping all over, the ghost people materializing and vanishing, the timestamp jumping. This does not look like a particularly reliable video. And so why should I then just count on this other thing? This other thing is reliable. I should take that on faith when everything else looks really hinky, you know? Don't know that necessarily makes a lot of sense. So if the tow truck driver has a different time of arrival than the Sallyport video does, then I think we got a real issue there. I don't know why it would take that long anyway. Yes, I understand it was snowing, but those main highways and stuff tend to be the first thing that get plowed, and they tend to be like fairly easy to keep clear just because of the volume of traffic on it. You know, the blacktop gets exposed, and then that's warm. It's got a heat sink. And so as snow is continuing to fall on it, cars are going over it. It just gets wet. You know, it gets slushy until the plow can come back through and continue to scrape that up. So yeah, it's not ideal driving, but it's not like, you know, you're having to four-wheel drive through the raw snow and, you know, try not to bottom out and stuff like that. I don't see why it would take like 3 times the normal driving time to get there. I'm not going to say it didn't happen. Just to me, you know, I don't know. I'm pretty comfortable driving in snow, so maybe that's just me. But that just doesn't seem like a great explanation. I just don't know why it would take that long. So yeah, looking forward to the tow truck driver and seeing what he might have to say about this whole timeline. James Casatelli, do you have faith in a dog bite expert? What about that dentist, Michael West, who got a bunch of people wrongly convicted based on junk science about human bite marks? I worry about this. Yeah, this is a really good point. And frankly, in my opinion, it's going to come down to just what exactly her opinion is. I don't know that there's necessarily anything wrong with somebody testifying that an injury is consistent with a bite mark, or it's consistent with, you know, pretty much any type of mechanism of injury, because you're not saying it definitively is that. You're just saying we can't rule out that being a possibility. I think it is much more credible for her to be able to rule out other mechanisms for causing this particular injury, tail scratches from tail light, things like that. She's going to be able to look at these injuries and understand, is this something sharp that caused it? Is this something blunt that caused it? Just that type of information that can help you form a little bit better of a picture of what it was that happened, what happened to his arm. But I agree with you 100% that, yeah, if she were going to get on the stand and say, you know, not only is this a dog bite, but this is a dog bite that I can match to the jaws of this particular dog and say it's that dog. Like, no, that would be junk science. That's the whole bite mark evidence stuff like this guy, Michael West, has done. It's terrible. It's terrible. It's completely unvalidated. It's one of these things that they've gone back and done proficiency testing on, and they've shown that not only can you not identify, a bite mark to a particular set of teeth, right? Because when you get a bite, the skin, it like deforms and stuff. You know, we're soft. It's not like taking an impression or something like that where you leave this perfect bite mark on it. So not only can they not reliably match any particular bite to any particular teeth, they can't even reliably identify what species of teeth caused this injury. And that, like you're saying, yeah, that cuts pretty much against being able to say definitively, oh, this is a dog bite. But we'll see. I'm gonna hold judgment on it until I see exactly what her opinion is. If it's consistent with a dog bite, okay, I don't necessarily see a problem with that. The Commonwealth can point out consistent with other types of bites, consistent with injuries that are not bites, and I think that would all be fair game. So as long as she doesn't go over the top with how strong of a claim she's trying to make here, I don't know that I necessarily have a problem with it. Greg, she doesn't want to hear Yanetti's argument because she doesn't want a reason to deny it. Yeah, she doesn't want to make it a record. She doesn't want to make it a record. Doesn't want him defending himself. I mean, she is broadcasting here that, she thinks he's making his argument for the cameras and not for the court. Well, sometimes, Judge, we already know you're not persuadable. You're not going to be convinced. And so, yes, you're making your argument for the higher court. Very common to need to do that. For the cameras, really, she's going to go there and not put Lally under the same hot seat with that. I mean, yeah, that misrepresentation about the defense somehow conceded this issue or waived this issue. Bullshit. All I have to say about that. Not your mama's cornbread. I'm hot, y'all. Former defense attorney. Until now, I haven't thought she was biased. Bush League Bev should have recused herself. Clearly biased. I have tried the benefit of the doubt. I really have. But she just makes her all the time.
Yay. All persons have any business before the Honorable Beverly Cody, Justice of the Norfolk Superior Court, Unified County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. School is now open. You may be seated.
22117, the Commonwealth versus Karen Reed.
Good morning, gentlemen. We all met here at 8:30 to try and streamline things. And as a result of what we did this morning, it looks like there'll be some day this week that we will all meet to go through things that we need to go through, but we will excuse you. I just don't know quite yet when that will be. We'll know by the end of the day. And also on the 21st, originally we said we'd be off for the 21st, but again, you know that we don't want to take up any more of your time than necessary. So we will meet on the 21st, but just in the morning because I have a long-standing afternoon that we cannot cancel. So the 21st will be a half a day. So we'll let you know more as the day progresses. All right, I do have to ask those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left on Friday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, read anything about this case since we left here? No. Thank you. Everyone said no or shook their heads. Thank you very much. Can we get Sergeant Bukhenik, please? Jim, do you have that flash drive? No. The flash drive that I gave you.
Let's go.
You saw the show the evidence recorded during the case.
Bukhenik.
The whole truth and nothing but the truth, so help me God.
Got to get that right. He was quite particular about that. Bukhenik.
All right, Mr. Jackson.
Thank you. So when we left off on Thursday, we were discussing the Sallyport video that was introduced by the Commonwealth on Wednesday during direct examination. Do you recall that?
I do.
When he introduced that video, Mr. Lally asked you several very specific questions about the video, including if you recognize the video in general, correct?
Yes, he did.
And you said you did.
I did.
He also asked you whether you recognized any individuals in the video at a particular time where he paused the video and you used your green laser pointer to point out a couple of individuals that you recognize. Do you recall that?
I do.
And in that pause, you indicated at that time on Wednesday that you recognized Trooper Proctor and what you thought was yourself, the person slipping at the front of the SUV, correct?
I indicated that Trooper Proctor and myself were in the video, and there was an individual slipping in the front of the vehicle.
And you then on Thursday, you corrected that to make sure that we were clear about it. The person slipping was actually the tow driver, not you, correct?
That's what it appeared, so yes.
Okay, I'd like to take a quick look at that with the court's permission
Mhm.
at 4:46. May I publish
Okay.
that?
Yes.
This is 4:46. It's the same video that you were shown by Mr. Lally. We're at runtime about 5:37 and 05 p.m. I'm sorry, I said runtime. I meant time of day. Thank you. As a matter of fact, the time of day would be most easily seen right down here, although it's pretty.
I mean,
pretty
he
small
did. He
where you're
specifically
at.
said it was
If you
him.
can't see that, please let me know.
I do not see that, no.
Okay, Your Honor, I'll hold off on that question, and I may ask the court for relief in just a moment. If we can play this for just a quick second, and I'll ask you, Mr. Bates, if you can pause it. Go ahead and pause there. Okay, Sergeant, this is the basic video, the point at which it was paused when Mr. Lally asked you to identify the individuals in the video, correct?
I believe it was a different time, but I'm
Believe it was
not
a
sure.
different
Do you
time.
remember using your green laser pointer, pointing at the person in the back and identifying that person as Trooper Proctor, and then pointing at the person in the front, screen right, mistakenly as you? You remember that?
I remember indicating where the individuals would be, yes.
Okay, and so do you have the green laser pointer with you?
I do.
Could you point at the location where you see Trooper Proctor?
I do not know specifically right now if that is
Mhm.
Trooper Proctor behind the vehicle, but when Mr. Lally asked me to indicate where we would be, it was in this location here.
That's not
You're
what he
indicating toward
asked.
the rear of the SUV.
That's not what he
Correct.
asked.
On Wednesday, and I
You
just wanted
pointed to
draw
the
your attention
people
back to your
with the
testimony on
pointer.
Wednesday.
But
You used
that's
the laser pointer
Proctor,
and pointed
and
at
that's
two different
me.
individuals. Person toward the back, and you identified him as Mr. Proctor, as Trooper Proctor, correct? On Wednesday.
I indicated that Trooper Proctor and myself would be in the shot in the rear of the vehicle.
It's not what
And
he
then
said.
I indicated that I'm wearing a olive drab baseball hat, and Trooper Proctor's wearing a winter style knit black hat.
Isn't it true that on Wednesday, what the question you were asked from Mr. Lally is, Ms. Gilman, from Mr. Lally, Ms. Gilman, if you can just pause there for a moment, as the sergeant's almost falling in the video, and the
He's got
court
the
said,
transcript.
keep your voice up, Mr. Lally. Do you recall that?
No.
I do not recall that, no.
Do you remember Mr. Lally saying, Sergeant Bukhenik, with reference to any of the individuals you see in this video, do you recognize any of those individuals? And you responding, I can recognize Trooper Proctor and myself. And you use the green laser pointer in doing so.
Yep. That's what happened.
Yes, I did.
And that was on this area, may not be to the frame, but this is where the video was paused when you made that identification, correct?
It was approximately at this time.
Okay. So you were then asked after you identified, and at that time you did identify Trooper Proctor, and again, mistakenly, yourself, correct?
I directed the laser to the area where we would be.
Okay. And Trooper Proctor is the one toward the back of the truck.
Again, I cannot tell you which individual. There are multiple individuals there. I do not know at this point in time where it's
But that's not
frozen
what you said.
if that's exactly Trooper Proctor. I know we were
But that's
present
not
at
what
that
you said,
location, and I
you
know
did
what
say
he
it
was
was
wearing
him.
for a headdress and what I was wearing.
All right, so you have to move along from this point.
Then why did you, one more question, Your Honor. Then why on Wednesday did you indicate very clearly the person toward the back of the SUV was Trooper Proctor? If you don't know, why did you say that on Wednesday?
During the frozen frame, I could tell there were two individuals back there, and I was at one point in time in that location with Trooper Proctor.
That appeared to be Trooper Proctor
What?
in the back of the car.
From where the video is frozen right now, I cannot tell.
So you're changing your testimony from Wednesday?
Objection.
Are you changing your testimony?
I am not changing my testimony, no.
Okay, next question, Mr. Jackson.
You were then asked whether the video was true and accurate as in terms of its depiction of what you saw, what you observed in Sallyport that night, correct?
I indicated that the video is true and accurate to the location.
And you were then asked whether or not, in looking at that video, watching it, either you or Trooper Proctor approached, manipulated, touched that right rear taillight at any time, and your answer was never, correct?
That's correct.
And while you testified, this is the video that was displayed for the jurors, correct? But it was this orientation, the front of the truck facing right, the rear of the truck facing left, correct?
That's correct.
And for all appearances, it would appear that the right rear taillight of the SUV is the one facing the jurors, if you will, facing the viewer, right? From appearances. You didn't know anything different.
Can you rephrase that question, please?
Sure. Just
Can
from
you
the
rephrase
appearance
it?
of the video, as it is now, the appearance of the video looks like the right rear taillight is the taillight that's facing the jurors.
Look at him smirking.
Facing the
He looks
viewer.
very smirky.
Toward the rear of the truck, correct?
As it is frozen, correct.
And on Wednesday, I want to move through this relatively
Just
briefly.
very
Sergeant.
defiant
On Wednesday,
expressions.
you did not mention that this video was inverted, did you?
It was not brought out, no.
Not brought out by.
And you didn't
that's a passive
volunteer
way
it.
of saying it. I'm asking you directly. Did you mention that this was an inverted video?
Not on Wednesday, no.
On Thursday, Mr. Lally finished his questioning on Wednesday, then came back on Thursday. You continued on direct examination under questioning by Mr. Lally again to start the day, correct?
That is correct.
And during that testimony on Thursday morning, you also, under direct examination, did not mention that this video was inverted, did you?
Did not know.
And then it was my turn to ask you questions. You recall that?
I do.
And then I began asking you questions about the accuracy of this video. And at that time, for the first time, you said it appears that it is a mirror image. It's an inverted video, correct?
I advised you that it is a mirrored image at that point, correct?
When you got caught, you mentioned it. The entire internet figured it out. Karen Reed figured
Would
it
you
out
agree
in
with
court.
me now, as you sit here, that this video, as we're looking at it, is not a true and accurate depiction of what you viewed in that Sallyport that night?
I would not agree with you, no.
You believe that what the jurors are seeing right here is a true and accurate, surveillance footage of the Sallyport that night,
Yes, it's just mirrored.
which means what's left is right and what's right is left, correct?
Correct. If
Yeah.
the jurors were
this
actually
angle.
standing where the camera is recording, which it's recording all accurate depiction of activity and events taking place, the back of the vehicle would be on the right and the front of the vehicle would be on the left, but all activity is accurately depicted in the video.
So in point of fact, everything in this video, every bit of it is reversed,
It's the opposite.
correct?
It's just a mirror image.
So it's not accurate, is it?
It's an accurate depiction of what has taken place.
Sergeant Bukhenik, if I were to ask you, let me give you a hypothetical.
But it's not. It
Let's
skips
say you
all
were
over.
investigating a circumstance in which a suspect was being identified by 5 witnesses based on a tattoo on that person's left arm. And then you go show that witness, or those series of witnesses, an inverted version of a photograph of that person with the tattoo appearing on his right arm. And those witnesses all say, no, that's not the guy. I remember the guy. The guy had the tat on the left arm. Would you think that that's an accurate depiction of the person with the tattoo?
Objection.
Sustained.
He made his
Do you
point.
agree with me that an inverted video is not accurate? It's inverted by definition, right?
It's an accurate depiction of the events taking place.
You've reviewed this video in its entirety, you testified, correct?
Yes.
About how long would you say this video is in its runtime? from start to finish?
I did not take note of the length of the video.
I'm going to ask you, Mr. Bates, if you could, with court permission, can you just pull the cursor back to the beginning of the time of day for this video? And pause it there. Can you see, and this is not an eye exam, can you see the timestamp on the lower left-hand side?
No, I cannot.
Your Honor, with the court's permission, I could do this.
I'd like to see it sidebar.
Like to see you at sidebar. What, she's had enough of the inverted video? Well, too bad. Too bad, Bev. He gets to continue to explore the inverted video. I mean, this is getting out of hand. This judge with the interfering. I mean, the thumb on the scale. I have tried so hard to give her the benefit of the doubt. Recognize, yeah, judges have a lot of discretion. They have different opinions. She's been with the case for a long time, so she already has her view of the kind of personalities involved and how they conduct themselves and things like that. This is just not right. Not right the way she is interfering. Not letting him get into what he needs to get into. He's got the time, Bev. You've made it clear. The jury's going to get the case by the end of June, based on representations the defense made for how long it's going to take them. So he's got his time and he can use it how he sees fit. I think she's gonna it would be funny if she's up there, you know, challenging the foundation for the timestamp, right? I mean, he clearly wants to bring up an issue relating to the total time of this video and then the skips, right? All of the skips, that omitted time. I've seen some folks break it down that are saying it's something like 9 minutes in total that's missing from this video. I don't know if that's correct or not, but if it is, that's an awful lot. That is an awful lot of missing time for something that supposedly, truly, and accurately depicts the events that are contained on that video, because it's not clearly in depicting the parts that aren't there. And it's creating a false impression that what is here is the entire thing. So she doesn't like this angle because it's making Trooper Bukhenik uncomfortable, and he should be uncomfortable. He's the one that attested that this is accurate. And so, yeah, the defense is entitled to explore. If he's going to say this is accurate, that's his standard for what is accurate. What does that mean? That means accurate is right is left to Trooper Bukhenik. If it's the right-hand side, but it's really showing the left, that's still accurate according to him. You know what really jumped out at me here too is you didn't mention it was mirrored. It wasn't brought up. It wasn't brought up on Wednesday with Lally, so it didn't, didn't matter that he didn't bring it up. You know what that reminds me of? It reminds me of that group text. Reminds me of that group text where Brian Albert is saying, if they didn't ask the right questions of what's her name? It's early, guys. Carrie Roberts. If they didn't conduct a thorough interview of Carrie Roberts the first time around, that's on them. You remember that? That's on them. That's what that reminds me of. If you don't ask the right thing, it doesn't matter then if the jury gets the wrong impression or the investigators have the wrong idea about the case. That's on them. So, it puts quite a spin on this whole the whole truth, and nothing but the truth, doesn't it? They're fine with partial truths. They're absolutely, not only are they fine with them, but that's where they navigate. That's where we have seen this guy at play throughout his entire direct and cross-examination, is playing with what is technically true, what is technically untrue, and trying to skate that in a way that creates the impression he wants there to be. With just examples of things like when he's asked about having first reported to some of the medical people that they thought that John O'Keefe could have been hit in the face with a cocktail glass. This was the working theory at 10:40 in the morning. And he denies that, just flatly denies it. And then it's elicited through continued questioning, like we're seeing Mr. Jackson do here. Then it's elicited, well, no, he did actually say that. He just didn't say it to the people that Mr. Jackson had suggested he said it to. So if you're interested in the whole truth, your answer to that
You
question
are unmuted.
no. It would be, well, I didn't say that.
Jurors,
to them.
sometimes lawyers have what we call stipulations rather than prolonging
Oh, they're
either
gonna
testimony
stipulate.
or calling an additional witness. Lawyers agree as to certain facts. So what the lawyers have agreed to here is that this video begins at 5:30 and 23 seconds, 5:30 p.m. and 23 seconds, and it ends at 5:48 and 15 seconds. And the total run time of the video is 5 minutes and 51 seconds.
Ooh,
All right, your questions, Mr. Jackson?
that's a lot more than 9 minutes. That's 13 minutes. 12 minutes, somewhere in there.
Thank you for that, Your Honor.
There's a lot of time missing.
Sergeant Bukhenik, given the fact that the beginning time, the time of day, is 5:30 and 23 seconds in the evening, and the end time of this video stops at 5:48 and 15 seconds, would you agree with me, without doing the math down to the seconds, that's about 17 minutes and 50 seconds or so?
In real time, yes.
In real time. The actual time of this video, the run time of this video, however, is only 5 minutes and 51 seconds, less than 6 minutes. You'd agree with that?
That is what's captured.
So that means that about 2/3 of the video is missing, correct?
It's not missing, just not recorded.
It's not there.
It was never there.
I'm not saying it was ever there. I'm saying, I don't know if it was ever there or
Well,
not. Neither do
defensive?
you. I'm saying it's not there, correct?
It was never recorded.
Well, you don't know what has been or and wasn't recorded, do you?
Objection.
I'll let him answer that.
He already said he didn't extract it. He doesn't know.
I can only speak to what was turned over and what we received. And based on the evidence that was produced, the video that was produced is what we got.
I understand. So based on that answer, you acknowledge you don't know what may or may not have been recorded without your knowledge.
No.
Right. Did you notice that there were obvious portions of the video that in which individuals just seem to appear or apparate out of nowhere?
Yeah, the fog.
It's not a smooth recording of the events. When the motion triggers the recording, the video appears as if a person appeared in the video. But that is due to the triggering of the recording.
Well, you don't know what it's due to because you're not an IT person who actually captured the video, correct?
Objection.
Sustained, ask that differently.
Sure. You're not the IT person, the technical person who captured this video, correct?
I am not, no.
You don't maintain this video system, do you?
I do not know.
You don't know the inner workings of how the video system was originally installed or how it operates, correct?
Based on my training and experience, I know that certain systems, due to the restriction of the storage of the system, they try to save the storage and trigger the recording only by motion or certain time parameters. So in this video footage, I could tell you that the video is triggered by motion to record.
How much storage did this system have?
I do not know.
What was the level of storage at the time that this video was taken? Was it 60%? Was it 99%? What was it?
I do not know.
So you actually don't know, Sergeant, the inner workings of this system, do you?
I do not know all the inner workings of the system.
But you do know that there appears to be portions of this video missing and portions of this video in which people just seem to apparate out of nowhere.
It's not missing. It just was not recording.
Let's move to
This is not coming over well. You can concede it's missing because it's not there. Those are synonymous.
A few seconds. Okay, if we could, with the court's permission, can we play about less than a minute?
Yes.
Yep, the people apparating. I remember the mystery fog, Aurora Borealis. In this season, localized entirely in your kitchen. There he skipped.
Pause it. You see where the person that was toward the back of the vehicle went in this video?
It appeared they went behind the vehicle.
Which would be which area of the vehicle, the right or the left, in real life, not on this video?
In real life, it would be the right rear portion of the vehicle.
Toward the taillight area.
That quarter panel, correct?
Yeah.
Let's go ahead and play it.
And then the mysterious apparition
It appeared
there.
that someone just seemed to appear out of nowhere toward the rear of the vehicle. Just now?
Due to the triggering of the
I
motion,
asked you why. I asked you if. Did it appear if someone just appeared out of nowhere in the back of the vehicle?
that's what the footage represents. Yes.
Can we go ahead and play this?
Mm.
Pause it. Did you see that the person walking away from the vehicle that you earlier on Wednesday identified as Trooper Proctor appeared to have a notebook, black portfolio in his hand?
Yes, I did.
And can you see from there, I'm going to ask you this, basically knowing the answer, can you see from there the time of day on the lower left side as that person leaves the screen?
No, I cannot.
Would you disagree if I indicated to you that was 5:38 and 7 seconds in the evening?
I would have to see it for myself. I cannot agree with you based on your statement.
Well, the jury will see it.
You want to maybe approach briefly?
Sure.
Or they want to, pull it up. Do your pinch to zoom to show us the timestamp. You could do that if you need to. I don't know where he's getting, what he's getting to with this particular time frame, but we know, 8 minutes. It's been 8 minutes since the beginning of the video, and yet what we've actually watched is like less than 1 minute. There is so much time missing from the
You are
video.
unmuted.
All right. So, Sergeant, we're going to ask you to go take a look at that, okay?
Thank you, Your Honor.
Thank you, Kurt. Thanks so much for being here, part of the chat. This is a great crew here.
And please
Stick
don't
around, you're
speak
gonna love
until you're
it.
back in the witness stand. Thank you. All right, Mr. Jackson?
Thank you. Sergeant, did you have an opportunity to look at the time of day at the point that the video is paused right now?
Yes, I did.
What is that time of day?
5:38:07.
5:38 and 7 seconds, correct?
That's correct.
And remind me about how far of a drive in time is this location at Canton PD from 34th Fairview?
With no traffic, no adverse weather and road conditions, several minutes, four minutes, maybe 5 minutes, depending which route you take.
Your Honor, I have a flash drive that I'd like to have marked.
Is this a different flash drive than we had on Friday?
It is, and I can explain it sidebar if the court wishes.
All right. Are you just marking it or you intend to show it?
I intend to show it with the court's permission.
All right. So we'll mark it for identification and then I do need to see you. Yes. Thank you. Yes.
So a different one from last week, which we never got to find out because she wasn't going to let him play a small portion of it for the trooper to authenticate it, to be able to identify if he knows what it was, which is normally, I mean, again, there's a lot of judicial discretion here with these things, but that's not an uncommon way to handle something like a digital recording. Because if you're not the person who stuck it on the thumb drive or stuck it on the disk or whatever, you don't know what's actually on there. So you have to be able to see a little bit of what the actual digital file is to say, yeah, okay, that is the one. That's the interview I did. That's that's my body camera, whatever it is that you're trying to identify. Because you can't always identify it from the physical object that it's contained on. So that's pretty routine, not a particularly uncommon. You just play a few seconds of something that is, ideally pretty innocuous, so that it doesn't really matter that the jury is seeing it. And then, he either recognizes it and can identify it or not. The other option too is you can just let the jury out, take the jury out, excuse them, do a brief voir dire. Do it that way. If your concern is the jury can't see this little bit of something that's not in evidence, which again, Bev has been so all over the place with this anyway. At the very beginning of the trial with Mr. Lally, yeah, she's telling them specifically, go ahead and play it and then we'll admit it. Like, no, that's not how it goes. You admit it and then you play it for the jury. So very just strange relationship with the technical requirements of publication and admission of an exhibit. But if your concern is the jury shouldn't be seeing any part of it before it's identified, then let them out of the room, play it, and see if he can identify it or not. It looks like maybe that's what we're going to do. The jury is going out. Karen back in those power blue pinstripes. Oh, yeah. I like this look. I always loved the blue pinstripes myself. It's just something about it. So fierce. I just love it. Did we lose the sound again, or did they just mute it? Or are they still at sidebar? They shouldn't be at sidebar anymore if the jury's out. Yeah, don't know. Don't know what's going on here or what they're doing. Why we don't get to hear. But I guess that's going to be the theme of the day. Sound getting cut. So to play it in the right orientation, yes, Bev could say no, more than likely. But what they would basically need, I think, would be to just have somebody authenticate it. They're not going to be able to do it through Bukhenik. They're going to need their own witness, their own tech person who's going to be able to say, this is what I did. It would be a demonstrative exhibit at that point. It's not substantive in its own right. But yeah, I think they could introduce as a demonstrative, this is what it would look like in the correct orientation. And as long as they can testify to the process that they use to create that, to correct the orientation, and that otherwise they didn't modify the video in any way, then yeah, they should be allowed to do that. It's just that we wouldn't get to it until the defense case in chief. I'm going to go ahead and, I don't know that it matters a lot right now. I am going to go ahead and put the closed captions on. I'd kind of forgotten to do that. It's early, guys. A lot of things to remember here, but it has been helpful. We haven't had, other than just the whole sound going out, I haven't had too many difficulties understanding what the people are saying, but, that's just me. I understand other people might prefer to be able to have those captions up. So we'll just go ahead and have them on as soon as we get to hear the proceedings again. Just taking a look at who's in the courtroom. Doesn't look like Turtle Boy made it in today. At least I don't see him. And Mr. O'Keefe, I don't see him. Seems a bit surprising. There's quite a few. Looks like empty seats on the family side. Karen Reed's family is still there. I'm there with you, Mr. Reed, rubbing his head. Yeah, that is the kind of day I think we're all having here with Judge Bev. We're doing a lot of things calming there.
2-minute recess.
All rise to the court, please.
So now she's going to take her break, and we're going to go to Fan. Great. Well then. Let's get that off our screen. I saw somebody run through the chat, make a comment about the court's only fan. It's pretty good. I like that. Very clever. Very clever. Well, while we're on break then, let's go ahead and try to keep caught up on some of these because I know there's a lot of time sensitive stuff with that motion. Rain Man YYC, I'm no legal expert, but I have enough senior management experience to see Weasel speak. It looks like this judge is bending over backwards to shield the Commonwealth from the accusation of bad faith. Yeah, Weasel speak, that's such a great description, and that's the running theme here, right? That's the running theme. That's the same thing I've been talking about with Trooper Bukhenik, that all fits in with this Brian Albert voiced philosophy of, well, it's on them. If they don't get the whole truth, if they don't ask the right question, and all they get is the piece that leaves a false impression, well, that's on them. Yeah, that's exactly what we're dealing with. And I don't, this really, this is the piece that to me is putting me over the edge when it comes to Judge Bev, is how the accusation of bad faith, it seems to only be allowed to go one way. It seems to only be allowed to go one way. They can make all kinds of accusations against the defense and cast aspersions on the defense. But when it comes time to point out, no, you're the ones being weaselly over here, that's when Judge Bev draws the line. That's the part that is particularly infuriating, because you're not letting them fight. You're not letting them fight. You're interfering. What is good for one needs to be good for the other. So if you're going to let the Commonwealth get away with making these types of accusations, then when it comes back to the other side and they get to correct the record, they get to defend themselves, they get to point out, no, you're misled. This is the Commonwealth being misleading about what happened. Yeah, that's fair game. Greg, the Commonwealth has shifted from getting down to the truth to conviction at all costs. I am increasingly skeptical that the Commonwealth was ever about getting down to the truth. I mean, we've seen them over and over and over again, just not raise issues in the direct of their own witnesses that they know are coming. They know are coming. These are not secrets. These are not surprises. Those text messages, the Haas long to die in cold, The butt dials, they knew all of this was coming. Did they seem to show any interest at all in eliciting that, explaining it, getting to the truth of it? No, they didn't. They just left it there for the defense to bring out on cross-examination. So if you, the prosecutor, are interested in the truth of the case, when these types of things come to light, yeah, you should be asking your witnesses about them. You should be asking your witnesses about them. What's your explanation for that? Because you have a duty to be putting on evidence that you believe is true and accurate. And so not seemingly showing any interest in that is really undermining the perspective that I can have on your interest in this as a truth-finding process, and not just a game you're playing to try to put this woman away. John O'Rourke, to be fair, it's all not the Commonwealth fault, homie. I don't know what this is talking about. I don't know. I mean, the Commonwealth was, yeah, they misled. They were not accurate in their depiction of what happened in those pretrial proceedings. That's on the Commonwealth and how they chose to cherry pick that and present it. And I don't blame David Yannetti one bit for being quite irritated by that. Dottie Miller, wake up, fam. New conspiracy just dropped. Yannetti got extra spicy in the hearing this morning, so Auntie Bev revoked our audio privileges. Yeah, I don't know what was up with that. It looked to me like somebody probably just stepped on the cable, but they got it restored. So no harm, no foul. Although, I would have liked to have heard the end of what happened in that motion. So. John Duncan, 11 p.m. in Tasmania, Australia. Ready for an all-nighter. This trial has destroyed my sleeping patterns. Yeah. Wow. You're hardcore. Hardcore. Something like that. Yeah. I mean, I suppose I could say my sleeping habits are better now. Right. I'm going to bed so early, waking up so early. I was up at 4:15 today, guys. I don't know that that's super healthy, but it's the time of year. Maybe I'll get a nap later if I need one. I'm supposed to box again tonight. Yeah. The crypto tax lawyer. I'm not your mama's cornbread. Other channel. Andrea, my BP through the roof. This type of judicial arrogance and thinly veiled good old boy attitude is why I left litigation. # Bush League Bev. It's tough, isn't it? The old boys club is not a fun place to be in a courtroom when you find yourself on the outside. If you don't play those games, it's pretty annoying to watch that game being played while you're just over there on the sidelines, just trying to make a case. I get it. I mean, I get it. I've talked before about the politics of the judiciary and why, I've had people say, appreciate it very much. Andrea, you should be a judge. You should be a judge. And I really do. It's a huge compliment. And I'm very grateful for that. But the politics that go with being a judge, that's the problem. You got to be playing this game because there's two ways you're going to get on the bench. You're going to get appointed by somebody political, which means, are you the one who has curried the favor of those people? Is there somebody else, an alternative candidate who maybe is a little bit more buddy-buddy with the person who's made the decision? Maybe a little more active in fundraising and things along those lines, re-election campaigns, supporting important causes for you. This is how the game is played, is through those political connections. So that's route number one, is you go and play the political game. Route number two is you get yourself elected. And getting yourself elected is, it's just as much an ability to garner things like op-eds by important people, endorsements, going out and getting those endorsements from the powerful organizations, like, for example, the police union, law enforcement unions, extremely powerful, have a lot of money that they spend on these types of things. Prosecutors associations, Department of Corrections, all of these guys are involved in politics. So it's just not a situation where you get to go and rely on, your good character, your good legal record and stuff like that. That's not going to be enough to get you on the bench. And it's not going to be enough to keep you there, especially if you start making decisions that displease those people that control who ends up on the bench. And
Does counsel need to see me, or are we all set?
I think we're all set.
Okay. Right ahead, Mr. Jackson.
Thank you, Your Honor. As a matter of housekeeping, I would ask for the admission of the last item that was marked for identification.
XX. Was it YY? Ah, it was back again.
I did the
Okay.
same thing. It's
All right.
exact.
So that will now be what, Madam Court Reporter?
542.
Thank you.
And with the court's permission, I'd ask to display that video. Yours.
Okay.
States, if you could move that to a runtime of 1 minute and 17 seconds. So thereabouts.
Sorry, guys. Trying to get it in a good spot.
Go ahead and pause that.
So it is reversed.
Sergeant, do you
This is what he's
recognize
doing. They
this
just
video
stipulated.
that's just been marked as Exhibit 542.
I do.
How do you recognize that?
It's an inversion of the video provided from Canton PD Sally Point.
It's actually, and that inversion corrects the perspective. Would you agree with that?
I would.
Okay, so now we're looking at what we've always been looking at, but it's clear that we're looking at the driver's side of the vehicle, correct?
That's correct.
And everything in it's properly oriented, is that right?
It's an accurate depiction of what is taking place.
Meaning right is right and left is left in this video.
The vehicle came from the right into the left. The driver's side is visible and is closest to the camera.
We can go ahead and, thank you, Sergeant. We can go ahead and play this for just a few seconds, please. Pause it. You saw the person that was toward the back of the vehicle that you earlier on Wednesday identified as Trooper Proctor moving toward the right, yes, the passenger side taillight area in this video, correct?
I observed the person walking that way.
Let's go and play it.
And it's just hanging out back there. Then the apparition.
Awesome. And you see the person toward the taillight area moving out of frame just now, correct?
I did, yes.
That person had that black portfolio in his hand.
That's correct.
I'd like to ask Mr. Bates if you wouldn't mind moving the cursor back to the beginning before the SUV was actually in the Sally Port. You can pause that. Do you see what's depicted in the video now at runtime, at the beginning of the video?
I see the still frame. I'm observing the still frame.
Okay, fair enough. Can you see from where you are, sir, can you see the chyron at the bottom of the video in blue, indicating the date stamp and time stamp? You see that from where you are?
I see the blue color. I don't know what exactly it is.
Are your eyes good enough to see that that is completely inverted?
They are not.
They're not inverted?
They are not good enough.
That was a good answer to a bad question on my part. With the court's permission, would it be possible for the sergeant to approach the screen and take a look at that timestamp?
Can you do that, Sergeant? please?
Yes, Your Honor.
Let's see if I can bring this down a little bit more. So is he trying to show that just inverting the video, the timestamp is a part of it? I'm not sure.
Were you able to, may I inquire? Yes. Were you able to see that timestamp?
Yes, I was.
Sergeant, did that timestamp appear to be inverted?
The blue writing appears to be backwards.
So in this version of the video, which has been inverted from the version shown by the Commonwealth, the timestamp also was inverted, correct?
What appears on the screen is inverted.
Thank you. I'd like to zoom in on, just with the court's permission, on a portion of the middle of the video.
Okay.
The snow and the tracks coming from the other side.
Sergeant, I want to direct your attention to an area of the video right above the hand truck. Do you see that area?
I do.
You see that white object just above the snow line?
I see something there. I do not know what it is, if it's an object or it's more snow.
Yeah, I don't know
So
what it is
that's
either.
a sort of a dirty white rag.
I cannot tell what it is.
Fair enough. Thank you, Mr. Fish. We can take that down.
Hmm.
We've seen a corrected version of that Sallyport video from that camera. There's also another camera on the opposite side of the Sallyport, isn't there?
There is.
And that one, for lack of a better phrase, that one came out pretty grainy. Would you agree?
Yes, it's not perfect quality.
The other view would show, given the fact that it's on the opposite side of the wall of this video, that actually would show the right rear portion of the SUV as it was parked in that Sallyport, would it not?
Yes, it would.
Let's take a look with the court's permission. This has already been marked as 446. I believe it was introduced last week.
Okay.
Display that.
Yes.
Thank you. I know it's very hard to see, Sergeant, but could you tell me, as the video is paused right here at the beginning, timestamp, can you see the outline of the
I'll make myself
antique
smaller.
police car?
I can make that out, yes.
And it appears that there's no vehicle in the foreground this side of that antique police car, correct?
That's correct.
You also can see that this video is in fact not inverted. It's the correct orientation, right?
That's correct.
And obviously it's pretty lacking in quality, but you can make out the fact that there is an outline of a vehicle there, correct?
Correct.
Very hard to see.
We could play, may I approach the screen briefly?
Yes.
So I see folks reminding me in the chat the dirty rag was in the photos from
If we could, with the court's permission, begin playing it.
Sallyport bag.
This is about 5.
the Stop and Shop bag.
And 10 seconds. That's time of day. We can play for about a little less than a minute.
Okay.
Which is when Maureen Hartnett went out there on February 1st. Is it the same rag? Is that what he's getting at? Boy, who whacked the camera?
Sergeant, did you see what was depicted on the video that just ran from 5:07 and a few seconds until it was just paused?
I did watch the video.
And how much time would you estimate elapsed as we just watched that video in real time?
15 seconds, maybe.
Okay. And do you see something you see something in the foreground that just sort of appeared there next to that antique police car.
It appears that the SUV has now pulled into the Sally Port and there's an individual standing behind the SUV.
And you see what the time of day is on that timer?
I do not.
Can you see that it's paused at 5:50 and 46 seconds?
I cannot.
This is the last time I would ask that unfortunately, I cannot zoom on this, Your Honor. With the court's permission, would the sergeant make one more trip to the screen to give us the exact time that this is paused?
This is the last time, Sergeant. Would you please?
Thank you, Your Honor.
15 seconds real time, but 43 minutes missing. Yikes. On the not inverted timestamp, presumably.
What was the time? What is the timestamp where the video is paused?
5:50:46.
5:50 and 46 p.m. Correct?
That's correct.
So it appears that this video in about 15 seconds jumps 42 minutes to the 5:50 mark. Correct?
I don't know how much it jumps.
Well, from 5:08 approximately to 5:50 approximately, how much time is that?
Approximately 48.
42 minutes, right?
Excuse me, 42. Yes.
That's okay. And Miss Reed's vehicle, which shows the right rear taillight portion, just appears, correct? At 5:50.
There's a vehicle that appears. There appears to be an individual standing behind the vehicle. It's not just a taillight that appears.
But Sergeant, the exact time that
So when
would
you want to
show
be specific, you can.
what Trooper Proctor was doing at the right rear taillight, that is missing.
Objection.
Sustained.
The exact time that would show what the person who you identified on Wednesday as being Trooper Proctor, that video is not there, correct?
Objection.
Sustained.
This video,
Agreed.
Sergeant, you will agree, if that 42-minute period existed, that would have shown, that would have been the only video that would establish the actual condition of the taillight the moment the SUV arrived in police custody in that Sally Port, correct?
Objection.
You can ask that differently.
Is there any other video other than this one that would show the exact condition of that taillight as it pulled in to the driveway, and then to the Sally Port? Or is this the only one?
From that location,
Correct.
that is the video that captures that time frame.
And that's also the video that captures that area of the car, correct? The right rear portion of the car.
Correct.
And that 42 minutes from when the car arrived until 5:50 in the evening, that portion is missing, correct?
It's not missing. It's just not recorded.
It's not there, Sergeant Bukhenik. I'm not splitting words with you.
It's not
Wait, here,
missing.
it's
It's
not
just
there.
not recorded.
It's gone.
You're playing semantics.
It's not on the screen now.
It's not
So
anywhere.
what?
is it?
Everybody was still for 42
I
minutes?
do not know.
Freeze.
That's all I have.
Freeze frame. And that's it. That's all
Thank
he
you, Your Honor.
got. Well, well, well. It's not missing. It's just not recorded. He doesn't like that because that was the defense argument in opening, right? All this missing video. And he's trying to wriggle out from that, but he's right. It's missing. It's not there.
Morning, sir.
Remarkable
Good morning, sir.
coincidence.
So how this video was played before the jury on Wednesday during your direct testimony, the condition of that video, the view of that video, that's how you received it from the Canton Police Department, correct?
That's correct.
But nothing was done to alter it, change it in any way, shape, or form from when you received it to when it was played before the jury.
Objection.
Sustained. You can't lead, Mr. Lilly.
What if anything was done to alter or change that video, received it to the time that it was played before the jury?
Objection.
Ask it differently one more time.
Struggling.
As far as the condition when you received it and the condition when it was played for the jury, what was different?
There was no manipulation, alteration of the video between
I'll allow the answer.
when we received it from Canton Police Department, when I played it, and when it was played for you.
Now, as far as the cameras are motion activated, correct?
That's correct.
And as far as the skipping that you observed at various points of the video, was that something that occurred once or more than once?
More than once, repeatedly.
And was it one specific portion of the video? And by that, I mean, was it only at the beginning or only in the middle or only at the end, or was it sort of throughout?
It's consistently happening when there's lack of motion. The video does not record because it's not triggered to record.
From the video, at least as far as you've seen, the one that you were shown on Wednesday and the one that you were shown today, or the portions that you were shown today, what, if any, difference did you note between the content of what's contained in the video?
The content of the video is accurate depiction of what's taken place. The only difference that I noticed today is that the version played was actually inverted from the original version that I received and which was produced.
Your Honor, with the court's permission, I would ask that the entirety of that 5 minutes and 51 seconds of video be played for the jury.
Okay.
Okay, no problem at
May I
all
have
with
one moment, Your
that
Honor?
from
Yes.
Bev. We need to see the entire thing that we've seen the important pieces of. Yeah, some animals more equal than other animals, huh? Yeah, the problem is it's still not an accurate depiction of what's taking place because there's, what, 18 minutes missing on that side? Is that what we came down to? 2/3 of the video? It would be nice if we had some other video from the Sally Port where we'd be able to see, is it motion activated? Does this same skipping happen when it's not Karen Reed's car that we're trying to look at? There's a mystery person appearing and moving, and yet the camera stops. That's not motion activation. Come on.
Pause there, Ms. Gilman. And that area just played before the jury. That is when the vehicle was brought in by the tow truck driver from the flatbed from the driveway video into the Sally Port area, correct?
That's correct.
We did. I saw that. That pause. He was stuck. He was mentally, I'm trying.
Sergeant, I'm going to direct your attention to the person that just opened the driver's side door. That's the tow truck driver, is that correct?
That's correct.
Just ask you to take a look at the door, and in particular, the snow on the door when he closes that. Gentlemen, if you could. You pause just for one moment.
Okay, so some snow
Sergeant,
fell
if I
off.
could direct your attention back to the ring video. I think it was video 153 from Exhibit 6. And you were shown that video on cross-examination and asked about any movement that you saw on the driver's side rear tire, things of that nature. Do you recall that?
I do.
And do you recall that portion of the video when it's alleged that Ms. Reed's vehicle came close to or made contact with Mr. O'Keefe's vehicle in the driveway? At that point, did you observe any snow coming off of Mr. O'Keefe's car when they came close to each other?
Objection.
I'll allow it.
Why don't you just show it? I mean,
I don't remember exactly if
Yeah.
there was snow coming off the vehicle. There was snow falling, and that was captured by the Ring video. I don't recall if any snow came off the vehicle.
Just a minute, if you could.
mm. And then the mystery person appears in the garage, somehow walked into the garage without creating movement that would activate the camera. And now is shoveling should activate the camera the entire time. We should have no skipping in any of this, right? Because it's motion activated and there's lots of motion happening. And yet it skips. And yet it skips. Six people in there that I can see so far, milling around the back. Looks like there's another one just coming in. Three of them over there by the back tail light. Maybe more than three. It's hard to see. Because it just happens to be the wrong angle that's working today. Then the whole crowd there at the back, and it's still skipping, even though they're still shoveling and moving around. Bev has no problem with this at all. Why are we looking at this? Why are the people suddenly materializing? And why did that guy just like pixelate out with the dolly? That's not a motion activation. He was walking away with the dolly. That's not motion activation. This officer is quite a bad liar. But he's trying. He's trying. I would love it if they could. Yes, they should. They should try. They should just PRA some video from the Sally Port from a day like right in this same time frame, couple days before, couple days after, and see if it skips like this. See if it's motion activated. See if they have extended periods of video where nobody is back there in that Sally Port and it's still recording. Yeah. I mean, I don't know that it matters, though, frankly, even if it is motion activated. What we are seeing is not motion activation skipping because the people are in motion and it is skipping. Yes, that very secure crime tape. Why we need this in the police's own Sally Port, I don't know. And then the guy mysteriously gone from the door while he's walking. Like, no, no. Don't pee on my leg and tell me it's raining.
Thank you. And Mr. Officer, we can have the lights back up.
Boy, a
Now,
lot of
Sergeant-
confession by projection, huh?
That video starts at approximately 5:30 PM on January 29th, correct?
Correct.
Karen,
Is that before or after?
deleted ring camera
the
video?
Ring video, 153 from Exhibit 6 at 5:07 in the morning at Mr. O'Keefe's house when you can see the defendant's smashed taillight.
Objection.
So the objection sustained. Ask the question.
5:30 PM on January 29th, is that before or after 5:07 AM when you observed the defendant's vehicle on the Ring video at Mr. O'Keefe's house?
That is after.
And is that before or after you observed on the Ring video the defendant, Ms. Roberts, and Ms. McCabe driving the defendant's vehicle and parking it in the driveway of Mr. O'Keefe's house?
It's after.
And is it before or after about, say, 8:22 in the morning?
What a
At some
dumb
point when
question.
a Canton Cruiser
This is
parked in the driveway
argumentative.
behind the defendant's vehicle?
It's after.
And is it before or after about 12:30 PM or so when the defendant and her father and her brother from the videos from Exhibit 6, the Ring videos on One Meadows Ave, are parked in and around the defendant's vehicle and then leave with the defendant's vehicle to go to Dyke?
It's after.
And is it before or after the video that you testified about on Wednesday in regard to the surveillance video from the defendant's father's house in Dayton when that vehicle is being loaded onto the truck and you can see the taillight there?
John.
It's after.
Yeah, we know the time frame, Lally. The problem is the videos don't show what you're trying to tell us they show.
Now, again, you had a conversation or an interview with the defendant on the afternoon of January 29th when you were in Dayton, correct?
That's correct.
And during the course of that interview, she made statements about her broken taillight and when that occurred, correct?
Objection.
Do you want the instruction or do you want to come see me at sidebar?
Sidebar.
Sidebar. Beyond scope. All we heard from Karen's statement before was, oh man, I couldn't hear it because it was that tin can quality, but I did see several people report it. I went with what was from Ted Daniel, who's one of the news reporters. You're aware he was beaten up by Brian and Colin Albert. We're all in on the same joke. My taillight's cracked and his face is pulverized. That's all we heard on direct about Karen's statement. And Jackson didn't get into this on cross. So is he arguing it's beyond the scope? Maybe. Maybe. Or is that maybe just what he wants to revisit? My taillight's cracked and his face is pulverized. Don't know that that helps him, but you know, he elicited it in the first place. So maybe get a rerun.
You are unmuted.
So it seems like that's been sustained. And now Lally's trying.
Now,
He's
Sergeant.
trying.
Between the version of the video that's you and the jury witnessed on Wednesday and the version that you just witnessed the entirety of right now, again, what if any difference as far as the depiction or people
Again,
or
what if any?
places, between those
We've
two
covered
versions?
multiple times it's inverted.
Outside of it being a mirror image of itself, it accurately depicts any activity or action in the Sally Port.
And at any point in time that you were in the Sally Port area of the Canton Police Department garage, did you or Trooper Proctor ever go near, touch, manipulate the rear passenger side taillight area or the rear passenger side quarter panel of the defendant's vehicle?
We absolutely did not.
Absolutely did not. Well, that's the tell, isn't it? That's how we know they totally did.
Now, if I could turn you back to some questions you were asked on cross-examination about
Now, why not?
something that was
Why didn't you
reported
go
to
take a
the
photo
chief
of it?
medical examiner's office. Do you recall that?
You
I do
photoed the
recall
front
that.
of the car, but not the
And
bus
some
tail
questions
light?
about statements that you had made to the OCME at approximately 10:41 a.m. on January 29th. Do you recall that?
I do recall that.
And you were asked some questions about reporting it as a possible domestic assault, correct?
That is correct.
And can you explain to the jury what led to that statement as far as what you knew at that time and why you would make those statements to the medical examiner?
The Massachusetts general law directs us, just as it gives the district attorney's power to and authority over all death investigations. That's the following section 4 of that chapter. Excuse me, following section from section 4.
Yes, he
Section
is.
5 of that chapter directs all state medical and police entities to work in coordination with the medical examiner's office. By law, we're supposed to work together on the medical legal investigations that the medical examiner's office conducts. We conduct the criminal portion of the investigation. They conduct the medical portion of the investigation. Thus, I contacted the medical examiner's office and advised them that what we had learned at the time. Up to that point, we had learned that the defendant stated that she hit him. We had collected, meaning the Canton Police Department had collected a broken glass. So based on the physical evidence and the statements made by the defendant to the first responders at the scene at that point in time, I had communicated those facts to the medical examiner's office. That way they would document it, but also be prepared to investigate the case with the most up-to-date information available.
Well, that's weird because the
Now, at
other
that
people
time
on
that
the
you made
scene
that
who remembered
statement
that
to,
and said they
the
reported it, said they
representative from
reported a
the
motor
chief medical
vehicle
examiner's office,
accident.
had you been to Good Samaritan Hospital and
Not
seen
a
Mr.
hitting with
O'Keefe
a
at that point?
glass.
I have not.
And had you obviously seen any of the injuries that Mr. O'Keefe had sustained prior to making that statement to the medical examiner?
I had not.
Now, as far as the information that you received, you mentioned first responders indicating that the defendant had stated, "I kid him." Who was the first responder that provided that information?
Be Canton Police Sergeant Good.
In addition to that, did you or
Sergeant Good?
Proctor speak with any of the Canton fire personnel?
Yes, we did.
And who did he speak with?
I believe it was firefighter Fleming.
So firefighter Flamati, is that correct?
That's correct.
Now, after going to Good Samaritan Hospital and viewing Mr. O'Keefe's injuries, as far as what you had earlier reported to the medical examiner, what, if anything, changed based on those observations as far as your opinion as to what had transpired?
Based on what I learned from observing the injuries, I could tell that the glass.
Objection.
Yeah, he's not the medical
No,
guy.
I'm
You just
going to
told
allow
us.
it. You can move
Medical
to
guy
strike
does
it,
the
but
medical
I'm
stuff.
going to allow it.
So let the
I could
jury
tell
hear
that
it,
the
and
glass
then
was
maybe I'll
most likely
do
not
take back seats.
the object, the weapon, which was used to cause the injury to the back of Mr. O'Keefe's head.
Yeah, that would
Thanks,
be
sir.
the ME's
Now, may I have a
determination.
moment?
Yes.
So did you ask them? Did you have more follow-up conversations?
Thank you, sir. I
Or
have no
with
further
the ER
questions.
doc?
Any recross?
Very briefly.
Okay.
Brief
You referred
recross.
to the OCME, you said it was a glass to the face, not to the back of the head, correct?
I'm not sure how they wrote it down. but I would need to be refreshed on my memory.
Okay, fair enough. May I approach?
Yes.
Last sentence.
Last sentence. Go ahead and feast your eyes, Trooper.
Yeah?
Yes.
Did they get that wrong?
Does that refresh your recollection?
Yes, it does.
What did you say to the OC, or what did you report to the OCME?
That there was a possibility that the decedent was struck to the face with a glass.
You also, with regard to the phrase, I hit him, or the Sergeant Good and or Flamati telling you that she said, Ms. Reed said she hit him. When did Sergeant Good tell you that?
It would have been during our conversations at the police department.
And when did EMT Flamati tell you that?
He never told me that.
So the only thing you were going on with regard to the phrase or the statement that you claim my client indicated, where my client indicated she hit him, is coming from Sergeant Good.
That information at that time was provided by the first responders from the scene.
And Sergeant Good then relayed that to you, correct?
Don't remember good
At some
testifying
point,
to
yes.
that.
Is there a single report memorializing that Sergeant Good reported to you that morning before 10:41 a.m.? Before 10:41 a.m. that my client made the statement that she hit him?
I don't believe so.
I want to shift gears real quick to the video. A couple of quick questions about that. When did you, and I'm talking about the higher quality video, the one that was inverted. When did you receive that video? What date?
I'm not sure. It was at some point in either late April or early May.
After we had started this trial.
Objection.
Do you know?
I do not, Your Honor.
Okay.
If after mid-April, correct?
I believe so. I'm strictly speculating.
Who asked you to retrieve that video?
I did not retrieve that video.
I'm sorry, that was a presumptuous question.
Who did
At what
retrieve
point
it?
were you asked to secure the video, or were you ever asked to secure the video?
That video was never secured by me. I was not asked to secure it. I just was asked to review it.
Okay, so who did secure the video to your knowledge?
I do not know.
You're aware that it was, well, let me ask you a couple of different questions then, based on that. You've already testified that you knew that the Canton Police Department was recused from any investigation concerning this case, correct?
At one point, we learned that the Canton Police Department, the decision was made way above my level. And I was advised by Detective Lieutenant Tully that Canton Police had recused themselves from the investigation as far as interviews go.
And you knew that that recusal was because of a connection between the Canton Police Department and the Albert family, correct?
Objection.
Sustained.
Did you know, or were you informed that the recusal was based on the connection between the Canton Police Department and the Albert family?
Objection.
So it's sustained for the same reason I sustain the Commonwealth's objection at sidebar, Mr. Jackson.
Last question. Who provided the video?
I do not know.
Canton Police Department, wasn't it?
You asked who? That's an entity.
Okay, what entity provided the
An
video?
entity can't be a who?
It came from the Canton Police Department.
Thank you, that's all I have.
All right, Sergeant, you are all set, sir.
Thank you, Your Honor.
All set.
Your next witness, Mr. Lally?
Yes, Your Honor. The Commonwealth call Officer Nicholas Barrows to the stand.
Okay.
Nicholas Barrows. He's the one from Dighton who wrote the report where these guys were calling for the tow, I think before they even got on the road.
So I see you.
Just hope so the ever skip the court and jury in the case now and answer the truth, the whole truth, and nothing but the truth, so help you God.
I did.
So, all right, whenever you're ready, Mr. Lally.
Thank you. Your Honor. Good morning, sir.
This has actually been the case
Could
since
you,
long
please state your
before
name and spell
Citizens
your last name
United.
for the jury?
Nicholas Barrows, Barros,
And how are you employed, sir?
with the town of Dayton.
And what, if any, role or what do you do for the
They
town of
say it
Dayton?
like
I'm a
Canton.
police sergeant for the police department.
And how long in total have you been a member of the Dayton Police?
In total, started in 2011, 14 years this December.
And how long have you had the rank of sergeant with the Dayton Police?
A year and a half.
Now, if I could direct your attention to January 29th, 2022. Do you recall that date?
I do.
And were you working that day?
I was.
And do you recall what kind of shift you were working on that occasion?
I was working the 8 to 4, the day shift.
And was that the only shift that you had worked on that occasion, or how long had you been on shifts by the time you came on for the 8 to 4?
That particular day, I was working from 8 a.m. to midnight. It was on a double.
Now, at some point when you first came in, with reference, if you could explain to the jury just briefly or in general terms, when you come on shift for the Dayton Police, what, if any, communication, well, first and foremost, what was your role as far as that particular shift was concerned?
I was the officer in charge that day from 8 a.m. to midnight. When I came in at 8 a.m., the outgoing shift, the midnight to 8 shift, had advised me that a resident had called the police station on a 911 call requesting a ride to Brockton Hospital to meet his daughter due to her daughter's boyfriend passing away, and he needed a ride due to the snowstorm.
And then as your shift continues, what, if any, further contact or who, if anyone, reached out to you in regard to that earlier situation?
Later on, I believe it was around 2:30 in the afternoon, I received a phone call from the Norfolk District Attorney's Office with the troopers assigned there. And they had stated that they were going to come to Dayton to retrieve a vehicle that was involved in a homicide.
Yeah.
And did they give you a specific address as far as where they were going?
I believe the address was 345 Country Hill Drive in Dayton, North Dayton.
And with regard to that address, what, if anything, did you recognize between that and the earlier call that you were just speaking?
That was the address that came up on the 911 call when that gentleman had called earlier on the prior shift.
And at some point, did you come to find out who the residents were at that address on Country Hill Lane?
I did.
Okay.
Who did you find them to be?
It was the Reed residence.
All right, so Sergeant, I'm going to ask you to keep your voice up, and Mr. Lally, you too.
Okay.
And the Reed residence was at a William and Janet Reed, is that correct?
Correct.
Now, as far as you received that call at about 2:30, do you know specifically who you spoke to around 2:30 in the afternoon?
Trooper Michael Proctor.
And as far as that earlier information that you were talking about with the 911 call, what, if anything, from that did you impart to Trooper Proctor?
I advised Trooper Proctor that we did receive a 911 call on the midnight to 8 shift about the resident looking to get a ride to Brockton Hospital.
And during that initial call, how was it sort of left as far as what, if anything, you were going to provide as far as assistance or with regard to the troopers on that first call?
On the first call, the troopers just had asked me if I could meet them at that residence as a courtesy since they were coming into my jurisdiction.
And what, if anything, did they indicate to you as far as where they were or when they felt they would be arriving in that area?
Trooper Proctor advised me that they were heading, I believe, from Canton, and once they were about 10 minutes away, they would recontact me so that I could meet them at the residence.
And subsequently, later in that afternoon, did you receive further contact from Trooper Proctor?
I did.
And do you know about what time that was?
I believe the first phone call was around 3 p.m. that he had called me and said that they would be there in about 10 minutes.
And upon receiving that call, what, if anything, did you do?
I had contacted, Trooper Proctor had asked me to contact our tow company to have them meet us at the residence as well. And I said, once I hung up with him, I would contact the tow company and then respond to that address on Country Hill Drive.
Is there a specific tow company that the Dayton Police uses with regard to towing of vehicles within the town?
During that period, it was Diamond Towing.
And so did you contact someone at Diamond Towing in reference to responding to that address as well?
I did. I contacted the owner and he responded.
Now, as far as that area of Dayton, if you could explain to the jury sort of what you observed as you were coming down towards that residence on that day.
Okay, so when I responded to that address, that street is off of 138. When I turned onto Country Hill Drive, I was traveling west. When I arrived on that street, I observed a black pickup truck parked on the street facing east. I was flagged down by that black pickup truck by the driver and was told that they were the troopers that I had spoke to, Trooper Michael Proctor and the other sergeant.
Sergeant that left the room as you were coming in?
Correct.
And what identification did they provide to you in reference to that?
They showed me their ID and their badges.
And then from there, where did you proceed?
I had parked my marked police vehicle at the end of the driveway since it was a snowstorm and we could not get into the driveway. And then we walked up to the residence.
So when you say it was a snowstorm and we couldn't get into the driveway, can you expound upon that a little as far as explain to the jury why it was that you couldn't get into the driveway?
There was about a foot of snow in the driveway.
And as far as that snow that you observed when you arrived there, was that snow, how did that snow appear as far as, did it appear as if it had been shoveled or snow blown or untouched or how did it?
It was untouched.
Now, as you're going through the snow, and correct me if I'm wrong, but it's yourself, Trooper Proctor, and Sergeant from the State Police, and who, if anyone else, is going along with you?
I had an officer that was field training with me that day, and he was with me as well. And we went up to the residence.
And as you're walking up to the residence, what, if anything, did you come upon as you're going towards, say, any door or getting closer to the home?
I remained at the garage. The two troopers went to the front door and made contact with the homeowner.
Now, as far as you were there specifically for a vehicle, correct?
Correct.
Did you observe a vehicle in the driveway at any time?
Yes, we observed a black Lexus SUV in the driveway.
And what, if any, observations did you make to the rear area of that vehicle specifically?
At first, I did not go up to the vehicle. I just remained at the driveway and waited for the troopers to come back. And once they came back, they were let into the house through the garage. I had walked in with them briefly and then went back out to the garage and remained with the vehicle.
And as far as at any point in time, did you have any conversation with anyone named Karen Reed that day while you were at the house?
I did not.
Now, with respect to you come back out to the garage, is that correct?
Correct.
And the troopers are inside the house, is that also correct?
Correct.
Now, at some point, do other vehicles come down to the driveway area of this residence that you were at?
I had contacted the highway superintendent after speaking with the troopers about how to retrieve the vehicle since the driveway was untouched and had about a foot of snow. I had made the decision that I would call the highway superintendent and see if that he would come and plow the driveway so that the tow truck would have access inside in the driveway.
And just in reference to this driveway, just if you could, not exact footage or anything, but how close is this Lexus SUV parked in relation to the roadway? How long is that driveway?
It's got to be about 150 feet off the roadway, if not more.
And if you recall, from where you're standing at the point of the garage, was what part of the vehicle was facing you? Was it the front of the vehicle, the back of the vehicle, the side of the vehicle?
I was looking at the left side of the vehicle.
And at some point, did you make any observations of the right rear part of that Lexus SUV?
I did.
And what, if anything, did you observe about that area of the vehicle?
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked and a piece was missing, but not completely damaged.
And then beyond the taillight area of that vehicle, what, if anything else, did you observe as far as damage to the rear passenger side area?
Like a dent on the rear quarter.
And as far as the dent on the rear quarter panel that you saw, was that above the taillight, below the taillight, or something?
It's probably right in conjunction with the taillight in that same area.
And from the time that you made these observations of the vehicle, at any point did you go sort of physically up to the vehicle?
I walked up to the vehicle, correct.
And about how far away from the vehicle did you get?
5 to 10 feet away.
And as far as the sort of outside or exterior of the vehicle, you mentioned obviously there was about a foot of snow on the ground. What, if anything, precipitation-wise or weather-wise, was around or on the outside of the vehicle?
Just snow.
And in particular, in this area of the right rear passenger side and that taillight, was there any snow or ice or anything around that area that you observed?
On the vehicle itself?
Yes.
Yes, on the vehicle, there was snow on the vehicle.
And not to put words in your mouth, but sort of caked on there, is that correct?
I guess you could say caked on, correct.
I guess you
So
could
you'd
say
reached out to the
caked on.
highway superintendent to have someone come out and plow the driveway, correct?
Correct.
And do you know about how long it was between the time that you made that call and the time that the plow driver came out to clear it?
Less than 10 minutes.
And the sort of clearing of the driveway and the process of that, do you know about how long that took?
I'd say another 10 minutes or so.
And as far as the time that the troopers went into the house, at some point the troopers obviously came out of the house, correct?
Correct.
You know about how long it was that they were inside of the house?
More than 30 minutes, less than an hour.
Now, at any point in time that while you were there, did you yourself or did you see anyone else touching or making any contact or manipulating or anything in that rear passenger side area of either the taillight or the dent?
I did not.
I'm sorry.
I did not.
Cracked, but not
Can I have a moment,
completely
Tom?
missing.
Yes.
Just a piece. That ain't what we saw in the Sally Port, is it? Kind of looks like how it looked when it was reconstructed and that one little piece was missing, didn't it? Oh, I would love to show him if he remembers. I hope the defense has interviewed this guy. Because if they could show him that reconstructed taillight with the big piece in the middle still missing, kind of like it looks like maybe where she hit John's car in the
I
driveway.
remember the question.
Okay, cross-examination.
Was that what it looked like?
All right, Sergeant Barrows,
Done.
you are all set, sir.
Thank you.
Thank you.
No cross. Oh.
Do you want to call another witness or morning recess?
Morning recess, but, Your Honor, if I could just, either before or after, I just need to address one thing with the court at sidebar.
All right, so we'll send the jurors out. Jurors, why don't we take the morning recess?
Taking the morning recess. No cross because I think they felt like it wasn't needed. They already got out what needed to be gotten out. The call went in at 2:30 from the prosecutor's office before they even left on this quote unquote fact-finding investigation. They had already decided it was a homicide. They had already decided they were seizing the car. That's important because that just shows they had already reached the conclusion of what had happened and what the significance of all of this was. Elicited that the taillight was cracked, a piece missing, but not entirely gone. Not completely damaged, she said. It was cracked and a piece was missing. I mean, there's nothing else you're gonna get from that cross. Like, what else do you need? Like I said, I really wish if they had a chance to interview him beforehand, would have loved it if he had been able to identify, that reconstruction. Because yeah, I'll bet that probably is what it looked like. That little piece that little piece that somehow they never recovered those pieces from 34 Fairview. And it's that one little piece that's right at the top, that's right next to where the tail light meets the door hatch. That's the one, when you look at the body cam video, everything else looks smooth, looks intact. It's not caked full of snow like Proctor and Bukhenik has been trying to say. It just looks like it's covered smooth in snow, and then there's a little indentation in that same little spot where it looks like where that piece is missing in the reconstruction. So yeah, what does it look like? Looks like she hit his car, broke off that one little piece. Those pieces didn't get recovered because they're in John's driveway. So they never recovered that. But the rest of the taillight was intact. That sure seems to sound like what this officer just testified to. So that's why you don't cross him. You don't need to. You don't need to. Don't know that they're going to give us anything here until we get the fan, but I'm going to pull up my notes, guys, show you where I'm at here. Mentioned before, I'm on number 14 of my little yellow pads here because of my obsessive note taking. And so I'm just going to find right here on pad number 3 where Sean Good's direct examination started. And so he got there, lots of people standing around. He got there at about 6:16 a.m. John was already in the ambulance. It was a chaotic scene. He spoke to Reed. She was yelling, "Is he dead?" Asked if she'd driven there. She said, "I think so. Then I don't remember." She spoke to the others. Then the whole getting her into protective custody. So this was all on direct examination. Then they talk about the snowblower. It worked great. I remember him talking about how great the snowblower worked because they were able to get it down all the way down to the bare ground.
You are unmuted.
All right, so we'll take about a half an hour break.
Taking their break, and we're going to the only fan. The only fan. Well, let's that too, because I'm sure Jesse's going to come up with his ad for law and crime. Just continuing to look through here. He's the one that told us that Canton Police Department hasn't been involved in any homicide investigations in 18 years. This is the one that they chose, that they needed to do that collection with the solo cups and the Stop and Shop bag for some reason. Heard Karen Reed screaming at the top of her lungs. Later, it came up that I was one of the first on scene. Never heard Karen Reed say, "I hit him, I hit him." Right there in the cross, would have included it in his report. Never heard Karen Reed say, "I hit him, I hit him." There you have it. There you have it. So are we to believe Trooper Bukhenik, or are we to believe Sergeant Good? You know what this is starting to remind me of? Hang on a sec. I'm going to drop these off. All right. Got them all back in their place. What this is reminding me of, you remember how Amber Heard? Remember how Amber Heard had all those people that backed up her story, that they saw this or they said that or they commented about something, And then either none of those people showed up or when they did show up, that's not what they reported. That's not what they reported. I mean, even things as basic as like, oh yeah, all the friends of hers that were living in Johnny Depp's penthouses and were totally witnesses to all of this abuse that she was going through, saw her injuries and stuff. Yeah, they didn't. They didn't. They never saw any abuse. And they all said that. They never saw any abuse. Ugh, remember the doctor? Remember how the doctor saw all her injuries? And then you got the actual medical note where it said skin intact, no head, ears, eyes, nose, throat, normal. When she's saying she's got a broken nose, a split lip, 2 black eyes, et cetera, et cetera. Remember that? She's like, the doctor saw it, and the doctor's note said none of it's there. This is triangulation. This is the triangulation technique, where you put somebody else on the spot, you put words in their mouth, and now you've put the pressure on them. Are they on your side? Because if they're on your side, they're going to have to back up what you said, right? Right? If they're not on your side, that's the only way. It's the only way they could possibly disagree with you, right? Not because they're being truthful, but because they're not on your side. Yeah, that's what a lot of this is reminding me of. A lot of this is reminding me of which side are you on? Not what's true, not what's not true. Whose side are you on? Oof. So they're taking a half-hour break. It's going to be a little bit of a longer one. Guys, what I'm going to do here, I forgot to get my tea this morning because it was so super early. I'm going to go ahead and check in on some of our super chats again. But then I am going to pause briefly and run and get some of my tea while I can. So Jason Sorensen starts. So basically the judge made it so they can't talk to the feds, hoping the defense wouldn't call them, and they did it anyway. That's why she's so mad. It's not clear to me that it was the judge who said that the defense can't interview them. It sounded like, okay, because this is part of the 2E process and the 2E proffer, right? They got this information by making their 2E request to the feds, and these reports were disclosed. But being able to subpoena somebody or compel somebody as a witness or interview them or anything along those lines, that requires a 2E process as well. And so that's what they would have to do in order to compel like a deposition or something like that of these particular witnesses. They'd have to submit a 2E request. It would have to go through Department of Justice. They'd have to do the whole independent evaluation of, whether it's disclosable or whether it is under the exemption, which in this case, how all of this stuff doesn't fall under the active investigation exemption. I don't know. That's what sort of blew my mind initially when I heard that all of this federal stuff had been turned over in the first place for an investigation that's still active. Yeah, unheard of, because it's just so easy for them to say, no, it's still ongoing. We haven't resolved it yet. We can't be showing our cards. It'll tip people off, and that'll jeopardize our ability to pursue our own case. But, maybe they just determined, well, if you get the report, that's okay. But if you go in and, I don't know, just get into details of the process or something like that, maybe that would be more of a problem for them. So that's my sense of where the limitation likely came from. I don't think it came from Bev. I think it came from the feds. They're like, you can have the report, but you're not gonna be able to interview these people until they're actually testifying at trial. Rube, she insisted on telling jury done by end of June before hearing arguments on this motion, which she knew would likely end in need for voir dire. Now she uses that time frame to bash defense. Yeah. I mean, she's the one who made the choice to make that announcement, to get that firm commitment. And here's the thing. Mark this, and we'll come back. We can come back and see how this particular prediction I'm about to make plays out. Because we have seen the meandering, repetitive inability to get to the point questioning of Mr. Lally on direct examination, okay, the part where it's easy, because all you really have to do is ask the officer, and then what happened? And then what happened? We haven't seen him on direct yet, or we haven't seen him on cross yet. We haven't seen him on cross. And I don't have any reason to think he's suddenly going to be skilled and artful at being able to elicit a specific fact that he's trying to get into evidence, that he's going to be able to craft a question to get to where he's going. I just have a suspicion that Mr. Lally is going to be one of these prosecuting attorneys who's not very good at cross. And what he's going to do is he's basically going to just have them repeat what they testified to on direct. He's going to go back through all of it with them, repeat it all, and then try to nitpick little things. Take issue with this word, this phrasing, something like that. Or so you said, pull a little Kathy Newman questioning on him. So you're saying, and then say something completely different than what he actually said. He's going to take just as much time and be just as ineffective, maybe even more so, on cross than he is on direct. So he's going to suck up a lot of time, right? The defense's estimate of how long their case is going to take is based on how long it's going to take them to get the information they need. They have no control over Mr. Lally and how much time he wastes trying to achieve something on cross-examination that may not be achievable. So you just watch. You take this prediction right now. I am predicting that Lally is going to drag out the crosses. It's going to take a lot more time than it needs to. And that means the defense is going to get short on time. And who is Bev going to blame? Who is Bev going to blame? Yeah, based on what we've seen today, I'm going to predict she's going to hold that against the defense. She's going to blame the defense for it. And that's going to come through to the jury when she's going to have to communicate, because she can't cut off their case. Okay, you cannot arbitrarily decide we're done, clock is run out, time is over, material evidence doesn't get presented to the jury just for sole reasons of the stopwatch. That would absolutely be reversible. That is arbitrary, not defensible. So she would have to continue the trial beyond the last week of June. And I can just already see the jury, I know we told you, but this defense case is just taking longer. Something like that. You think we might see something like that? Yeah, that's my prediction. Go ahead and mark that, and we'll revisit it. Because Lally is not going to conduct tight, reasonable cross-examinations. Tracy Collins, don't they have the, I think this means grand jury, the GR transcripts from the FBI? Yeah, I would think that they do. If the whole point here is that nobody's able to interview them, if the feds invoked TUI and said you get the report and that's all you get, or you get the grand jury testimony and that's all you get, then the defense and the prosecution are on exactly the same footing with what they know about these witnesses and what these witnesses are going to say. So here it is. Gotta love courts only fan. Yeah, that was a good one. Kevin Dorr, how many days off has this judge taken off since the start of trial? The G. Kelly trial and this trial, prosecution takes forever, then judge tells defense, hurry up. Yeah, exactly. How much time did we waste on shoveling the apron and establishing that it's snowing and where the band was set up at the waterfall? Okay, at least a day. I swear, at least a day got wasted on this repetitive, immaterial stuff. And here we are blaming the defense for things taking too long. KH8, recurring dreams about searching for something represents insecurities around that item. Looking for your car, you're uncertain about what direction to take in life and where you are going. Oh, it's very insightful. Yeah, the future is always kind of wide open. And I'm at a point where yeah, a lot of ways I could go. A lot of ways I could go. I don't have, I don't have kids, so I don't have obligations kind of that way, forcing me to do anything. Got a lot of freedom right now, and that's a wonderful place to be. But yeah, it can also be a little pressure. Where do you go now? What do you do? So good read. I like that. Marcelo Frias, I want to scream to Auntie Bev so bad. I really can't stand this judge, this prosecution, and these disgusting witnesses. I would be seething if I was in the jury. What are the odds that out of 12 people sitting there, plus, however many alternates, I don't remember how many alternates they chose. I think 3 or 4. I can't remember now. Anyway, they're all sitting there watching this. What are the odds that none of them are sharing this? That seems pretty unlikely. I got to think some of those people on that jury are feeling exactly the same way that you are. Micro Kimmy, also a repeat dream of mine. It means you're seeking clarity, direction. You're feeling vulnerable without the usual protection or guidance you're accustomed to. Yeah, I don't have a schedule. This trial now is what's giving me my schedule. And so, yeah, that was, it's been a difference since I stepped back from my public defense work and that real just constant active practice of law where you're just you're in the trenches all the time. There's deadlines flying. I mean, everything gets structured for you. And part of my reason for stepping away from that was that I wanted to have the chance to get bored, and see what would I even do? Like, if I got bored, what would I want to do to fill my time? Like, what would I feel like doing? Would I want to travel? Would I want to make something? Would I want to take a class? Would I want to learn a new skill? I mean, there's so many opportunities for how to fill your time when you have complete freedom to be able to explore that. So that's really, I think, what I was looking for. But yeah, it is both comforting and restricting having that schedule. You don't have to make those types of decisions. You don't have to, look at things like, what am I doing with my life? Am I where I want to be? All that type of stuff. I'm in that stage of life where you start thinking about those kinds of things. So Arla 7247 had to drive slow to keep the hair attached. That's why it took all that time. And then the more we've seen this body cam or this, the security video from inside the Sally Port, even as, unreliable, stitched together and so forth that it is. I mean, that one section we saw, there was like 7 people in there, okay? And nobody is wearing protective. You're not wearing your hair nets and stuff like that. You got stuff on your clothes. I mean, you're going to try to tell me that this is a John O'Keefe hair that was on there from the point of this accident that they say happened at 12:30 in the morning, made it through all of these long drives. That's somehow more realistic than somebody in the area milling about, just had a hair kind of fall out, land on the car. Yeah, that's going to be a pretty tough sell for me. Bukhenik like mechanic fixing the evidence. He's sure trying, right? He was trying so hard to explain that away. Well, no, it's not that it's missing. It just didn't get recorded because of the motion activation. We can see with our own eyes, Trooper. I'm not having the gaslighting. I'm not going to accept your word when your word contradicts with what I can see with my own eyes, which, by the way, is the same thing that happened with all that security footage from CF McCarthy's. With all the drinking that you said you saw, we sat there and watched the video. We watched it with our own eyes. Didn't see it. Didn't see it. You don't have magic eyes. Yeah, that's what he's doing. He's trying to fix the evidence. Brenda S., what governance exists to prevent judges from corruptly managing a trial? How are they held accountable, kept in line? Thank you. So there's really 2 mechanisms. One is appeal. They make bad calls, they'll get reversed. It's a tough standard on appeal. I've talked about that many, many, many times because judges can make a lot of mistakes. And if the Court of Appeals doesn't feel like those mistakes actually had an effect on the outcome, then it won't matter. It will be harmless error, which still isn't great, right? I would think if you're a judge, you don't necessarily want the Court of Appeals saying over and over and over again, yeah, you messed this up. Good thing it wasn't fatal. Good thing you don't have to do the whole thing over now because of that. But those are usually cases where there is overwhelming evidence of guilt. So even if there's a mistake, something comes in that shouldn't have, something gets excluded that maybe should have come in. When you look at the sum total of everything, like, look, the guy's on camera, the guy confessed, there are eyewitnesses, there's physical evidence corroborating, it's overwhelming evidence, then yeah, a lot of errors are going to be harmless. But I don't think that's this case. Do you? I don't think that's this case. I don't think that's this case at all. I mean, we're supposed to be relying on video evidence and stuff. It's not showing what you're trying to tell me it's showing. I mean, I can look at all these videos of taillight, and to me, at best, it's ambiguous. At best, it's ambiguous. It really doesn't show one way or another what the condition is. And I have to say, I mean, some of these videos, like the 5 a.m. one when she's leaving from John's house in the driveway, awful lot of red on that taillight for that taillight that is supposed to be, nearly entirely missing that whole red section, the part that wraps around to the outside of the passenger side. So at best, it's ambiguous. And we haven't even gotten to the injuries yet. This is not overwhelming evidence. This is built on the statement, I hit him, okay, of the questionable provenance anyway. Bukhenik says, I heard it from Good. Good says, I never heard her say that. She didn't say it. I was on the scene since 6/16. She didn't say it. Oof. Yeah. So then the second way that judges can be held accountable besides appeal is they have their own, like attorneys have ethical commissions and things like that. The Bar Association typically have a branch that handles discipline, attorney discipline, and judges have similar types of oversight like that. Not sure exactly what it is in Massachusetts. I think it's a judicial commission. It's something like that. But similar type of situation where, judges have ethical responsibilities. And so if they aren't meeting those, they can be reprimanded, they can be sanctioned, they can be, up to the worst case scenario, removed from the bench. We had a judge, I've mentioned him before, Scott Galena from Soton County, Washington, over here not that long ago, who got removed from the bench by the discipline committee because, he was convicted of raping the courthouse staff. Yeah, a little bit of an ethical problem there, among other things. So that's the other way that judges can be held to account. Now, practically speaking, does that happen a lot? No, it doesn't happen very much. I have seen one case I can remember off the top of my head where a judge got reprimanded and was ordered in to do training because of just basically repeated rudeness to everybody, but of course, typically to defendants and to defense counsel. She would be very, just rude, make derogatory comments about them, stuff on the record. It was bad. And so, if it gets really, really bad, it can rise to that point. Nothing that I've seen from Bev rises to the level of the stuff that I remember from that case. I mean, just like straight out, basically like name calling and telling them they're stupid and just, stuff like that. So that's an option, but it's really, most of the time, it's kind of like the state bar, where really the only thing that really gets you in trouble is money stuff. Money stuff is what gets lawyers in trouble, and money stuff is what gets judges in trouble. Judges are very restricted on things like gifts that they can receive. You're typically not supposed to receive any gifts over a certain amount. You're supposed to declare any gifts that you receive, things like that. So if stuff like that, or financial interest, you're supposed to declare any like financial conflicts of interest you have in a case because you may need to recuse yourself, that type of thing. So if judges are not being forthcoming and honest about the financial implications, yeah, that's something that that these commissions will often be interested in. But just in terms of this judge sucks, there's political remedy for that. The remedy is political. You got to vote her out. You got to vote her out. You got to vote in a new judge. And that takes us back to square one from today, where we were talking about the politics involved, because somebody has to beat her. Somebody has to beat her in the re-election. And incumbent's always going to have a structural advantage anyway, just because people know their name. Judicial elections, to me, it's just such a strange process because typically they're not supposed to be partisan. There are some states where I believe judges are part of the political process, which to me is just no, that's terrible. Should not be that way. But you know, people, it's very opaque how to choose a judge. How do you choose a judge? Most people don't know much about a judge's record, maybe aren't thinking about what, you know, makes a good judge versus a not good judge. And how do you even tell that if somebody hasn't been a judge before, they're just an attorney who's running for the bench? How do you know if this person would be a good judge? It's just, it's a strange selection process for this particular type of position. And so it ends up typically running on connections. Who's endorsing them? Who have they volunteered with? Who, you know, so who knows who's in the club? Are you part of this club? Are you part of that club? And it just, people make those decisions based on their ability to position you in their worldview of us and me, my people, versus you over there and you other people. If the judge is one of the others, you're not going to vote for that person. If they're one of me, you're going to vote for them. So Judge Bev, she's already established with the me's, right? People have voted for her, voted her into office. Actually, has she? I got to double check. I'm going to look that up real quick. Are judges elected in Massachusetts? I can't believe I have to check that out, but I do. Are judges elected? Oh, judges in Massachusetts are appointed by the governor. Appointed by the governor. So there's no election process at all. Sounds like. Interesting. Oh, we're already back from our break. Let's go ahead and bring you back up here.
Going back to session, you may be seated.
So those are your options. Appeal, judicial commission, voter out. That's how you keep judges in line.
All right, Mr. Lally, your next witness, please.
Yes, Your Honor, the Commonwealth to call Trooper Michael Proctor to the stand.
Proctor. Guys. All hands on deck. Proctor. Well, let's get this going, shall we?
Do you mind please step up?
Raise your right hand. You solemnly swear the evidence the court and jury in the case now hearing to the truth, the whole truth, and nothing but the truth.
Good morning, Your Honor. Good morning, jurors.
Good morning, jurors. What's that?
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning, sir.
Would you please state your name and spell your last name for the jury?
Trooper Michael Proctor, Proctor.
And how are you employed, sir?
I am currently assigned to the Norfolk County District Attorney's Office in the Homicide Unit within the Massachusetts State Police.
And how long have
Trooper, I'm going to ask you to keep your voice up loud, okay?
Yes, ma'am.
Thank you.
And sir, if you want, that microphone in front of you is adjustable, so however close or far away you want. How long have you been a trooper with the state police?
For over 10 years, and it'll be 5 years in September with the Homicide Unit.
Now, with reference to your work with the Homicide Unit, with the Detective Unit at the District Attorney's Office, what, if any, specialized training did you receive in regard to your work within that unit?
I've attended several homicide schools. I've also been certified in Celebrite software programming. I've also, in addition to homicide investigations, have worked within the narcotics unit on several different investigations there as well.
Celebrate trained, huh?
Now, with respect to your work with the detective units, as far as, do you have sort of an on-call system?
We do.
And can you explain to the jury sort of how that works or how those specific days for your on-call duties are assigned?
Sure. So a Sergeant Bukhenik usually sets the on-call rotation. It's at random, and your on-call is from 7 a.m. to 7 a.m. Any unattended death, homicide, suicide, overdose, things of that nature that comes in during that time frame, you own it. That's your call.
Now, were you working in that capacity with the detective units on January 29th, 2022?
Yes.
And at some point in the morning, did you receive a call in regard to a situation in the town of Canton?
I did.
And what, if anything, was that? When did you first receive that call from them?
Sergeant Bukhenik called me at approximately 6:48 that Saturday morning, advised that Canton PD had a male party that was discovered in the snow outside of a residence, and he wasn't sure what had happened. It was originally given to me as a possible medical situation.
And based on that initial call and that initial information that you received, what, if anything, did you do?
And at that point, I knew I needed to gather further information, so I contacted Detective Lank from Canton Police Department to see exactly what transpired in the morning. He had informed me that a male party had been transported to Good Samaritan Hospital with some injuries. Detective Lank didn't have much more information, so I knew I needed to contact the paramedic at the hospital, the individual treating Mr. O'Keefe.
Now, before I get to that, if I could, I'm sorry. As far as Detective Sergeant Lank was concerned, was that someone that you called on your own, or how did you get his information, or why did you call him specifically?
I knew he was on scene, so I called Detective Lank.
So that was some information that you had received at some point earlier, and then you contacted Detective Sergeant Lank.
Correct.
And following that, you reached out to whom? I'm sorry.
This firefighter Anthony Flamati.
And with reference to that conversation, what, if anything, did you learn from that?
Firefighter Flamati informed me that
I'm going to allow it.
Firefighter Flamati informed me that Mr. O'Keefe had some injuries to his right arm, some abrasions to his right arm, some injuries to his eyes, a cut to the nose area, and he put a 10% chance of survival for Mr. O'Keefe.
And then based on that information, who did you call next?
I contacted Sergeant Bukhenik, advised him that this sounds like it's more than a medical situation.
And what, if any, decision did you and Sergeant Bukhenik come to with regard to what to do or where to go or what the next steps should be?
So there's a couple different steps. Number one, it was blizzard conditions, and we operate, Ford Fusions or Chevy Malibu. So we got authorization to use our personal vehicles that are four-wheel drive, and to meet at Canton PD and to speak with the responding officers.
And about what time was it that you and Sergeant Bukhenik arrived at the Canton Police Department?
It was approximately 10 a.m. that morning.
And so, Trooper Proctor, if I could ask you, whereabouts were you at about 8:22 in the morning?
Home.
Had you shoveled out of your driveway at that time?
Not yet.
Had you cleaned up your car at that time?
No.
So you arrived at the Canton Police Station about 10 a.m. or so. When was it that you arrived in relation to Sergeant Bukhenik?
At Canton PD?
Yes.
I don't recall if Sergeant Bukhenik arrived first or myself.
But suffice it to say, at some time you both arrived around 10 a.m., is that correct?
Yes, sir.
And where did you go with the Canton Police when you arrived there?
We spoke with the Sergeant Sean Good.
And what, if anything, did you learn from Sergeant Good?
Sergeant Good informed us that while he was on scene, he identified Kerry Roberts, Jennifer McCabe, Karen Reed. He also informed us that Jennifer McCabe was out early in the night at a waterfall bar in Canton with some individuals, and that she was the one who called 911 when they found Mr. O'Keefe in the snow that morning.
Now, with regard to the parties that you just mentioned, prior to January 29th, 2022, had you ever met or were you aware of either Jennifer McCabe or Kerry Roberts, or Karen Reed, or John O'Keefe?
I've never met any of them.
And at some point subsequent, did you have occasion to meet and speak with Ms. Reed?
Yes,
And do you see Ms. Reed in the courtroom today?
I do.
Just for clarification purposes, if you could identify as to where she's seated or an article of clothing that she's wearing.
She's seated between Mr. Jackson and Mr. Yannetti wearing a pinstripe sport coat.
Just ask the record reflect identification of the defendant.
Yes.
Now, after you speak with Sergeant Good, did you speak with anybody else at the Canton Police Station?
No.
And where did yourself and Sergeant Bukhenik go from
We then traveled to the home of Matthew and Jennifer McCabe.
there? Now, with reference to when I say you and Sergeant Bukhenik, at how long a period of time was it that you were with Sergeant Bukhenik on that date of January 29th?
From 10 a.m. approximately when we met at Canton Police Department until we returned to the Canton Police Department that afternoon around 5:30 in the afternoon. So all day. And we also had a debrief meeting with just the troopers in my office at Canton PD. So at least from 10 to 6, 7, because we also went back to the office with some evidence.
And so from that entire time, from 10 in the morning until later on in the night, other than maybe short drives in individual cars, were you essentially with Sergeant Bukhenik that entire day?
Yes, we used Sergeant Buchenek's pickup truck that entire day. I left my personal vehicle at the police department and I rode with Sergeant Bukhenik all day and into the evening.
Now, from the Canton Police Station, where did you and Sergeant Bukhenik go?
The McCabe's house in Canton.
And who, if anyone, did you speak with there?
We spoke with Matthew and Jennifer McCabe, as well as Brian Albert.
And those interviews that you conducted, were they how were they conducted?
One-on-one, Sergeant Bukhenik and myself kind of rotated out Jennifer, Matthew, and Brian. So first we interviewed Jennifer, and then once that was completed, we had her step out, go to a separate room, brought in Matthew, and then the same thing with Brian.
And for the balance of the interviews that you conducted several interviews over the course of your investigation in this case. Is that correct?
Correct.
And for those interviews, as far as individually done, was that primarily what you did with each of the people that you interviewed over the course of the investigation?
Yes, each interview conducted was either with Sergeant Bukhenik or another trooper, and one-on-one, with the exception of Julie and Chris Albert, I believe, were in the same room as us.
Now, with respect to, I believe you just answered it, but as far as each of the interviews that you conducted over the course of your investigation, was it at any point in time, was there an interview that you conducted just by yourself?
There was just one.
And who was that one that you conducted by yourself?
That took place just at the grand jury across the street. It was the Currans. I had some difficulty locating them, so when they appeared for grand jury, I interviewed them one-on-one by myself prior to their testimony at grand jury.
You had attempted to meet with them prior to them coming to the grand jury, is that correct?
Yes.
These are defense witnesses, I believe.
Correct.
However, they were responsive to the summons, and so you interviewed them before they went into the grand jury, correct?
Yes.
Other than those, as far as Mr. and Mrs. Curran, every interview that you conducted was in the presence of at least one other trooper?
Correct.
But
now,
not recorded.
as far as you mentioned one name that we hadn't discussed before at the McCabe household, a Brian Alberts. Prior to January 29th, 2022, had you ever met or were you aware or did you know Brian Alberts?
And I've met Brian Albert until that interview.
Now, following the interviews that you conducted
So
at
did
the
you know
McCabe
him?
household, where did you go from there?
After the interviews at the McCabe household, Sergeant Bukhenik and I traveled to Good Samaritan Hospital for two reasons. One, we knew Miss Reed was there receiving treatment for Section 12. And two, we wanted to view Mr. O'Keefe.
And when you arrived at the Good Samaritan Hospital, was the defendant, Ms. Reed, still at that facility at that time?
We had spoke with the security staff at Good Samaritan Hospital. They informed us that Miss Reed was released.
I'll allow it, just to where you went.
That Miss Reed was released several hours prior to our arrival.
And do you know about what time it was that you arrived, yourself and Sergeant Bukhenik, at the Good Samaritan?
Maybe approximately 1 o'clock.
And you mentioned there was a second reason, and that was to view Mr. O'Keefe, correct?
That's correct.
And did your application, or did you have a chance to view Mr. O'Keefe's body at the Good Samaritan?
We did.
And where was that within the hospital?
That was in the emergency room.
And when you went to where Mr. O'Keefe was, can you describe for the jury what, if any, observations you made of Mr. O'Keefe's body at the time that you observed?
The first thing I noticed on Mr. O'Keefe is he had abrasions on his right arm. On the top of his right arm, there's approximately 6 to 8, ranging from his forearm to his lower bicep. There was no injuries underneath that forearm. Both eyes were swollen and black and blue. He had a cut on, I believe it was his right nostril. Another smaller cut, I believe it was on his left eye. Those were the injuries that kind of jumped out to me.
At any point in time, did you make any observations of the back of Mr. O'Keefe's head while you were there?
I did observe blood on the back of the head. I wasn't able to tell if there's any significant trauma to the back of his head.
Now, from the Good Samaritan Hospital, yourself and Sergeant Bukhenik, what, if any, items did you secure in evidence from the Good Samaritan Hospital?
So after we viewed Mr. O'Keefe's body, we observed a pile of clothes in the corner that hospital staff had cut off Mr. O'Keefe and kind of piled into the corner. The one thing that had jumped out to both of us was one sneaker. And it's fairly common in a motor vehicle pedestrian strike that.
Sustained. Next question. I'll strike from fairly.
Yes,
common.
Reddit themes are not evidence.
As far as the clothing that you observed, can you describe the clothing that you observed?
Yes. We observed one black sneaker with the Nike logo, a pair of blue jeans, a belt, boxer shorts, an orange t-shirt, and a two-tone gray, light kind of hooded sweatshirt type of material.
Now, Trooper Proctor, over the course of your career responding to unattended deaths or death investigations as a member, as a detective of the unit, how many of those have involved situations where a pedestrian was struck by a motor vehicle?
Well, I've been in the unit, maybe 3 or 4, and then I've had other experiences on the road.
And as far as the other experiences on the road, can you expound upon those as far as how many or over what time period we're talking about?
About 6 years I spent on the road, so maybe another 3 or 4.
And with reference to
The shoes, are they
with
always
reference
dead?
to
if
those
the shoes are
pedestrian
missing?
crashes,
That's
what
what
if
Reddit
anything have
says.
you seen in those prior investigations in regard to sneakers or footwear of pedestrians involved in motor vehicle crashes?
Objection.
I'm going to see you at sidebar.
It's Jackson. Jackson is objecting. Yeah, I mean, come on. Reddit memes are not evidence. This is silly. You guys know that one. It's like literally, it's the whole thing. You know, on Reddit, there's like you watch a video of an accident or a fight or something like that, and that's like the whole joke is, did he make it? Well, are his shoes on? Apparently, if you get knocked out of your shoes, then that means you're done for. So a couple things I've noticed already. Never met Brian Albert until that interview. Courtney's wedding. Hello, everyone is there. You're all sitting at the same table. You didn't know who he is. That's going to be hard to believe. He saw blood on the back of his head, but couldn't tell if there was trauma to the back of his head, and you didn't ask. This is like the early part of your investigation. Don't you need to know what the injuries are, what could have caused them? That's like literally that's why you went there. You said you went there to observe his body, right? Because you need information about what condition his body is in order to make investigative decisions about pursuing what could have caused them. So you didn't bother to figure out why there's blood on the back of his head? That seems unusual. Seems a bit strange. It's the whole reason you went there. Find out how he was injured.
Say, John?
Yes.
Now, with reference to your prior experience with pedestrian crashes involving motor vehicles, what, if any, observations have you made on those prior occasions
about people losing their shoes? She's going to let him go there. I mean, she let Bukhenik.
In those experiences, I've observed one, if not both, pieces of footwear remained at the point of impact.
And so with respect to your observations of the clothing, there only being one sneaker at Mr. O'Keefe's property, what, if any, significance did that have to you as far as the sort of steps you took subsequent in your investigation?
That was just a little piece of evidence that Sergeant Bukhenik and I picked up, that only one piece of footwear revealed the potential of a vehicle strike.
Now, in addition to Sergeant Bukhenik is one of your
the only way you can have only one shoe.
Is that correct?
Yes.
And is another one a Lieutenant Brian Tully?
That's correct.
Now, with respect to the one sneaker that was found in Mr. O'Keefe's property, what, if anything, with regard to that, did you communicate to Lieutenant Tully?
Objection.
As to how it goes to the investigation,
Yes.
I'll allow it.
So Sergeant Bukhenik and I informed DLT Tully that there was one shoe at the hospital.
And with respect to Detective Lieutenant Tully, are you aware that subsequently in the afternoon that there was a search that was conducted in the area of 34 Fairview Road where Mr. O'Keefe was found?
Yes.
And are you aware of what, if anything, was recovered in the area where Mr. O'Keefe was found on that day?
Objection.
I'll allow it as to the investigation.
That's
Yes.
That's not
And
as
what
the
are you-
investigation. That's what you were told.
We were informed, Sergeant Bukhenik and I were informed that SIR team and Detective Lieutenant Tully discovered a black Nike sneaker with the white swoosh logo that was a match to Mr. O'Keefe's shoe at the hospital.
Now, from these items of clothing, I'm sorry, let me just look up the song and move on. Trooper, in addition to the shoe that you've already referenced, what, if anything else, did you observe about what kind of clothing and the condition of the clothing that you observed in the hospital?
The clothing seemed was wet. It was pretty well saturated. The right sleeve had some like cuts to it, like tears to it. There's blood and vomit on it, if I recall. Those were the observations I had made of the clothing. And they had been cut due to rendering first aid as well, the pants area.
Now, subsequent to viewing these clothing items at the hospital. At a later time, did you have occasion to observe surveillance video from a variety of places on the evening of January 28th into the early morning of January 29th, depicting Mr. O'Keefe?
Yes.
And what, if anything, did you note with regard to the clothing that you observed at the hospital and the clothing that you observed in the video?
So the videos I reviewed at CF McCarthy's bar and the Waterfall bar were the same clothes Mr. O'Keefe was wearing that Sergeant Bukhenik and I had secured at Good Samaritan Hospital.
Now, Trooper, I'm going to ask you some questions just in regard to securing these items specifically as evidence, but in general terms, as far as securing items and evidence within your unit. How is that accomplished? How is that done? What do you do with items that you deem of evidentiary value that you then secure?
Generally, if we take an item for evidence, we'll put it in a brown paper bag, document it, time, date, who secured that item, address, where it's discovered, and then we'll bring that back to our office, to the evidence processing area. From there, it'll go to a permanent evidence room that has triple retention. It has an actual key, a key card, and an actual access code. And only 3 members of my office have access to that room: the 2 evidence officers and Detective Lieutenant Tully.
And at this time, in January 29th, 2022, who was assigned as the evidence officers who had access to that room?
So that'd be Trooper David Achico and Trooper Jeffrey Kukowski.
Did either yourself or Sergeant Bukhenik have any access to that evidence storage?
No.
Now, with reference to these items that were seized and, say, items that were seized subsequent during the course of your investigation, did they go through that same sort of evidentiary storage process that you were speaking about before?
Yes.
Oh,
Now,
did they? Because it took
with
several
reference
days.
to, in addition to the clothing items, at some point did you come into possession and seize Mr. O'Keefe's phone?
Yes.
And do you recall where it was that you received or retrieved Mr. O'Keefe's phone from?
We received it at the Canton Police Department.
And was that prior to you going
At
to the
the
Good
scene?
Samaritan?
After, I believe.
That's
So
back.
following the Good Samaritan, where did you go from there?
So after the Good Samaritan Hospital, Sergeant Bukhenik and I traveled to 345 Country Hill Drive in Dayton.
And why did you go to that location?
That was the residence of Miss Reed's parents' home, and having a brief conversation with Miss Reed on the phone, she informed us she was at her parents' house.
So you had called Miss Reed, spoken to her, and informed her that you were coming there to speak, correct?
Correct.
And just as you had done with Ms. McCabe, Mr. McCabe, you spoke to Miss Reed within her home?
Yes.
And who, if anyone else, did you reach out to on your way there with regard to local law enforcement as you were driving to Dayton?
We contacted the Dayton Police Department just for a couple of reasons. One, it's a common courtesy. If we're in another town, we just kind of give the local PD a heads up. But also we needed to coordinate a plow truck and potentially a tow truck as well.
And why did you need to coordinate those?
At the time, there must have been at least a foot of snow on the ground, more. And it was a dead-end cul-de-sac, so which made it difficult to navigate. So we requested the plow to clear a path for Sergeant Bukhenik and I to get down the roadway, as well as clear the driveway of the residence, so the tow truck could pull into the driveway.
Now, as far as the drive from Good Samaritan, that's in Brockton, is that correct?
Yes.
As far as the drive from the Good Samaritan Brockton to the defendant's parents' home in Dayton, about how long a drive was that, and how would you describe the weather conditions along the way?
Yeah, the weather conditions were whiteout, high winds, blizzard conditions. We had to travel very slow. It was almost about an hour to get there.
And when you arrived there,
So why did it take another
you're in
half
Sergeant
hour to get
Buchanan's, truck, is that correct?
Correct.
And where did Sergeant Bukhenik position the truck in relation to the house at 345 Country Hill?
From what I recall, Sergeant Bukhenik went down the cul-de-sac and turned around, and he actually had to let me out first because of the high snowbanks, and then he parked kind of along the snow, pointing essentially to Mr. Reed's house.
And at some point, did members of the Dayton Police come along and join?
Yes.
And do you recall who those people were?
I believe one of the officers' last name was Barros or Barrios.
And had you ever met that officer before?
No.
Now, with respect to the home, had you and Sergeant Bukhenik approached the home at any point prior to the Dayton Police showing up?
I can't recall if, no, they had arrived first before we approached the home.
And when you approached the home, you went, what did you
Okay, that makes
traverse?
sense.
How did you get from the street to the home?
We walked down the driveway, and then we observed Miss Reed's Lexus parked in the driveway, the front of it facing one of the garage doors. That's when we observed the broken taillight on the right side of the vehicle. We then proceeded to the front door. The snow was about up to our waist, and knocked on the door and was greeted by Mr. Reed.
So as you're walking up the driveway towards the home, you see Miss Reed's vehicle, is that correct?
Yes.
And that's a vehicle that you later subsequently found to be registered to Miss Karen Reed, is that correct?
Correct.
Now, may I approach?
Yes.
So I'm showing you documents, 4 pages in length, just ask you to review that and finish.
Yeah, waist deep snow. I mean, it's going to be the Donner Party here pretty quick. That's why it took so long to get back to Dayton, because they, you know, had to eat somebody. I mean, yeah, snow will drift, but waist high, come on. It was rare to get waist high powder in Tahoe.
And do you recognize that document?
Boy, when you did,
Yes.
those were
What do you
great powder
recognize?
days.
The Registry of Motor Vehicles, it's the certified document for Miss Reed's Lexus.
Is that the plate information that's contained in there, is that the same plate that was affixed to Miss Reed's vehicle on that day?
Yes.
And that also details sort of the history or how long she's had possession of that vehicle, is that fair to say?
Correct.
Going back to, I believe, 2021, is that correct?
Yes.
May I approach, Your Honor?
Yes.
Call with the seeking to introduce and admit as the next exhibit. No objection. Now, with respect to Ms. Reed, at some point you go into the house, is that correct?
Yes.
And how do you enter into the defendant's parents?
So Sergeant Bukhenik and I, after we had knocked on the front door, Mr. Reed directed us around the corner, opened up the garage door for us and invited us in.
Now, if I could take you back to, I'm sorry, just as far as when you're coming up the driveway and you're passing by the defendant's vehicle, you mentioned some damage that you observed to the right rear passenger side area, is that correct?
Yes.
Can you describe to the jury what it was specifically that you observed as far as damage to that area of the vehicle?
Yeah, the right rear taillight had essentially large pieces missing from it.
So you proceed inside the home and
you
where
chose
is
not
it
to
that
take a
you're
picture of
directed
that.
and where is the defendant?
We're invited into a large living room area. Miss Reed is seated on a couch, and her parents, William and Janet, are present for the conversation and kind of standing off to the side.
And that conversation goes on for approximately how long?
Approximately half hour, 40 minutes.
And when you terminate that conversation, you come back outside of the home, is that correct?
Yes.
And where is the vehicle at this point?
That is being put on the tow truck.
Now, in addition to the defendant's vehicle, what, if anything else, was taken and seized as evidence from the defendant on that one?
After confirming the phone Miss Reed was holding was in fact hers, we told her we were seizing the phone and we'd be writing a search warrant for that.
Now, during the course of the conversation that you and Sergeant Bukhenik had with the defendant that afternoon at her parents' home in Dayton, Were there some questions in relation to contact information for other people that were at bars or different establishments the night before?
Yes, we asked Ms. Reed specifically for some of the friends that Mr. O'Keefe was with at CF McCarthy's. One person in particular was Michael Camerano. So we observed Ms. Reed enter the passcode on her phone, retrieve Mr. Camerano's phone number for us, provided to us, and that just further confirmed that was her cell phone.
Now, through your training experience, when a cell phone is seized from a person, what, if anything, is it that you do with regard to that cell phone
For
to
news.
observe the information on?
Well, the first thing we do is we put it in airplane mode, and then we give it to a cell phone expert in our office, Trooper Nicholas Garino, and he essentially tries to access the data in that phone once a search warrant is obtained.
Now, as far as putting that cell phone in what you described as airplane mode, what is the purpose of that?
It's to avoid if someone wants to go
Remote
on a
access.
tablet or a laptop and access the information on their phone, and they can start deleting stuff off their iCloud. This prevents that.
So you secure the phone, you secure the vehicle on the tow truck, and then where did you and Sergeant Bukhenik go from there?
We follow the tow truck from the address in Dayton to the Canton Police Department. We're secured in the Sallyport Bay.
And if you know approximately what time was it that you arrived at the Canton Police Department and secured the defendant's vehicle in the Sallyport?
So we left Dayton around 4:16 p.m. and arrived in Canton at the police department at approximately 5:31 p.m.
And with
Approximately
reference to the
5:31.
Canton Police Department's Sallyport garage, why was the vehicle taken there?
I wasn't part of that decision, but it's my understanding that it was a heated facility. The other options were, I believe, the barracks in Milton, but that's not large enough to house a vehicle that size, and it's not heated.
And in regard to the heated, what was the sort of purpose or utility of storing it in a heated setting?
Miss Reed's vehicle was covered with snow and ice at the time. It was transported from Dayton to Canton.
And with regard to the Sallyport garage area of the Canton Police
And
Department,
still
at some
here.
point were you inside that area?
Yes.
And what, if any, observations did you make as far as the temperature or the heating within that facility?
I don't remember the exact, I couldn't put like a ballpark on temperature, but it was certainly warmer than outside.
Now, as far as the vehicle was concerned, either on scene, either in Dayton or at the Sallyport garage, or at any point in time that you were in the presence of that vehicle, what, if any, contact did you have? What, if anything, did you do or observe Sergeant Bukhenik to do with regard to that damaged area you described on the right rear passenger side?
Yeah, Sergeant Bukhenik and I never touched any part of that vehicle.
Absolutely never.
And as far as the moving it from sort of the
Bet
tow
you
truck
absolutely
into
never
the Sallyport
photographed
area,
it.
how was that accomplished?
The tow truck driver removed it from the tow truck and pulled it into the Sallyport Bay.
Now, as far as prior to leaving that Sallyport area of the garage where the vehicle was, what, if anything, did you and Sergeant Bukhenik do with reference to securing that vehicle or coordinating it off in any way, shape?
We tried to set up a perimeter as best we could using caution tape, and just kind of sectioned it off with caution tape.
Now, at some point, you leave the Sallyport area, the Canton Police Station, and where did you go from there?
We had a debrief meeting. So there's other troopers. There's troopers at scene on 34 Fairview Road. There's other troopers conducting interviews. So at the end of the night, members of my office met in a conference room at the Canton Police Department to exchange information as far as what everyone had learned throughout the day.
And as far as that
Canton
meeting is
Police
concerned, that's
Department.
just troopers from your unit, from your office, is that correct?
That's correct.
And so there were no members of the Canton Police Department that were present for that, is that correct?
No, correct.
And do you know why that was?
They had taken a step back from the investigation. They weren't going to participate in any
Not just the
interviews
interviews?
or anything of that nature.
And
Or
how
anything
was that
of that
communicated
nature.
to you and Sergeant Bukhenik?
Best of my recollection was that debrief meeting that we were informed that essentially Canton PD would be taking a step back from the investigation, and that now this is just solely a Norfolk State Police investigation.
So before we get to sort of the debriefing and all that's covered in that, as far as when you're on call, you get a call for any kind of sort of homicide or unattended death or anything like that. You then become what's called a case officer for that investigation. Is that correct?
Correct.
And can you describe for the jury sort of what the duty or the role is of the case
Well,
officer?
kind of like a lead
vis-a-vis,
investigator.
The rest of the members of the unit.
So essentially, a case officer is more of a facilitator. You kind of delegate out tasks, coordinate interviews. The case officer isn't the sole decision maker. I have supervisors. I have that we bounce ideas off of. I get feedback from. I also keep them updated. It's a collaborative effort in each investigation. We're a small office, so when a homicide comes in, everyone essentially drops what they're doing, and we all work on it together. So it's a collective effort to work on these cases. And essentially, the case officer is just kind of the record keeper of all the reports that come in and video that comes in. But when it comes down to decision-making time, it's a group effort.
Now, with reference to that collaborative effort that you were just discussing and this sort of debriefing meeting, so there were other troopers doing other things or other tasks throughout the course of the day of the 29th, correct?
Yes.
And so what was sort of the purpose of or not specifically what was discussed, but in general terms, what was discussed during the course of this debriefing?
The taillight piece is found at 34 Fairview Road by CERT. The one sneaker found at 34 Fairview Road. Interviews conducted, and then Sergeant Bukhenik and I also shared everything we had kind of learned throughout the day as well.
And that debriefing meeting, if you know about how long approximately did that take in this case?
I can't recall, maybe half hour.
And so following that meeting, where did you go from there?
Sergeant Bukhenik and I had secured some evidence, the clothing from Good Samaritan Hospital, the additional sneaker found at 34 Fairview Road, as well as the taillight pieces discovered at 34 Fairview Road. And
So you had
Mr.
them.
O'Keefe's cell phone and Miss Reed's cell phone,
So
and him
totally
and
gave
I
them to you.
transported those to the office in Canton.
And when you transported them to the office in Canton, what, if anything, did you do with those items?
The two cell phones were given to Trooper Nicholas Garino, and the clothing was laid out on top of butcher paper to dry out in our evidence intake area. And then the bag taillight pieces were set aside in the evidence intake processing area. Sergeant Bukhenik and I didn't have access to the permanent evidence locker area, so we just secured them in the temporary intake area.
And that leads me
Why didn't
to
you
my
book
next
them in?
question. As far as the area that
And
you're
why
talking
did
about with regard to
Chico
clothing
bag them
items
on
and the other
February
items that are
4th?
secured beyond the cell phones, that was in a secure area of your office, is that correct?
Correct.
Why didn't
And
you
by
book in
secure, I
the
mean
phone
restricted
before you gave it
access
to Garino?
The troopers within your unit, correct?
Correct. It's you need a key card, and it's also equipped with an alarm.
Now, following that, as far as these items of evidence and other items of evidence that are seized throughout the course of an investigation, how is it that they go, or what, if anything, is done, if you know, between the time that they go from this temporary storage area to the permanent storage area?
Yeah, I'm not an evidence officer. I never have been. My understanding is once it's in the evidence processing area, it gets put into the permanent evidence room that only, like I said, two troopers and a detective lieutenant have access to. And it's
You just leave it in
the
10
evidence officer's responsibility to
and it magically makes it into
process
permanent?
that material when they see fit.
Now, sir, if I could
Oh,
turn your
really?
attention to February 1st of 2022. Were you working in regard to this investigation on that date as well?
Oh, really?
And at some point, did you have occasion to go back to the Canton Police Department, specifically in the Sallyport garage area?
I did.
And what was the purpose of you going out to the Sallyport garage on that?
Pursuant to a search warrant, we were processing Miss Reed's Lexus SUV.
And when you say we, who, if anyone else, was present with you, or who, if anyone else, did you contact in reference to the processing pursuant to that search warrant of the defendant's vehicle?
So we had a chemist from the State Police Lab, Miss Maureen Hartnett, as well as a trooper from Crime Scene Services, Trooper Zachary Clark. And then later in the day, the accident recon team, Trooper Joe Paul, had arrived as well.
Now, if I could just ask you a couple questions in regard to Crime Scene Services section. Can you describe for the jury sort of what their role is in regard to investigations that you do and how they're sort of contacted?
So in any scene, if it's required for it to be documented, Crime Scene Services will arrive. They'll document the scene with photographs. In more serious situations, in a homicide, for instance, they'll actually take video as well as dust fingerprints.
Now, with respect to this particular investigation, there were a number of different areas or different times when Crime Scene Services was contacted to document things, correct?
Yes.
And that would include at Good Samaritan when you observed injuries to Mr. O'Keefe?
Correct.
That would include the autopsy that was performed on Mr. O'Keefe?
Yes.
That would include February 1st in the Sallyport garage when the search warrant was executed on the defendant's vehicle?
Correct.
That would include subsequent searches that occurred at Fairview Road, is that correct?
Yes.
And with respect to each of those instances, if you know, was it ever the same trooper from Crime Scene Services section that came out and memorialized each of those respective areas?
Yeah, it was a different trooper each time.
And is that something that you or any member of your unit has any control over whatsoever as far as who shows up from Crime Scene Services to memorialize or document?
It wouldn't matter.
No. Now, with respect to the search warrant execution on February 1st, what I want to ask is between the time that you were in the garage on January 29th, 2022, and the time that you're there for the search warrant execution on February 1st, had you been in that Sallyport area of the Canton Police Station at any time in between?
No.
Now, with respect to the taillight area on the passenger side of the defendant's vehicle, what, if any, differences or what, if any things you note sort of between your observations of the
What, if
taillight on the
anything, did you
29th
fail to
versus your
photograph?
observations on February 1st?
Yeah, the only difference from the 29th to the 1st was snow and ice had melted from the taillight.
So as far as the condition of that particular taillight, was it in essentially the same condition that you observed it on the 29th when you observed it on the 1st?
Yes, it was still broken and large pieces missing from it.
But as far as the broken status of it and the pieces that were missing, was it any more broken or any more pieces missing from it when you saw it on the 1st versus when you saw it on the 29th?
No.
And with respect to the taillight housing for that vehicle on that particular day, what, if anything, happened with it on that day, if you know?
The state police chemist, Ms. Hartnett, had it removed, which she brought to the lab herself.
So she had it removed it herself, and then physically took it with her when she left to the lab?
Yeah, it was with the assistance of a Canton police officer who had an auto body shop, so he's kind of well versed in cars, so he was able to assist the chemist with removing the housing unit.
Now, at any point in time on that day of February 1st, 2022, did you
not rocket
come into
science.
contact physically or otherwise with that tail light? Did you handle it in any way, shape, or
No.
form? Your Honor, if I may, with the court's permission, I would request to publish. Give me one moment, Your Honor.
Hartnett was not the puzzle master. That was Ashley Valier. but she is the one who was there on the scene and recovered it.
May I have one moment, Sharon?
Yes.
Right? I mean, it was mainly just Amber gaslighting us in that trial. Amber and
My
Elaine.
apologies, Your Honor. With the court's permission, if I could publish a portion of Exhibit 34,
Okay.
the Sally Port video. Ms. Gilman, if I could have from February 1st, 2022. At approximately 9:12 a.m.
She did, and there were little pieces with it in evidence, remember? There were some broken off pieces together with the taillight housing that was in her photograph.
You can just pause it right there. Okay. Marty, if I may, it may be easier and more visible with this particular video with the lights on.
Okay.
Try that.
Sure.
Trooper Proctor, directing your attention to what's up on the screen is Exhibit 34. Do you recognize what's depicted on the screen?
Yes, that's the Sallyport area, Canton Police Department, and Miss Reed's Lexus kind of roped off with yellow caution tape.
And this is the execution of that search warrant that you were speaking about before, as far as your presence and some of the other members of the state police and the state police lab that you were talking about.
Correct.
And Ms. Gilman, if you could run it from here for just a few minutes.
This is what it looks like. Jackson is the one who is objecting, so he'll get the cross. Nobody thinks it's weird how they relied on the Sallyport video to document all this stuff?
So while this is going, if I could just ask a couple
That they didn't verify was working?
People within this video, do you recognize anyone in this video?
Yeah, myself, kind of the top of the screen. Trooper Zach Clark, we the one with the camera taking photographs of the vehicle.
Now, with reference to this video from the Sallyport Garage of the Canton Police Department, what, if anything, did you learn over the course of this in regard to how that video is reported, or how it's, what, if anything, sort of activates that video?
Objection.
Ask it differently, Mr. Miller.
As far as this video is concerned, is this one continuous time frame that we're looking at, or how is it?
Objection.
Sustain.
No foundation.
My understanding, it's motion
That
active.
means you can't answer.
Oh, I'm sorry.
You can ask it differently.
Oh, yeah, sure, you don't get that.
All right. I'll strike if there was anything. But Mr. Lally, just ask a question, please.
With respect to this video, as far as the recording is set up, how is that activated, or how does it record?
Objection. Same question.
Yeah. How does he know that?
Don't tell him, Bev.
Just
Now you're going to
sustain.
tell him how to fix his
Have you
problem.
watched this video or other videos?
He knows
the
from
Police Department,
hearsay
Sallyport
because somebody
Garage?
told him.
Yes.
That's how it works.
What, if anything, did you note with regard to timing? As far there is a timestamp on the video, is that correct?
Yes.
What, if anything, did you note with regard to the timestamp on this video or the other videos that you observed with regard to how time moves throughout the video?
The timestamp on the video tends to pause, indicating it's motion activated.
Last
It tends to pause. I'll strike out.
The jury sees you trying to slip that in. I mean, she basically is, isn't she? Giving him a little boost there.
Ms. Gilman, yes. Ms. Gilman, you can take that. Thank you very much. Now, Trooper, with regard to that taillight that was then taken by Ms. Hartnett to the lab, is that correct?
Yes,
And at some point that was returned to the custody of the state police, your detective unit?
correct.
And do you have that taillight housing with you today in court?
I do.
And Your Honor, with the court's permission.
Ooh, the
would,
actual
retrieve that.
taillight housing.
Yeah, Coach, Your Honor.
Yes.
Probably be easier that way. Sir, you can stay right there.
Dun, dun, dun. Oh, no gloves on him. He's not going to put gloves on at all.
Yes.
What do you
Come
recognize
with the
that?
theater. Oh, no, there
That's
they
the
go.
I recognize that to be the housing unit.
So somebody handed him
And as
gloves
far
on the
as
outside.
you're recognizing of the housing unit, is there any sort of denotation or anything on the outside of that box indicating what's contained therein?
Touch the glass, the box, then touch the glove.
There's a state
That you
police
haven't put
crime
on
lab
yet.
sticker with the number associated with it. It also indicates fragile and evidence tape that is initialed and dated as well when it's sealed up.
He doesn't seem to have
And
a
it's-
lot of
the sticker
felicity
also
at
says
putting on
passenger
gloves,
side.
does he?
TA, indicating taillight.
How
Your
long
Honor,
did it take him to
with
put
the court's
those
permission, I
on?
would ask, I would seek to admit and introduce that as the next exhibit.
Do you want it out of the box first, Mr. Jackson?
We could just take a quick look at it.
Sure.
Sure.
With the court's permission, if the.
Yes.
Grab the scissors that have been who knows where with your nice clean gloves. Yeah. Must continue the theater at all costs at this point. That poor court reporter is going to get brought up for murder sometime. Our DNA is on everything now. Come on, pull it a little harder. Just yank it real good. There it is with the reconstruction.
Thank you, sir. Trooper, you can go ahead and put that back in the box.
It's upside down, isn't it? I don't know what we just looked at. It didn't seem like the pieces were on it, the reconstructed pieces, because a lot of the red was missing. I mean, it shouldn't be because those were separately bagged.
Put it on the. We need to mark that, and we're going to mark it twice, folks. We're going to mark the bag within the box, and we'll mark the box as well. Thank you. Nancy.
I'm sorry, Trooper, if you could hand that to Madam Clerk.
With your nice bare hands
Hold on.
now, because
So
you couldn't
it's
wait
in
to get those gloves
544 and
off.
544A.
Your Honor, may I inquire, is the A, the light, and the 44's bag?
We're not even putting it right on the light because it's broken.
Understood.
So we're putting 544 on the bag, 544A on the box.
Understood. Thank you.
You put that on the bag, please, sir.
Open it all back up with your plain ungloved hands, digging around in there with your sticker. So much theater. And now let's just get the court reporter sticking her whole grubby microphone in there.
544A. Thank you.
What are we watching? Oh, man. That poor lady, man. Just wait. Her DNA is going to be at some
With respect to that
crime
item that's
scene.
just been marked as evidence, is that essentially the condition that you observed it in both on January 29th and February 1st?
Yes.
Yes.
Your Honor, with the court's permission, if I could ask just to publish what's been marked as Exhibit 147.
Okay.
Trooper Proctor, do you recognize what's up on the screen that's been marked as Exhibit 147?
Yes.
What do you recognize that to be?
That is the right taillight of Miss Reed's Lexus SUV. And you can see large pieces of it are missing.
Again, is that the same condition that you observed it both on February 1st as well as January 29th, obviously minus the snow and ice?
Yeah, minus the snow and ice, sorry, yes.
Thanks. Just going to take that down, Mr. Officer. You can have the lights.
We
back
saw
up.
it in the Sallyport. It wasn't covered in snow and ice. It's only on the
If I
video.
could turn your attention to February 3rd of 2022. In the morning hours of that date, where did you go in regard to this investigation?
Sergeant Bukhenik, Trooper David Achico, and myself went to 34 Fairview Road along with Trooper Evan Brandt from Crime Scene Services to essentially dig out the snow in pursuit for more evidence.
Who the hell calls anybody
Now,
today?
as far as you mentioned, as far as dig out the snow in pursuit of other evidence, what, if any, tools or implements did you and the other troopers bring with you in order to effectuate that on February 3rd?
We just had kind of standard snow shovels.
And with respect to that, as far as going back to 34 Fairview Roads, and let me clarify as far as that's concerned. Prior to that date of February 3rd, 2022, had you been to 34 Fairview Road at any point in time in the course of your investigation?
No.
So that morning of February 3rd, that's the first time that you went.
Correct.
Now, with respect to
When Karen has already been arrested.
is that how
Already
many
been
times
charged in rain.
did you go to the area of 34
Hadn't even
Fairview
been there
Road over
yet.
the course of the next sort of days and weeks in regard to potential recovery of items?
So February 3rd, I retrieved items on the 8th, the 11th, and 18th. And we was out there on the 10th with Sergeant Bukhenik as well.
Now, as far as any of those occasions that you just described, that you went to the area of 34 Fairview Road, on any of those occasions, were you by yourself?
No.
And with respect to those other occasions, what type of people, who was with you? I know you've mentioned on the 3rd, but beyond the 3rd.
What type of people? My type of
Those
people.
other occasions that you described, who was with you?
On the 18th, I believe it was Trooper DeChico, based on the handwriting on the evidence bag, kind of recognized his handwriting. And the other 2 dates, I don't recall who was out there with me.
Now, with respect to items that were located, starting with the 3rd, do you recall specifically what, if any, items were located on the 3rd?
We've located a black drinking straw, consistent with the one seen in the waterfall video of Mr. O'Keefe walking out of the bar holding the glass. We located his hat that had the American flag that was deep underneath the snow. As we were digging, we discovered that. We further discovered other pieces of plastic as well.
Now, as far as these return trips on successive dates to 34 Fairview Road, what was the reasoning behind that, or what was sort of the plan in reference to why were there so many different dates that you returned to 34 Fairview Road with other troopers?
So after the 29th, there was close to 2 feet of snow that had fallen. And in the days and weeks that had followed, the temperatures ranged from 30 degrees up to 60 degrees. And there was about a half a dozen days mixed in of, heavy rain. So as the snow started to melt, more evidence started to present itself.
So there were items that you recovered on the third,
Presented
and then
itself,
items you
those same
recovered on
words.
successive dates that weren't visible or you didn't see on the third, correct?
Correct.
Now, if I could, keeping you on February 3rd, you mentioned that there was Trooper Evan Brent that was present with you during the search on that day as well.
Yes.
Now, in addition to going to 34 Fairview Road, where else did yourself and Trooper Brent go on that particular day?
We traveled to One Meadows Ave, Mr. O'Keefe's residence.
And is that the first time that you had been to One Meadows Ave or Mr. O'Keefe's residence?
Yes.
Now, with respect to that residence, why is it that you and Trooper Brent went there on February 3rd?
We wanted to document Mr. O'Keefe's vehicle to show that there was no damage to it, as well as the garage doors.
And why did you want to document that?
During the review of Mr. O'Keefe's ring video, particularly the one above the garage that displays the driveway, on the 29th at approximately 5:07 a.m., Miss Reed's pulling her vehicle out of the garage door, backing up towards Mr. O'Keefe's vehicle, and comes extremely close, if not slightly hitting the vehicle. So we want to at least go document that there was no damage to Mr. O'Keefe's car.
And Your Honor, with the court
Because you
permission,
really
if I
wanted
could,
to disprove
publish
that that's how
for
the
jury as
taillight
far as
got
what's been
damaged.
marked as Exhibit 6, video 153.
Okay.
This time, if I could ask the pause. Trooper Proctor, with regard to this ring video, how was this obtained, if you know?
So we first observed it through Mr. O'Keefe's cell phone on the Ring app, and then I wrote a search warrant for Ring itself.
And as far as the videos that you received from Ring, did they match what was on or what was viewable being the Ring app on Mr. O'Keefe's cell phone?
The videos on Mr. O'Keefe's app, yes, they was what Ring produced, matched.
So as far as any videos that were present that you received pursuant to the search warrant, or any videos that were not present, that was consistent with what you observed on Mr. O'Keefe's app on his phone?
Yes.
Now, Ms. Gilman, if you could press play through here.
Yeah, that's convenient, huh? There it was moving, right there.
Now,
Look at those
with
tracks.
regard to this video, you've seen this before, is that correct?
Yes.
Now, the point from this video, are you able to discern who the
A lot of
operator of
red
that
on that
vehicle is?
taillight right there.
Based off the attire, Miss Reed driving.
Now, with respect to when that vehicle, the defendant's vehicle, if you could, there's a laser.
I mean, keep it paused here to stare at the red all day.
If you could, I would just ask you to draw the jury's attention to what, if any, vehicles you observe in this video and whose vehicles you believe them.
So right there, it's Mr. O'Keefe's vehicle and Miss Reed's vehicle.
Now, as far as when those vehicles come close or come into contact with each other, as far as Mr. O'Keefe's vehicle is concerned, what, if anything, do you observe like on Mr. O'Keefe's vehicle at the time?
There's some snow you can see on the back window here, the bumper and the windows here is starting to be covered in snow.
And as far as when that vehicle comes close to or makes contact with Mr. O'Keefe's vehicle, what, if anything, do you observe the snow to come off of the car at that point?
I do not know.
Now, with reference to the back area of Mr. O'Keefe's vehicle, specifically in the area of the ground, as far as that area on the ground, what, if anything, did you observe in reference to the red pieces or any pieces of taillight or plastic or glass or anything in that area that you observed on this video?
So this area here is, you can see the white snow. There's no red pieces of taillight, which would show up in the contrast to the white snow.
Ms. Gilman, if you could run it from there for a moment.
Yeah, what if it wasn't the red that broke off? What if it's the clear?
Now, as far as the damage area that you were discussing previous that you observed in the January 29th.
I mean, look, you can see the entire thing.
The Sally Port, and then the item that was just marked as evidence. What, if anything, do you observe in the right rear passenger side taillight area of the defendant's vehicle from this video?
You can see the inconsistent lighting. If you compare it to the left versus the right, there's a gap right there.
A tiny little piece, not the
What you observed
entire
in that video, does
taillight
that appear to be consistent with what you observed on January 29th at the Canton Police Department, February 1st, and in the item of evidence that was just marked?
Yes.
Thank you. Ms. Gilman, you can take that down. Mr. Officer, we can have the lights back on. Thank you. Now, sir, you proceeded to One Meadows Ave for the first time on February 3rd, is that correct?
Correct.
And Trooper Brent from Crime Scene was with you and took some photographs, is that correct?
Yes.
May I approach?
Yes.
Oh, so Trooper Britt, somebody finally took some photographs at the scene? You the one in charge of documentation? Didn't do it? The other guy did? I mean, it's the gaslighting. It just is next level. They are telling us our eyes are wrong. It's all in our heads, guys.
Trooper, I'm
It's all
showing
in our
you,
heads. We must be going
photographs.
crazy.
You those look up when you're finished.
That's what I saw. That's what I saw.
Trooper, just generally speaking, do you recognize what's depicted in those photographs?
Yes.
And what do you recognize them to?
The front is, the first picture is the front door of Mr. O'Keefe's house, and it's also Mr. O'Keefe's Chevy Traverse.
May I approach, Ron?
Yes.
I'm up to introduce and admit as the next 10 exhibit.
No objection.
Okay.
Yeah, these sound real probative. His front door. Didn't photograph the broken taillight when we saw it, but we photographed John's front door. That, what does it have to do with anything? We're back in this mode of Lally prosecution. Put in a bunch of stuff that doesn't mean anything. This is the Proctor equivalent of the band at the waterfall. See, great investigation because he photographed the door. The lack of the photograph of the taillight at Karen Reed's parents' house, to me, that is fatal to any sort of resolution of the condition of the taillight in favor of the Commonwealth here. You had every opportunity. You would document it. You would do that. You're telling us now this is like the most important piece of evidence that there is that you saw, and you didn't bother to take a photo. I am going to infer there is a reason why you didn't take that photo, because it doesn't show what you're saying it showed.
Thank you.
And Your Honor, with the court's permission, if I could just have permission to publish just a few of those photos for the jury.
Okay.
Ms. Stillman, if I could have photograph 7752. Trooper Proctor, do you recognize what's up on the screen? It's now been marked as Exhibit 546.
Yes, Mr. O'Keefe's Chevy Traverse vehicle.
And with respect to this particular foreground here, if you could describe to the jury what we're looking at there.
So that is Mr. O'Keefe's driveway. You see two garage doors there that lead into the house.
The part where she would have hit him
And
is
above those garage
underexposed
doors
and
is
shows
the
no
ring camera.
detail. You can't see it.
Now, with
It's in the
respect to
shadow.
rear of Mr. O'Keefe's vehicle,
The left
from
rear
your
quarter panel.
viewing of the video from Exhibit 6, from the ring video, video number 153. If you could, using that laser pointer, direct the jury's attention to where it is on this vehicle that there's contact, if any, between Ms. Reed's vehicle and Mr. O'Keefe's.
It would have been in this general area here.
Yeah, the part that we can't
As far as
see.
your observations on that date, February
What's the,
3rd,
hold on.
Maybe approach briefly.
Okay.
This is just nuts. This is just nuts. This is not a difficult to okay. Is it just our angle on the T? It could just be our angle on the TV. That looked like when we weren't getting the glare from the camera that there is more detail there. So yes, to clarify for everybody where we're at, what we're looking at, this is on February 3rd when Proctor and Brent went to John's house. They went to John's house to document the condition of his car because they saw the ring footage where Karen backed into him. And according to him, they wanted to document the lack of damage to John's car, right? Not that they wanted to go out and see if there was any damage, but to document the lack of any. So that's what these photographs are of. These are of John's car in the area where Karen backed into him. And of course, the inference they want to draw is, well, if it was enough to break her tail light, it would have caused some damage on his car. I don't know that that's established. I'm sure we'll have accident reconstruction people who will be explaining those types of details to us. But in general, yeah, plastic is a lot easier to break, than hard paint, enamel paint. But we'll see. Are you guys hearing the dog snoring this morning? It is a little, it's exciting for me, even with Lally, even with the Lallyisms here. But they still can't quite handle it. I got a picture of what's going on over here once we get to break, so I'll share it with you guys. This is just the adorableness that I live with every day. Yeah, Janice, that's I think what Gordon Ramsay would call it, wouldn't he?
You are unmuted.
Trooper, when you were in the driveway of Mr. O'Keefe's residence on February 3rd, 2022, you had occasion to make observations of Mr. O'Keefe's vehicle, is that correct?
Correct.
And what, if any, damage did you observe to the driver's side rear area?
I didn't observe any significant damage or any damage.
As far as the entirety of the vehicle, that was all photographed on that day by Trooper Frank, is that correct?
Yes.
And memorialized in those photographs that were just presented to you, is that correct?
Correct.
As far as your observations on that day or in those photographs, what, if any, damage did you observe to Mr. O'Keefe's vehicle?
I did not observe any damage.
And Brooke Trump?
Yes.
So there's another 8 photographs that I placed before you. Have you had a chance to review those?
Yes, sir.
And do you recognize what's depicted in those 8 photographs?
Yes.
And what do you recognize those to be?
More photographs of Mr. O'Keefe's vehicle as well as the garage doors.
Madam Mayor, approach.
Yes.
I'll proceed to introduce the next 8 exhibits.
No objection.
Oops. Daniela, today is a full day. Every day we have this week is supposed to be a full day, and tomorrow is our only day off. That's what we've been told of the schedule so far.
It's 5:55. Thank you.
Your Honor, with the court's permission, if I could publish just a few of those to the jury as well.
Okay.
Ms. Gilman, if I could have photograph 7779. And Trooper, do you recognize what's depicted on the screen now as exhibit 559?
Yes.
And if you could describe to the jury what we're looking at in 559.
The rear bumper area of Mr. O'Keefe's vehicle,
That's the driver's side or the passenger side?
the driver's side.
And what, if any, damage did you observe in that area of the vehicle on February 3rd when you were there?
No damage.
With respect, Ms. Gilman, if I could have photograph 7780. That's my answer. And sir, do you recognize what's up on the screen and what's now been marked as exhibit 560?
Yes, those are the two garage doors of Mr. O'Keefe's house.
And what's contained up on that screen, is that a fair and accurate portrayal of what you observed in Mr. O'Keefe's garage doors on February 3rd?
Yes.
And with respect to those garage doors, what, if any, damage did you note or observe on those garage doors at any point when you were there on February?
I did not observe any damage to the garage doors.
Ms. Gilman, you can take that down.
Why would the garage doors be damaged? We didn't see anybody hit a garage door. And they're trying to explain why the door didn't
Trooper
open.
Proctor. Subsequent dates following
didn't
February
close.
3rd, specifically February 8th, 11th, and 18th. Did you have occasion to return to 34 Fairview Road on those days?
I did.
And you had mentioned a little bit about sort of changes in the weather. What, if anything, sort of evolved as far as the weather was concerned between
I already said
the
this.
dates of February 3rd when you were there and February 8th, 11th, and 18th?
Yeah, as I mentioned, the weather pattern had kind of fluctuated from 30 degrees up to 60 degrees with a handful of days of heavy rain mixed in. So that caused a lot of snow to melt as well.
And with respect to each of those respective days of February 8th, 11th, and 18th, what, if anything, did you observe or recover, you and the other troopers that were present on those days?
Yeah, there's further evidence that was originally buried under the snow because of the warm temperature and the rain and the snow melting kind of revealed itself. More pieces of plastic clear and red.
Now, with respect to the residence at 34 Fairview Road, each of these times that you were at the residence, including February 3rd, where in relation to the house were these items observed and recovered by you and the other troopers on those respective days?
So if you're looking at 34 Fairview, looking at the front of the house, it's the left side of the property between like the flagpole and kind of the fire hydrant in that general area, the front and left of the property.
Now, with regard to these three subsequent dates, as far as February 8th, 11th, and 18th, these items that were observed and recovered on those dates, where were they in relation to the roadway? Where were they in relation to the hydrant, the flagpole, other sort of markers in these?
I don't specifically remember exactly if they were around the flagpole because the search team had came and shoveled an area around. So
documented it.
That stuff had melted first because there was a lot less snow, and then they created more piles. But as far as the general area was by the flagpole and fire hydrant, it wasn't like on the other side of the property. It was in that general area.
And just with respect to those items, were they generally found, or were they specifically found either on the grass or the roadway area?
Grass.
Asphalt or grass is basically what
I'm sorry, grass area.
And with regard to each of those items that were recovered on those 3 successive dates, as far as February 8th, 11th, and 18th, did you bring those items with you to court today as well?
I did.
May I approach, Ron?
Yes.
So those taillight pieces flew into the grass. They didn't get buried in a snowbank by the plow, like we saw from the other photos.
You recognize that bag, sir?
I do.
What do you recognize that to be?
It's an evidence bag containing 3 smaller
Put your
evidence
grubby
bags.
hands all over it.
And with the court's permission, if you could.
Hold on a second.
Thank you.
I apologize.
Go ahead.
With the court's permission, may the witness remove the 3 smaller bags from the larger bag?
Yes.
So the photos we saw from CERT had them recovering taillight pieces in the road. And then all these later ones are in the grass. Grass would melt a lot faster than the berm. The berm from the snowplow would melt.
Trooper, if I could just, in succession, if I could ask you to please open the bag with respect to February 8th first. And before you do that, I apologize. With respect to that bag, what, if any, indication is there as to the contents there?
It says taillight, 1 large piece of plastic, color red, 1 small piece of red plastic, and 1 piece of black plastic. Located 34 Fairview Road, front lawn, left side.
Thank you, sir. If you could please remove those.
Use the grubby scissors that have been handled back and forth, not sterilized in between. That would be good. They could have a real Milani Cosmetics moment, couldn't they?
Thank you, sir. You can place those back in the bag. I'm also seeking introducing you as next exhibit. No objection.
Okay.
This is going to take us to lunch, going through the bags.
Sir, if I could ask you just to retrieve the bag that's marked, retrieve the bag of items that were seized on February 11th. And if you could read to the jury what the description is in regard to that evidence bag.
So it's 2 on the 11th. This one is described as glass fragments. You can't tell how many pieces. It's been taped over. The second bag from the 11th says 3 pieces of clear plastic, 5 pieces of red plastic.
And with the court's permission, may the witness remove those items from the bag.
All right.
We're ignoring the glass now. The glass that didn't match. Same gloves, handling all over the other stuff.
Smaller bag in here containing the glass. Cut that open as well.
I think that's sufficient.
All right, so Madam Clerk,
What?
are you moving to introduce it?
Yes.
Madam Court Reporter, any objection? We can go ahead and open.
to object, but I don't know what's about that.
Go ahead and open it.
Yeah,
Yes, Your
open it. I mean, for heaven's sakes, confirm it is what it's supposed to be.
Right. These items appear to be just further on sealed up and wrapped up and
Do you want him to open everyone, Mr. Jackson?
Yes,
Yes.
yes, we do. If we're going through the theater, you need to commit to the role.
All right, so go, Michelle.
I don't need a motion. No objection.
Went ahead and let it go.
How many pieces are in there?
1, 2, 7.
Seven pieces of what? This is not the plastic then. It's supposed to be 8 pieces. 3 pieces clear, 5 pieces red if it's the plastic. The glass I thought was 3.
The smaller bag will be 564. Thank you. The brown bag will be 564. Thank you. Containing 7 pieces.
Trooper, if you could, the other bag from the 11th, if you could open that up and remove those items.
Yeah, I mean, I'm not against them having it in evidence, and they do need to. So this is the plastic. So the other ones were the glass. I don't know. I'm not against them having the plastic. There's been a lot of testimony about the plastic, the reconstruction of the plastic, the individual labels, all that stuff. I'm not against the jury having that to be able to examine it and reconsider all of that stuff themselves. And yeah, you need to identify it if you're going to put it in. So I mean, that's why they're doing it. But yeah, to some extent, it is just kind of look at all this evidence we have. Look at these photographs we took. They're not the ones that matter, but look, we've got them.
Your Honor, Commonwealth seeks to introduce and admit as the next exhibit.
The 565.
Lastly, sir, with regard to the fact from February 18th, again, if you could read to the jury what's indicated.
Was that 3 pieces of clear and 5 pieces of red?
Several pieces of red and clear plastic.
Several
Your Honor, with court
pieces.
permission, may the witness remove
Yes.
the items.
These ones look like they're still taped together. No? Yes? Yeah, they do.
Thank you, sir. If you could turn those items to the back. You're on the Commonwealth of seeking minutes of this exhibit.
No objection.
Exhibit 566.
Here's the original bag.
Now, Trooper, with regard to each of those items from February 8th, 10th, and 11th, excuse me, forgive me, 8th, 11th, and 18th, those are all items that you recovered from the front lawn area of 34 Fairview Road, is that correct?
Correct.
And what was just displayed to the jury is that essentially the condition that they were in when you recovered them on those respective dates.
Yes.
Except for the part
Now,
that they were taped
If I
together.
could turn your attention just briefly regarding the search warrants in regard to the ring video from Mr. O'Keefe's house. Was that one search warrant or more than one search warrant that you did in respect to those ring videos?
There was a second search warrant for the ring videos for Mr. O'Keefe's house.
And if you recall, what was the general time frame that was asked for in that warrant as far as from what date to what date?
The second one, I believe, was January 30th to the 3rd or the 4th, I believe.
Was the first one essentially from the 24th to the 29th?
Yes.
Now, with respect to the video that you received in regard to the first search warrant to ring, what kind of information did you receive from Ring as far as what beyond sort of the video itself? What, if any, other information did you receive as far as accounts or activity or anything like that?
It was just confirming that the user account was under Mr. O'Keefe's email, and then there was an Excel file where you kind of have to transcribe. So that each video has about a 17-digit number associated with it, unique identifier. You take that 17-digit number and you got to convert it using these Excel files to get the date and time.
Now, with respect to what you received pursuant to the search warrant from Ring, was there any kind of activity log? And what I mean by that, what, if any, information did you receive as far as what sort of devices or how many different devices were able to access that footage?
Yeah, I wasn't able to obtain a activity log of who was using the device, what device was accessing the system. Something, if someone logged in, I was not provided with any record of who was logging in on what day or time.
Now, are you familiar with the term, just as far as videos are concerned, or electronic devices, what's referred to as a digital footprint?
Yes.
Now, with respect to some of these, or the Ring videos in totality that you received and that you also viewed pursuant to the app on Mr. O'Keefe's phone, were there certain time periods where you would have expected to see video in which there was no?
Yes.
And can you describe for the jury sort of when those time periods were?
So the Ring camera above Mr. O'Keefe's garage, pretty sensitive, so it does not have
unlike
Miss
your Sally
Reed
port.
arriving back
He's got a better
at
camera
Mr.
than your
O'Keefe's
Sally
house
port.
around 12:34 a.m. is when she should have arrived. The only video, there's a gap from approximately 11:45 p.m. on the 28th to about 5:07 a.m. on the 29th when Miss Reed's backing out. It never has her pulling into the garage. And there's also a second video of Miss Roberts, Miss McCabe, and Miss Reed looking at the broken taillight in the morning.
Oh, there is?
What, if any, follow-up
there's
or
not.
inquiry did you make of Ring in regard to those missing videos?
I inquired several different times as far as if a video is deleted, is there some type of a record?
That was his inquiry, but next question, I'll allow that.
Now, as far as that term that you used before, as far as a digital imprint, can you explain to the jury what you understand that term to mean?
Essentially, a digital footprint is if, a video is created, it's going to leave some type of a record in the archives.
And what, if any, information did you receive from Ring as far as their videos system is concerned? In
Objection,
regards to,
hearsay.
the digital footprint?
Objection.
Not what anybody told you, but what you received.
You wouldn't know it without being told,
That
Bev.
if a video is deleted,
Objection.
The objection sustained.
Move to strike.
We're going to strike that.
Upon your further inquiry of Ring, were you ever able to obtain any video from those specific sections where you anticipated video would be?
no.
It's easy, Lally. Call person from Ring. Call the evidence custodian
Now,
for
sir,
Ring.
if I could turn your attention to
Establish it was deleted. But you can't. you're not
January
going to,
16,
are ya?
2024. Do you recall that date?
I do not, sir.
At some point over the course of your investigation, were you made aware of forensic evidence in relation to the taillight housing that was introduced earlier as an exhibit?
Yes.
And with respect to that, at some point, did you have occasion to meet with a Sergeant Brian Gallerani of the Needham Police Department?
Yes.
And where was that?
In the DA's office.
And who, if anyone else, involved in this investigation, as far as yourself, was Sergeant Bukhenik with you there as well?
Yes.
And what, if anything, did Sergeant Gallerani do with respect to yourself and Sergeant Bukhenik on that date in January of 2024?
Sergeant Bukhenik and I voluntarily provided our DNA for comparison testing.
And again, taking me to my next point, that was a voluntary decision that both you and Sergeant Bukhenik made as far as availing yourself or availing of that particular test.
Correct.
And as far as the testing or this, you know how that was, or can you describe for the jury sort of how that sample was collected or how it was conducted?
Essentially, it's just a swab of the mouth under the tongue with like it's basically just like a little pad on a stick, and you get swabbed, and that's how the DNA or saliva is collected.
And as far as those samples that
Not
were collected
saliva,
from
it's
both
skin
yourself
cells,
and
but
Sergeant Bukhenik on that particular day, where did they go from there as far as you know?
It was my understanding, went to the Bodie lab in Virginia.
And I'm sorry, but I should have asked just prior to that, as far as when they left from the room that you were in with Sergeant Gallerani, did you take those swabs, or did Sergeant Gallerani take those swabs, or where did they go?
Sergeant Gallerani took possession of those items.
Thank you. Now, sir, with reference, over the course of your investigation, you interviewed a number of different witnesses, correct?
Yes.
And from the witnesses that you, were there witness interviews that were conducted outside of your presence in the sense that you weren't there for those particular witness interviews?
Yes.
And each of the interviews that you're aware of, whether they were conducted by you or outside of your presence, were done, with the exception of the current, done with more than one trooper present, correct?
Correct.
Already said that.
Now, with respect to those witness interviews that you were present for, from the witnesses that you spoke with, along with other troopers that were present with you, who, if any, of those witnesses had you met, or were you did you know prior to the interview that you
Who are
conducted?
your BFFs and the witnesses?
Yeah, so all the witnesses that I had interviewed, the only individuals that I know or had met prior to this investigation was Julie, Chris Albert, and Colin Albert.
And how is it that you knew Julie Albert, Christopher Albert, and Colin?
So my sister, Courtney, her friend growing up, Jillian. Jillian's sister's Julie. My sister got to know Julie Albert, Julie Daniels, her maiden name, through her friend Jillian. Julie married Chris Albert. So my sister got to know Chris through Jillian and Julie. And then years down the road, my sister had Julie babysit my nephew. Julie would come from time to time and pick up my nephew from school. So that's how they kind of became friendly. And on occasion, they would be over my sister's house or at my parents' backyard. Julie and Chris and their kid Colin, and I would happen to be there.
Let me ask it this way, as far as, where did you grow up?
Canton.
Mhm.
Did you graduate from Canton High School?
Yes.
And as far as any of the witnesses that you interviewed, even the Alberts that you were just talking about, Christopher, Julie, and Colin Albert, were they around the same ages as you or went to high school with you at the same time?
No.
How much older than you would Julie and Chris Albert?
At least 10 years.
And as far as Colin Albert, what's the age difference between yourself and him?
At least 20.
Fair to say around this time of January 2022, do you know how old Colin was or what level of school he was at that point?
As senior in high school, I believe.
Is that something that you learned through this investigation or something that you knew independently?
Something I learned through this investigation.
Now, obviously you grew up in Canton and your sister did as well?
Yes.
And your sister's name is Courtney, is that correct?
Correct.
And what is the age difference between yourself and your sister Courtney?
She's 2 years older than me.
And how close are you and your sister?
She's probably one of my best friends. We talk about 5-6 times a day about anything and everything, as far as like mostly our children.
And she has, how many children does?
Your cases, her
We got two.
friends.
And about how old are they?
10 and 7.
And you have children as well?
I do.
And how old are they?
2 and 4.
Now, with respect to the conversation that you have with your sister about 5 or 6 times a day, how do you have those conversations? Is it via voice call or in person or text, or if you know?
Everything, FaceTime, phone calls, text messages. We're always kind of keeping each other up to date on mainly our kids.
Mm-hmm.
Now, as far as Julie and Christopher Alberts, when did you interview them in relation to this incident?
Sometime in February. I'd have to look at my report for the exact date.
And they're the
Sometime
only
in,
ones
say,
that got the
early to
special treatment
mid-February?
of both
Yes.
being in the same room.
And with respect to them, who, if anyone else, was present with you when you interviewed?
Sergeant Bukhenik.
And do you recall where the interview took place?
Yes, it was at their home.
Now, prior to this date that you went over to interview Christopher and Julie Albert, had you ever been over to that house before?
No.
Had you ever been over to any home where Christopher and Julie Albert had resided then or previously prior to that date?
No.
Had Christopher or Julie Albert, to your knowledge, ever been over to your house?
No.
Now, with respect to Christopher and Julie Albert, and Colin Albert, will throw him in there as well, how would you sort of describe your relationship with them prior to January 29th, 2022?
I'd classify it as acquaintances.
Mm-hmm. Sure you did.
All right, Mr. Lally, why don't we take our luncheon break?
Well, that's surely going to be a signal that there's some hot tub photos, huh? Are we going to see them all together in a hot tub
You are
in
muted.
some remote location? Yeah, we're going to get to cross today's, guys. It looks like. I mean, he's doing what he can to drag it out, but he's running out of time. Already up to January 24th. He's run through the whole
Thank you,
time
Ron.
frame. And once again, not taking the sting out of any of this stuff we know is coming. Gonna have their quick little consultation there. I don't know if we're doing a half-hour lunch today again, or we're doing the full hour. Maybe she'll tell us when they come back. Yeah, the problem here though is where did Proctor get it? Who did he get it from? I mean, we know he got it. He said in his report, or somebody said in a report, that he got it. He recovered it from the scene. That's the whole problem there. Said he got it from the scene. Now he says he got it from Canton Police Department. Since when is Canton Police Department the scene? She said she handed it, Carrie Roberts said she handed it to a first responder. Which one? Which one? Because that's the one who needed to hand it to Trooper Proctor for us not to have a big old hole in the chain of custody like we have with all this other stuff that so far seems to just be sitting around in this unsecured evidence holding area before being booked into evidence multiple days later, which apparently, according to him, is the fault of the evidence clerk. Mr. DeChico, is he going to appreciate that? Is he going to appreciate that? I wouldn't if I was him. So yeah, who did Carrie Roberts give the phone to? She stuck it in her pocket, according to her, gave it to a first responder. Who? Who? Still doesn't answer the whole question of how big of a problem it is that a civilian on the scene, a witness on the scene, is securing this type of thing, this critical piece of evidence. Why she had it in her hand in the first place is incomprehensible. Why it left the scene is incomprehensible. Should not happen. So who passed it to who, to passed it to who, to passed it to who? That's what we need to know. That's what a chain of custody is. Just waiting here to see if Bev gives us any details about when we'll be coming back. I am parched, guys. I'm going to do something a little bit different today because I need to get a drink like really badly. So once we're off, I'm going to go ahead and run and do my rounds. You guys know the routine. Gotta check on everybody. I gotta let the chickens out now. I didn't let them out at 4 a.m. when I got up. So they're sitting there in their house wanting to get out. And then I'll come back, hopefully before things are getting too underway with, before they're back in session. And then we can go back over some more of the chats again. If you want to see the chickens, they're up on my Instagram. Put them in my stories. We had a nice weekend, a great weekend. Grandma came over for dinner yesterday, along with my aunt and my cousin. So we made them a big, nice meal. We're starting to get all kinds of good stuff out of the garden, right? It's that peak season. We got lettuce, we got radishes, we got early carrots, we got peas, we got all kinds of green onions, basil, all kinds of delicious stuff. So all went into a very nice meal, and all those little extras. If you haven't grown your own food, you might not appreciate how much processing goes into food to make it pretty by the time it gets to the supermarket. Especially lettuce, guys. I got to tell you, if you're squeamish about bugs, you don't want to be growing lettuce. You don't want to be growing lettuce. I just have a constant feed in my mind of Troy McClure going earwigs. Ew. Yeah, that's your lettuce for you. Unless you want to go like full chemical holocaust, right? And kill off anything that touches them. That is an option to keep the bugs out of your lettuce, but otherwise they're pretty gross. So anyway, a lot of processing, trimming, cleaning, washing, all that extra stuff that goes to the chickens. It's a great little arrangement. Mad World loves how we call Americans, we call basil. Basil. We're supposed to call it basil. Basil, that's how Gordon Ramsay pronounces it. Some nice fresh basil. Yeah. It all tastes the same. It's wonderful stuff. Yeah, you pretty much, this is not a bad idea. That's what I usually do. I mean, there's several stages of washing this stuff. Okay, guys, I cut it, I trim it, I shake it. I shake it. You can get a good shower of earwigs by shaking it. But I guarantee you there's still some hanging in there. So then what I typically do, I stick it in a bucket, like a 5-gallon bucket, fill it up with water, dunk it, soak it, try to get some more of those out. Bring it inside, start to prep it for whatever I'm going to eat it with, cut the stem off. And they're not even going to tell us how long the break is. Wash it while you're trimming it and, spin it, all that stuff. Yeah. Many, many, many stages. Cause I don't want earwigs in my salad. Okay. I appreciate they're in the lettuce. I don't want them making it into my mouth. So yeah. Yeah. Growing your own food is not for the faint of heart. You better be okay with those bugs. So guys, I'm just going to go ahead and share this with you while I am taking my little break here. That's what's going on in the background. When you hear the snoring, that's what it is. So I'm just going to go ahead and let you guys watch that while I go ahead and dip for a little bit, get my drink, check the chickens, and I will be back as soon as I can. All right, guys, I'm back trying not to jump scare with that whole sudden coming back to life. Everything is good here. We're just realized I didn't change my banner. We're on the break right now. So chickens are all good, trees are all good. Got myself a little snack. Oh God, and I didn't get my tea. Hang on, right back. Okay, got my tea. Now all is right with the world. Life and brain power will come flooding back. Well, boy, what a morning it's been. What an exciting morning it's been. A Trooper Bukhenik cross and Trooper Proctor direct. We are going to get to this cross, guys. It's coming. It's coming. And still, again, I'm just dumbfounded by this Lally strategy of, I know all of this bad stuff is coming, and I'm just not going to address it at all. I'm just going to leave it entirely in the hands of the defense. They told you in opening. We're going to be talking about his text messages to his buddies about looking for her nudes on her phone. Okay, you didn't think that maybe you should elicit the explanation for that now instead of just handing that as a cudgel to the defense to batter him with? Guess not. Guess not. Gonna let him cope with all that on his own. Well, let's go ahead and get back caught up with some of our chats here. See where we're at. Cargo pilot guy. Judges like Beverly Cannoni belong in prison. No comment. Jason Sorensen. Why do you want an IDI over a 12-valve Cummins? Cummins are way easier to work on. I say this as a Ford guy. I would like to at some point. I'm interested in the whole mechanical timing. Like, that's just what fascinates me about that particular engine. I know that, I don't know if it was Cummins, but I know that there is a Dodge engine as well that, is a mechanically timed engine. Like, obviously they had diesels, before there were computer chips and stuff. It's just the IDI is the one I've heard of, and it's similar enough to the one I do know, the regular direct injection 7.3. So that's the piece that I'm interested in. That's why I'd like that one. But I wouldn't say no to a Cummins if you happen to have one. Time wrong on video from Mike. Proctor, enough time to plant? Yeah, that's the $1 million question, right? If so number one, if the time isn't right on the video, the timestamp on the Sallyport video, that's their documentation of the time that they arrived, right? So if that's not right, that's not reliable, then we are back now into having the open question of whether Proctor could have made it to 34 Fairview to plant taillight pieces before the CERT team got there to conduct their search. The other piece of this too is what if we're seeing on video is not the moment that the car arrived? The car, was potentially already there, dropped off outside. I mean, something like that. That's possible too. And that's where I think getting it straight from the tow truck driver is really going to be the best course of action at this point, because he's the one that's got no skin in the game. He's got no interest in any of it. So I'm going to be very interested to see what he has to say. AKA the cat lady. Microdots just confirmed on Twitter that the video is not motion activated. They were hired by the defense for AV stuff. Interesting. Interesting. Well, that's the thing. We know the defense has all of these experts. They have their own digital forensics people. So yeah, I would think they're going to be able to look at this, make that kind of determination. Very strange to me anyway, that you would have a motion activated camera in something like a Sally port, something, on police property. What, someone can't like sneak in and lie in wait in there and it wouldn't be on camera? You wouldn't want to know that? I don't know. Seems a bit strange to me, but yeah, I wouldn't be surprised at all if the defense is prepared to counter that. Dr. Hines is here. Hey, Hines. Thanks so much for stopping by. Tin Cat, masterfully done by AJ. Get the witness to double down on it's accurate despite being mirrored, and then follow it up directly with the timing issues. Yeah, that was really good. I mean, he's just really hammering home that when Trooper Bukhenik says something is accurate, you can't trust it. It's not reliable. His judgment on what is accurate, it doesn't fit with, I think, what most people would consider accurate. He's not going to commit to it's an accurate depiction, an accurate representation of the actual Sally port, right? So then he's trying to backpedal. Well, it's a true and accurate depiction of the events. Well, no, it's not. It's missing all the time. It's not even close to a true and accurate depiction of the events because the events included approximately 12 minutes of the entire 18-minute video that's not on there. So it's a true and accurate, maybe, depiction of less than half of what happened during that time frame. And no, he did not clarify that, did he? Dr. Hines, thank you so much. Good to see you here. Glad to have you in the crew. And Cap Mayer, Fog in the Sally Port sounds like a Stephen King novel. Yeah, it does. I mean, I still have visions of the David Copperfield show, right? Where we're on the stage in Vegas and poof, the big cloud of smoke, and then something mysteriously materializes on the stage. That's what it sounds like to me. I mean, I do think he's trying to magically conjure up an explanation for how bad this video is, but I don't think he has reached the David Copperfield level of illusion, of being able to actually convince us of that. Track worker, Bev's afraid of the huge mess of litigation coming. I mean, I don't know what's coming. I really don't. I mean, I've said before, for somebody to be able to sue law enforcement for wrongful prosecution, malicious prosecution, stuff like that, it's just the bar is so high. It's so extremely difficult. The officers themselves have, qualified immunity that extends to anything, any fact scenario, pretty much, that hasn't specifically already happened somewhere in this circuit, where a court has issued a published opinion saying, yeah, that violates somebody's constitutional rights. Absent that, then the officers get qualified immunity. They're not personally on the hook. But there is potential for liability, at least in theory. Canton Police Department, Massachusetts State Police, not the prosecutor. Prosecutors have absolute immunity for their charging decisions. So, yeah. I can't say there's no litigation coming. I certainly wouldn't blame her for trying, but it's definitely an uphill battle. I'm not so sure that's what Bev is really focused on here. I think she's concerned about those feds, if anything. Those feds. That's the thing to be concerned about. Arla 7247. Question for Sally Port surveillance. Security, how can you tell anything if disappearing people in inverted film is normal? Why bother having a system? Can a case be called for obvious bias? I mean, yeah, that's the $1 million question. Why would you have the system if it's not in fact accurate and it jumps around while people are clearly in there moving about doing their business? Why would you have this system? Why would a police department have this system? So bizarre to me that they're trying to say John O'Keefe's Ring camera is better than your police system that you probably got, some kind of grant funding for. You get all kinds of money going to police for equipment and security and upgrades and so on and so forth. Meanwhile, this rank and file Boston police officer with his regular everyday commercial camera surveillance system that, every civilian who wants one can go get, that's better than what the police have. Yeah, call me skeptical. Call me skeptical of that. Noodle JB, thank you, Andrea, for the early morning and best coverage on any media platform forum coming from the UK, Great Britain. Thank you so much. Really appreciate that. I'm happy to be here. I mean, like I said, I'm on the edge of my seat. I got sucked into this. I'm going to be watching it anyway. I think it's awesome that so many of you are here watching it with me. There was a comment at the end of Thursday that I caught because I was, kind of complaining a little bit about the early start here. A comment saying, Andrea, it's your own stream. You can start whenever you want. I know I could, but I like watching things live. Okay. I want to be here live. I don't want to be getting caught up, after the fact. I want to see it happen when it happens. So I'm committed to this whole, we're going to watch it. We're going to watch it while it's going down. We Heart Entertainment. KR also had the heat running, so snow fell. Yeah, this is a great point. That whole contrast they're trying to draw between when they slammed Karen's door in the Sally Port and some snow fell off of the bottom of her window there, the top of the door. I don't know what word I'm looking for there, but just the metal part of the door. As opposed to John's car that's out in the snow, super cold. Yeah, I mean, maybe the heat was on. I don't know. The heat's on in the Sally Port for sure. Definitely a possible explanation there. Mike and Odie with just the chat. Thank you so much. Appreciate your support. Stephanie L. Question, please let us know what happened with this morning's early prosecution motion to exclude defense experts. So the sound cut out at the very end of the hearing, and there was Lally responded. We don't know what he said. We don't know what Bev said in response to that either. I haven't checked the internet to see if anybody who was present in the courtroom has been able to fill us in on what was said during that sound gap. I mean, it sounded like somebody stepped on the cable or something like that, pulled out the connection. But what we were getting up to that point was that judge was not granting the motion. She is requiring that these witnesses be brought in to be voir dired by the Commonwealth, and that it's going to happen this week. She said specifically Wednesday, but then when she's talking to the jury, she wasn't specific about the timing. So don't know if it's going to be Wednesday. Don't know exactly what day it's going to be, but that looks like from what we saw how it's going to be resolved. So the thing that really just jumped out to me when she's making this ruling was thinking to myself, boy, imagine Karen Reed had a public defender and didn't have these attorneys with their extra resources, their investigators, their full staff of people back in the office who can be taking the lead on doing this coordination, other attorneys who are able to work on the case. The lone public defender going to have to go coordinate all these witnesses getting there on 2 days' notice. Yeah, we'd be seeing a little bit of a different situation there. So Kyle Cowden, on staff, I pulled audio and video files. I had standing orders to pull all agencies' data as well. Too many files had come up missing or corrupted. I don't know if this is referring to law enforcement, but yeah, I mean, very, very common to need to pull audio and video files. And yeah, they do come up corrupted all the time. It's one of the big complaints that I had, as the defense attorney, when I get discovery, you get all of this stuff and it's corrupted. This came up in Koberger as well in one of the last hearings, because some of the data files that were related to the work that the state's witnesses did on trying to reconstruct his location from the cell site information that they got, a whole bunch of it they didn't save at all, but then there were some other files that got produced and they can't be opened. They're corrupted files. So it's very common. This type of thing happens all the time. Nobody really seems that interested in fixing the problem so that I, the defense attorney, can get good and accurate information. That doesn't seem to be a real high priority for the folks who are responsible for funding those types of things, improving the equipment and the training for being able to do this type of stuff and so forth. American Dreamer, I'm still confused as to how they know she hit him from behind. Never looked at the front of her car, no witnesses. Well, if we are to take it from what's already known, what's already in the record, we would assume that Jen McCabe told them she had the broken rear tail light, right? Because they made a whole big thing about that. They tried to make such a big thing out of it that Matt McCabe testified he was concerned about them going out driving in the snow in Karen's car because of that broken tail light. No concern about all the people driving around drunk that night before, but the broken tail light, that's really the straw that breaks the camel's back. That's why they had to leave her car and take Jen's car. So, I mean, that's the best explanation I have. I mean, that's how they knew all this stuff, right? We already know he's basically laid out for us. They went and talked to the McCabes, and at that point, they, according to them, knew what was going on. They didn't even need to go to the scene to check it out. They didn't need to talk to any of the eyewitnesses. They just already decided at that point, great, now it's time to go seize Karen's car and her phone and go up there and conduct this fact-finding interview. That they already knew beforehand that they were going to do all that stuff. That's what came out from Officer Barrows. 2:30 from the DA's office, he gets the call to get the plow and the tow ready. So the idea that they were going back up there to just see what unfolded, see if they were going to develop probable cause to do this stuff. They had already made up their minds, and they had made up their minds based on what Jen McCabe, Matt McCabe, and Brian Albert had told them, and that they apparently, took on face value. Desert Cat officer exploded the exploding taillight theory. I mean, it has to be an exploding taillight, right, for this to work, because it's all over the grass, it's all over the road. And there's no indication, no evidence of the car going up on the grass. There's no tracks, there's no ruts, there's nothing like that. I'm not going to buy that this big heavy SUV, I don't know how much it weighs, but it's well over a ton, okay, is ending up on the yard that's wet, okay? It's wet. It's saturated with the snow stuff before it starts to stick. And not leave any kind of mark, no mark, nothing. No, I'm not buying that at all. So it didn't go on the grass. If it didn't go on the grass, then the only way for the taillight to end up on the grass, yeah, it exploded. It blasted from the point of impact all over the back of the yard. Not sure I'm going to buy that. Going to need to see a physical explanation of how that could have worked. Steve F. I'm getting the sensation that Yuriy Bukhenik, attended the Yuri Andropov Institute for Evidence Handling and Desinformatia. Yeah, could be. Just so unconcerned with the substance of the truth, just the technical, how do I navigate this so that I'm not technically lying, right? You know how somebody knows how to avoid a perjury trap? Yeah, I bet they conduct a lot of them. Somebody who conducts a lot of perjury traps is going to know how to avoid them. They're going to know how to navigate those questions to get the technically correct answer that is still substantively misleading. And don't know about you guys, but that's what I saw consistently throughout his testimony. And Cap Mayer, my dad worked in federal law enforcement and told me they avoided hiring local cops, called them badge heavy. Even the feds don't like these guys. There's so many politics in law enforcement, and yeah, just the departmental politics that get involved, the hierarchies that get involved, the pulling rank, the not communicating with each other, all kinds of this stuff happens all the time. So it would not surprise me at all if, the feds prefer people that go straight into federal law enforcement and not lateral in from a local department. Lateraling is pretty common in law enforcement. You just, you start somewhere you can get a job and you get some experience, and then, transfer to a different department. But I have to say, yeah, can't think offhand of a lot of feds that I remember ever cross-examining or interviewing or anything like that lateraled out of local. It's very common to have a military to federal law enforcement pathway. But yeah, can't say I remember offhand a lot of local to fed. Greg, Lally was in full Elaine mode. He had no clue how to say Bukhenik's cross. Yeah, he really was. When she wasn't going to give him that question, I don't even remember what it was now. I think I wrote it in my notes. She wasn't going to give him that question about John's car. Was it about John's car? I don't know. I don't remember. He's trying to I think he was trying to get in about how, John's car wasn't damaged and she wasn't letting it. He couldn't figure out how to get there. He's just sitting there. You could practically hear the creaking of the gears and smell a little bit of that burning of that oil, just grinding away, trying to find a way to get that question out. Couldn't get it, but he sure was trying. He was trying, really trying. Thomas with a $2 super chat. Thank you so much. Appreciate your support. Sentient Dreamer, watched the Young Jerks last night. Eyewitness to jury's reaction when AJ pointed out the inverted vid was shock-gasp. Jury had strong reaction to info. Well, yeah. I mean, it doesn't surprise me because why weren't you told? I mean, it's such an own goal. That is such an own goal. If you weren't actually trying to be deceptive and hoping that nobody would catch you out, why wouldn't you make it crystal clear what this is that you're looking at? You're supposed to be helping the jury. You know what this reminds me of? It reminds me of that distinction when you're talking to somebody and there is talking to clarify and talking to obfuscate. And you kind of get a sense of what somebody's motives and intentions are in a conversation based on, are they trying to help you understand, or does it seem like they're using a lot of big words and complicated concepts and weird leaps of logic and things like that to just try to create more confusion? And when I look at the way that the Commonwealth chose to handle this particular video, sure doesn't look to me like this is something they put out there in an effort to assist the jury in understanding, because if they were, you would have told them what it is that they were looking at very, very clearly, so that while they are looking at it, they understand, they know what to pay attention to. They're on the same page. Everybody is on the same page as we're evaluating this evidence. So yeah, I would imagine that the jury would be slack-jawed by this, that they were so misled by this particular piece of evidence. Yeah. It really is quite shocking. And again, it's just a total own goal. If that was not, in fact, what they were trying to do, deceive, major own goal. And so it, makes you wonder, was that in fact what they were trying to do at all? Greg Jackson, at any point, did you find any nudes on my client's phone, Proctor? No, I wish I had. Yeah. I mean, Lally could have asked him that, right? Want to take out the sting? Just go ahead and get it out there. We know it's coming. I think Jackson is gonna work him over a little bit first, try to get him a little uncomfortable before he comes in and hits him with these texts. We already know Trooper Proctor is gonna say all this is a joke, right? It's just a joke. This is just humor. This is just buddies. Uh-huh. Uh-huh. And the sense of humor is probably about as good as a sense of accuracy. I pulled this one up, Loquaria. It's funny, I was expecting monster level from this guy. In reality, he's more of a meth. The reason why I pulled this up is because as soon as I saw this, I thought, oop, the banality of evil, banality of evil, Hannah Arendt, very famous work on the trial of Adolf Eichmann in Nuremberg. After the Nazi regime, Adolf Eichmann was like the brainchild of the final solution. She was fully prepared for him to just be this monstrous, horrible, evil person. And what she found instead was sort of a petty little bureaucrat, somebody who was just drunk on his own ability to use rules, and procedures and things like that to carry out what ultimately ended up being a major atrocity in world history. And yeah, I think this is pretty common. I mean, I've said before, I've represented thousands of people. I mean, some very guilty people, some people who have done some very horrible things. And the actual number of them that I could point at and say, okay, you seem like a monster in human skin, less than one hand. I mean, less than one hand. There just are not that many monsters out there among us. Most of us are just people who are twisted, people who will, they're just very skilled at denial and, making self-serving types of justifications for things. They have bad impulses. They want to do what they want to do, and then they want to, justify it after the fact, and they'll lie and they'll make excuses and all of this type of thing. But it's really not monstrous stuff. It's pretty pathetic stuff, honestly, because most of the time it's dumb. It's just dumb. It's not a good explanation. It's not a good excuse. And if you had the insight and just the ability to self-reflect on some of this stuff, like if you could put yourself in somebody else's shoes, you would understand this is not a good explanation. I'll never forget this guy. He's caught on video doing the crime. Caught on video. He's right there. It's like a shoplifting thing. And they have the camera at the store. Here's the guy, and here's what he's doing with the stuff. And I remember sitting in the jail watching this video with this guy right there in Discovery. He's insisting, it's not me. Look at that. That doesn't even look like me. Well, I'm looking at it, dude, and it's you. Okay. You got the tattoos there. You got, the build, the frame, everything. It's you, dude. That's how the jury is going to see it. So that's what a lot of it is just people who will push the boundaries to see what they can get away with as far as the gaslighting, the denial, the bad excuses, et cetera, the blaming other people, also very common. Typically more pathetic than evil. Zencat. Proctor is involved with another high-profile case, the Anna Walsh murder that hasn't yet gone to trial. Commonwealth can't have him go down in flames here today. Well, this is quite a gamble that they're taking then, isn't it? Because he might go down in flames. He might go down in flames. We don't know. I mean, we certainly know there's bad stuff coming. Don't know how bad it's going to get. But if proof of dishonesty by Trooper Proctor comes out here, that's going to be Brady stuff. That's going to be Brady stuff for this other case. Going to have to be disclosed, going to come up as a basis to challenge pretty much anything he did, any of his reliability. So I got to assume this is a measured decision by the Commonwealth because of the discovery process, right? They should know the same stuff that the defense knows when it comes to Trooper Proctor. And so they've decided that whatever damage the defense is going to be able to do here, It's not going to be lethal. It's not going to completely take him out of commission. So we'll see. It's a gamble. Kyle Cowden, dozens of MPA's motor vehicle, like pedestrian accidents, only saw shoes come off at highway speed. I don't know what the hell he saw, and I don't know why it matters. I mean, is he saying shoes never come off under other circumstances? There's no other explanation for why the guy would have one shoe. I got an explanation. They beat him up. And, for some reason needed to take off his shoe and clean it. Maybe his shoes were already off. Maybe they had like stripped down for a fight and couldn't find the other shoe. Maybe the shoe had blood on it. Something like that needed to be cleaned before it could be placed back in the gutter there. These are possible explanations for why a person would only have one shoe. It is ridiculous that the only way a person could have one shoe is because they were hit by a car. That's just silly. Charles Argo. Sergeant Mechanic said the clothes were at the foot of the bed, not stacked in the corner, watching from South Africa. Yeah, I think he did. I mean, they're on the floor, they're on the floor where they don't belong, all mixed up together. Whatever type of evidence integrity you're supposed to have just isn't great. And now we combine that with apparently all this stuff is just left unsecured in the temporary evidence holding part of the police station. Well, who knows who is going in and out, and what are they doing with it? Looks like we're back, guys. I'll go ahead and get us up here. Get her off mute.
What's back in session? You may be seated.
Bring the witness in, please.
Be mindful to step up and just remember what's going on.
Just spilled my tea, of course.
So, jurors, before we begin, Mr. Lally, as you approach the podium there, when I tell you that I strike something from the record, I know I've told you before, that means you're not to consider it. Okay?
Great point.
Go ahead, Mr. Lally.
Thank you. Good afternoon, sir.
Good afternoon, sir.
So, with reference to, I believe before we broke, we were talking a bit about Julie Albert and Christopher Albert, correct?
Yes.
And how would you describe
acquaintances,
your relationship, if any, between Julie Albert and Christopher Albert prior to January 29, 2022?
We already know they were acquaintances.
Loose acquaintances.
People that you knew through your sister, is that correct?
Correct.
Now, with reference to the occasions that you had said where you may have been at the same place at the same time at a family function or something like that, over what period of time are we talking about, and about how many different instances of that occurred over those years?
Like I had mentioned, they had never been at my house. So it was either at my sister's home or at my parents' house. Over the course of maybe 10 years, I might have been at the same function half a dozen times.
And at those times,
So you've done
you
them
were at
quite
the
a
same
long time
function
then,
half a dozen
in the
times or
same
so.
circles.
How much interaction would you have with either Christopher Albert or Julie Albert, or even Colin Albert at those functions?
Just casual conversation, be cordial, and just typical conversations. Hi, how's it going? Things of that nature.
Mm-hmm. How's the weather?
Now, with reference to these experiences or relationships, or lack thereof, that you had with Christopher and Julie Albert, what, if any, conversations did you have with your supervisors, as far as superior officers in your unit, in regard to
I explained the connection or with my sister
Exactly.
to the Albert family.
And who did you explain that to?
That would be Sergeant Bukhenik, Lieutenant Fanning, and Detective Lieutenant Tully.
All right, Trooper, I'm going to ask you to keep your voice up, maybe approach the microphone a little closer.
And just with respect to those disclosures, what specifically did you
They
tell?
all said it was
Sergeant Bukhenik,
okay
Lieutenant,
because it's a group
Fanning, or
thing.
Lieutenant Tully?
Basically, that the Alberts are my sister's friends. That I've been at some functions with them, and the only kind of connection with the Albert family is through my sister.
And just when you say the Alberts, as far as who specifically within the Alberts are you talking about that had a friendship with your sister?
Can you say for the 8th time it was
Chris,
Julie and
their
Chris?
son Colin.
Now, with regard
Because time
to
is real short here.
The investigation that you were conducting and the interviews that you conducted, what, if any, impact did those relationships have with regard to your interviews of them specifically or the investigation in total?
Not self-serving at all.
Yeah, absolutely zero impact on this investigation.
Absolutely zero.
Your Honor, may I approach?
Well, now we know it was a lot. Just signpost for us that it had a massive effect on the investigation. Sure, this is going to be a super duper important, meaningful exhibit here since we're getting to it after the substance of the investigation has already been covered.
Sir, I'm showing you a document. Do you recognize that?
Yes.
And what do you recognize it to be?
It's a text message thread labeled Proctor Friends.
Now, over the course of your investigation, over the course of this case, are you aware that there were iCloud data that was obtained from your personal cell phone?
Yes.
And different text strings
that voluntarily?
from that iCloud data from your personal cell phone, correct?
Correct.
And with respect to what has just been placed before you, is that an excerpt or a piece from those particular messages?
It is.
And from the front page of that, can you tell the jury who are sort of the participants in this particular text communication?
There's several numbers that aren't identified. The three that are under kind of nicknames me and my buddies have for each other.
And generally speaking, just as far as the participants in this text communication, who are these people to you and how do you know them? How long have you known them? Who are they?
The members on this text thread are close friends from junior high, first grade even.
So people you've known for years, is that correct?
Correct.
And do each of them live, or do any of them live within the general area at this time?
Some of them do, yes.
And so when some of them do, some of them do not, is that correct?
Correct.
And the ones that do not, how far away do they live?
As far away as Tennessee.
And how many of them are
Now,
mutual friends with Alberts
With
or
reference
McCabes?
to this, there's an indication as far as the first message sent or last message sent from this particular text chain, correct?
I'm sorry, repeat the question, please.
Sure. Sort of towards the middle of the first page. Help direct your attention to that area. Is there any indication as far as the first message sent and the last message sent with respect to this text chain?
On the first page, yes.
And what is indicated as far as the first message and the last message?
The first message is, I need to brandish a gun more often. The last is Chip, name of that BPD cop.
No, I'm sorry, sir. If I could direct your attention to the first page in this packet, page 2527, you see conversation details.
Look at how red he is.
Sorry, may I approach?
Yes.
So if I could direct your attention to the right.
Okay,
You see what I was talking about now?
I do, sir.
And from that area labeled
Yeah.
conversation details, there's a first message sent,
Thank-
date and time, and a last message sent, date and time, correct?
Yes.
What is the first message sent, date and time?
It's 10/18 of 2021 at 8:48 a.m. The last message sent is 8/31, 2022 at 11:19 p.m.
And is there also within that conversation details an indication as far as number of messages over that time frame within this communication?
There is.
And what does it list for number of messages?
It's 38,707.
And fair to say the packet that you have before you does not contain all 38,707 messages, correct?
That's correct.
The first message that you had, I believe, alluded to in reference to the first one listed within this communication. What date and time is that?
That was January 29th, 2022 at 10:36 p.m.
And who is that message from?
My friend who lives in Tennessee.
And what if
Brandishing
anything did
guy?
you send to the group?
I need to brandish a gun more often.
And if you know, what is that in reference to?
He just recently moved to Tennessee, and he was kind of, I think, making a joke as kind of the lifestyle down there where guns are more prominent or more common to be carried around there. So I interpreted that as a joke in that nature.
Mhm.
And the next
Here
message,
we
sir,
go.
from that same page, 2527.
The next one is it's bold.
And is there a name associated with that number that's in these?
No,
Do you know who that person is?
I don't.
And the next message, sir, from 10:52 p.m.
Chip, name of that BPD cop.
And Chip, who is that referring to, sir?
That is one of my nicknames I've had since maybe high school.
So a nickname that would be familiar amongst these group of friends in particular?
Yes.
And this time period when these text messages begin, sometime after 10:30 or 10:50 p.m. on January 29th, where are you and what are you doing in reference around that time period?
At this point in time, on the 29th, I'm home.
And that last text message, do you respond to that at approximately 10:53 p.m.?
Yes.
And what was your response?
John O'Keefe.
And the next message down from there, also at 10:53 p.m.?
Yes. He took custody of his sister's kids.
That's your response. There's another response above that, is that correct?
Yes.
And what does that say?
How old?
And you respond as far as he took custody of his sister's kids, correct?
Correct.
Skipping down a couple, do you see an entry at 10:53:49 p.m.?
Yes.
And that's from a 617 number, is that correct?
Correct.
And what is the response there?
Oh man, that's rough.
And following that, do you respond to the earlier query as far as age?
I do.
And what did you say?
Mid-40s.
Now, the next message below that, as far as indication of mid-40s, what is that?
His age.
No, I understand that. I'm sorry. The next message underneath that, sir.
I'm sorry. It's a Facebook link.
And do you recall what that Facebook link is to?
It's to John O'Keefe.
And is that something you sent or one of your friends sent?
One of my friends sent.
And the next message below, turning to now page 2529 at the top there. What is the next message that's sent?
What's that? Don't have the book anymore.
And as far as the book, what did you understand that to mean?
Maybe approach.
Sure.
They're reading through the whole thing and it's not in evidence yet. Get it in evidence, then go ahead and read them all. I mean, just more of Bev with the double standards here. Letting the Commonwealth get away with this stuff. This is a classic Lally strategy, isn't it? It's bad, so make it as boring as possible. Bury the bad stuff in the boring tones, hoping the jury is sitting over there with their full stomachs from lunch, getting into a little doze. No, they're not. They know what's coming. They know what's coming. Why? Because Mr. Yannetti told them in opening, and I gotta say, so far, Mr. Yannetti has delivered on quite a few of his promises. Gotta think the jury's watching this. Absolutely not appropriate. There's a whole reason why they have these public records exemptions for pending investigations, because this information is not public. Releasing it can potentially jeopardize the investigation. So no, this is not typical. Not uncommon to talk about things in hindsight. Probably cops more than lawyers. Lawyers, you know, we have the confidentiality stuff. We have the secrets we have to protect. Washington, the standard is client secrets. It's broader than just, you know, communications and work product and stuff like that. Client secrets. So you get used to keeping things, you know, pretty tightly zipped. That said, after the fact, and frankly, even ongoing, you can typically talk about stuff that's in the public record. But talking about anything that isn't public at this point with your good buddies, no, very, very, very inappropriate. Very inappropriate. So we know that Trooper Proctor is under the internal investigation, the IA investigation for violation of procedure. We know that because that came out during the motion in limine. It was one of the things that was discussed as far as whether they're going to be able to go into that or not. Don't know exactly what the violation would be, but that would be a candidate, wouldn't it? That would be a candidate chatting about private
10-minute break.
information. Okay. Now we got to take another break. I'm thinking either he cherry picked out some of the texts, like this is not going to be a comprehensive listing here, and there's more that Mr. Jackson wants in, or, I mean, this is more than just to get it into evidence, right, before you read from it.
So do you have that copy for me?
I do.
So they got another copy. He's going to have to take 10 minutes to look at both copies. Yeah, that makes it sound like there's been some shenanigans with the Commonwealth's copy. What they're having him look at, there's messages in the defense version that aren't in the Commonwealth's version. Not sure what it sounds like. Guess we'll see when we get back. We had another break. Might as well get the jury a chance to stretch their legs, you know, get them nice and attentive for when we get back to hear about this little conversation he was having with his buddies. Chip. What does Chip mean as a nickname? I don't know. Isn't that I mean, when I think Chip, I think of chips. I think of the California Highway Patrol, right? That's why they got that name. That's why they had that show, the Chips. Was he one of these guys that was always going to be a cop? He was always going to be Chip? I don't know. Just wondering. Don't know where that name comes from. Well, let's see what some of your comments are while we're waiting here. Rainman YYC, yeah, taillights don't break like that without help from a baseball bat or a PR24. I mean, I've broken taillight, guys. Put it up on my Twitter even. I went ahead and fully disclosed, yes, I was a bad driver. I backed into my husband's car and broke my taillight. Kind of a little bit like Karen's, right? A little bit like Karen's. Just broke out a little piece of it, didn't shatter the entire thing. Husband's truck, completely unmarked. Completely unmarked. No damage to it whatsoever. It looks like it would be pretty difficult for a taillight to just completely break like that. Just because of the size you're talking about. I mean, how do you have an impact that's going to distribute like that? That's why we got accident reconstruction people coming. But yes, it does. It does look a bit like overkill, doesn't it? Mad World, Andrea's sarcasm is on course today. Well, they're just giving me too much to work with here. I mean, for heaven's sakes, how dumb do you think I am? They really think we're stupid, people. They think we're stupid. They think we're stupid, or that we won't have the courage to say, I see what I see with my own eyes, and you're not going to gaslight me. That's what these people depend on. Lugmeister, same Proctor as from the movie Police Academy. God, I'm going to have to go back and watch Police Academy again. It's been years. It's been years. I don't remember a Proctor. Now I'm going to have to go see so I can get that reference. Kai San, what you think KR is thinking about during trial? She's going to be attentive to what's going on. I'm sure there's a lot of just like, I can't believe this. You know, I can't believe this. I can't believe that they're saying this. I can't believe we're having to go through this. I mean, mostly I think she is probably really focused on what's happening. We see her interacting a lot with her attorneys. Very common. You know, you hear something, you catch something. They weren't there. They aren't necessarily going to know the details of what's potentially available to challenge that witness on a certain point. So you kind of depend on the client to call things out. Like if, hey, there's a text message from later on that would contradict that. Or, hey, somebody else said, you know, something like this, or, hey, that's not what she said the first time. You would hope that the attorneys would have a lot of this stuff, you know, in their heads because it's in discovery, right? That they would have the evidence for all that already, but they're not necessarily going to have it bookmarked in their minds quite like the defendant who has lived through it. So I would expect, yeah, she's paying very close attention to what's happening so that if she catches stuff, I mean, the Massachusetts State Police aren't the only people who can act like a team. Gather their information as a team, make decisions as a team. So I'd suspect that's probably what she's mostly thinking about, and probably sprinkled with a hefty dose of, I hate this guy, Lally. He's so awful. He's so awful. Why is he doing this? Why is he behaving like this? Duncan, Idaho, super behind, but I just want to say how much I admire the defense team's zeal, and especially Yannetti, not backing down, not being cowed by the judge. Pretty cool to see. Yeah, I agree. I like Yannetti. I really like this guy as a lawyer. He's a brawler, man. He's a go-getter. Like he's not taking any crap. He's going to make his record if he needs to make his record. And he's not going to, you know, tiptoe around the proprieties, the niceties, we shouldn't call people out on their bad stuff or whatever because of, you know, the collegiality, you know, that line that people like to draw when they don't want their bad behavior to be used against them. You know, they can use your bad behavior against you, of course, and that's just the justice process. But you try to do that back, somehow you're being uncollegial and you're just performing for the cameras. Yeah, I like it. He doesn't hold his punches. He comes out. He has gotten himself in trouble with that. You know, he is so willing to tangle that he has gotten himself in trouble. I think he did get himself in a little bit of trouble at the end of that testimony, that cross-examination of Matt McCabe. He just asked the one question too many, you know, the whole, what was this text about? Who was this about? Who was the they? because he's trying to imply that the group text message tell them that the guy never came in the house. Who was them? David Yannetti really wanted the jury to think it was the police, and just asking that question gave Matt McCabe the opportunity to say it was Channel 5 News. It wasn't the police; it was Channel 5 News. Kind of took the wind out of Yannetti's sails a little bit. It caught him. It caught him. It was the question too far, but that's because he's in there being aggressive. He's letting his hands go. He's not gonna give up and back away when he has a point that he wants to make. So I agree. I really like him as an attorney. I would hire him if I was in trouble over there, no question. Britt Cormier, let's make sure we are on the same page. Let me make sure we are on the same page. We are pressed for time to voir dire an expert, but we have all the time in the world to open up evidence bags that have plastic in them. How do these bag openings help anyone? Well, so they have to open the bag to identify that what is in the bag is what is supposed to be in the bag, namely all these pieces of black plastic that it says. Could it be stipulated to? Yes. And it looks like ultimately quite a bit of it was. But, no indication to me that the prosecutor asked for a stipulation on this. I'm sure if he had said ahead of time, I want to put all this stuff into evidence, you mind going and checking it out, that wouldn't have been a problem. But that's not how the case is going. So this particular one, I don't necessarily have a huge issue with. If they want the plastic in evidence, they're entitled to get the plastic in evidence, and I don't have a problem with the jury being able to see all that. I do take a lot more of an issue with asking for like the 10th time which McCabes or which Alberts are the ones you were friends with. He's already told this stuff over and over again. John's garage door, really? We needed to spend time on a photograph of John's garage door, which has nothing to do with anything as far as anybody has showed us. The only thing we know about the garage door is that Mike Camerano had a hard time getting it to come down when he went to the house to pick up his daughter. Had a hard time getting it to come down. Well, it's in the middle of a snowstorm, might have something to do with it. Snow gets in the way of the sensor, or just, I don't know if the cold would interfere with it. I don't know. Sometimes garage doors just malfunction. It's not unheard of. So I don't know what staring at the outside of the garage door really had to do with anything when, we're making a big deal out of voir diring material experts for the defense. That's so inconvenient that we're going to make a big stink about it. But no, we're going to stare at this completely immaterial photograph because the Commonwealth wants to do that. Nobody special. Clearly her vehicle kills cameras, only possibility. Yeah, that's the only way the Sally port, the only way the Sally port and the ring camera, right? The only way the ring camera could have not picked up Karen Reed arriving home. I mean, isn't it bizarre? The Sally port can be jumping all over the place, completely malfunctioning, and that's totally fine. And it's still a true and accurate depiction. But you think something should be on John's camera and it's not there, it didn't get picked up for whatever reason. And that's because Karen deleted it, but you have no evidence. Bukhenik said straight out, no evidence she ever accessed the system. So Charles Argo, O'Keefe car looks like it's been polished. Yeah, this was back that photograph of it out there in the driveway where we're looking at no damage. It did look pretty shiny and nice, didn't it? And if it hadn't been driven, I don't know what the water quality is over there in Massachusetts. I can tell you over here, we got really hard water. So you get snow and stuff on your car, especially if your car is not clean. And I don't mean like it's coated in mud or something like that, but just it's out in the air. Dust blows around, dirt blows around, yard, road debris blows around, detritus, stuff like that. Dust. So much like brake dust and things like that from a car gets all over the outside of your car. So then when it gets wet and that snow melts, you get spotting. It's like in the dishwasher, if your dishwasher uses hard water. You rinse it out. It dries there in the little droplets. It leaves behind that little bit of residue. So that's what you would expect to see on his car, but it definitely did look pretty shiny and nice. So it looks like they're back in court here, but not giving us sound yet. Still chit-chatting over there at the sidebar. Albert Norda, Sallyport video is daytime on one doorway while dead of night on the other doorway when SUV brought in. Also, how tow truck driver take a photo with headlights on? Yeah, good question. Good question. I didn't notice it was daytime on one time and dead of night on the other. I'd have to go look. I'm sure they would just explain, oh, there's exterior lights, on one side that were on and not on the other. I don't know. But yeah, isn't that rich how the tow truck driver can easily snap a photo of the front of the car, and yet again, nobody bothered to photograph the taillight. Nobody bothered to photograph the taillight. I mean, that's the piece that mattered, right? The front of it didn't matter. Greg, Proctor's going to need a doctor specializing in a field that's similar to his name after Jackson's done with him. I think we're going to find out. I think we're going to start to find out if Lally can't suck up the rest of this day. And yeah, it's sure looking like maybe he's going to try now, but we'll see. We'll see. Z, someone said if Trooper B think DV, why not arrest KR? Well, they did, right? That's what they did. They just had to go and chit chat. They just had to go and chit chat with the McCabes first, right? Get the story down. Get the story down. Jen, Matt, and Brian Albert. They're the ones that provided the information that they said, yep, sounds good. Based on that, we're going to go tow her car. They would have had, if they had PC to take her car, they had PC to arrest her. Why didn't they do it right that second? I don't know. I really don't. Looking for deniability on that interview is one possibility. They didn't want to Mirandize her. They didn't Mirandize her. They're always going to have the argument she wasn't in custody. She's at her parents' house on the couch. But if you're coming to her with your suspicion, with your probable cause already in place, that is a factor that weighs in favor of finding her to be in custody. So didn't want to give her that heads up that she might want to consider not saying anything. Carazola X was rewatching Jen's cross-exam. Crazy how her memory was bad on every event until the moment she had to say the lawyer he was mischaracterizing whatever event he was asking about. Then it's perfect. Yeah. I mean, just a lot of that kind of stuff. The quibbling about the details when it's the defense, but with the prosecutor, let them put whatever words they want, whatever characterizations they want in your mouth. You're the most agreeable person in the world with the Commonwealth, but with the defense, you won't concede anything at all, even obvious stuff that really should be conceded. But it's just a common theme with these witnesses, and yeah, the lapse of memory that they suddenly have with the defense. At that point, now they can't remember what the explanations are. Patricia McLean, where are the pieces broken in February 1 removal? That's what we all want to know. That's what we all want to know. All we should need to do is look at those evidence bags, because they should be sealed and dated and logged into the Massachusetts State Police evidence system the day that they were collected. Worst case scenario, maybe the next day. Okay, if it's a late night, you just kept it locked in your trunk overnight. But the first thing you did the next morning is you took that down and you booked it into evidence to preserve chain of custody. That's what you would do. So they didn't do that. So we don't know. We have no way to know.
Still on the vote?
Yes, sir.
Procedure, Your Honor?
Yes.
Trooper, if I could direct you back to page 2529 within that packet before you. And below that text stating what's that, I don't have the book anymore. You respond, is that correct?
Yes.
And what is it that you say there?
This one is a nightmare. Forget about the kids. That's awful.
And sir, if I could direct your attention again within that same packet to 2532. And there's a message there sent at 10:56 p.m. Is that correct?
Yes.
And who's that from?
A friend who lives in Tennessee.
And what does he say in that text?
I'm sure the owner of the house will receive some shit.
And you respond at 10:56 as well as 10:57. Is that correct?
Correct.
And what is it that you respond?
My first response was nope. Homeowner is a Boston cop too.
Nope.
And what, if anything, were you saying, or what was the purpose of that text in regard to the homeowner?
I was just letting him know that essentially Mr. O'Keefe is a Boston cop and the homeowner was a Boston cop as well.
Uh-huh.
Now, if I could turn your attention to
Yeah.
2533. And top of the page, sir, if you could read through that page as far as who's texting and what are they saying?
Again, for my friend from Tennessee and myself, I hope not, but I can't see it. I responded with, she waffled him. I looked at his body at the hospital. He was banged up.
He was banged up.
Now, as far as the next text from a 781 number, what does that say?
Did he get beat up?
And you responded to that, is that correct?
I did.
The objection is sustained as to form.
What, if any, response did you provide to that?
Nope.
Objection. The objection was to the former question and the answer.
I'll strike it.
Now, turning your attention to 2534. And from this page, sir, if you could, again, just read through as far as indicating to the jury who's speaking and what is being said.
From the start of the first text, so the owner of the house?
Yes.
So the owner of the house was a woman cop that beat him? That's what I initially thought after talking to Canton paramedic. Then I saw the guy.
And those last two are your responses, is that correct?
Yes.
Now, the following text messages are from your friends, is that correct?
Yes.
What do they say?
Bear, let's focus. What does she waffle to mean? What's the story? I responded, she hit him with her car.
And the she that you're referring to there, who is that?
Miss Reed.
Now, turning your attention to the next page, 2535. Again, if you could start at the top of the page and read through that page and just indicate to the jury who is talking and what is being said.
Okay. My friend in Tennessee states, okay, that's fucked up. I respond, intentional or not. Then another response, gotcha. He was frozen in the driveway and she didn't see him, question mark. That's another animal we won't be able to prove. And then I respond, they arrived at the house together, gone to an argument.
I didn't want to speak out loud or out of turn.
The objection's overruled.
Your Honor,
But
if I could say this, there needs to be an identifier of who's
I
speaking.
understand what you think the mix-up is. So, Mr. Lally, go back.
Thank you.
Sir, if you could please, again, start at the top of the page and just indicate.
No, just after the gotcha, he was frozen in the driveway, correct, Mr. Jackson?
That's correct, Your Honor. Thank you.
I respond, that's another animal we won't be able to prove. I follow that up. They arrived at the house together, got into an argument. She was driving and left. 781 number responds with, what's the name of the Canton cop living in Canton? The other one involved.
And how do you respond to that, sir?
There's several other messages before I issue a response.
Objection again. Bottom of the page.
So it's not an objection, but Mr. Lally, why don't you point him?
So, sir, at the bottom of page 2535, you have a response. Is that correct?
Correct.
And what is that response?
They arrived at the house together, got into an argument. She was driving and left.
Objection.
That's what he said before.
So it's going to be a matter you can address on cross.
There has to be some accuracy with the reading.
So I understand.
There has to
So,
be.
Mr. Lally, why don't you go point for your witness?
Mayor Proctor.
Yes.
Why don't you go? Yeah, I'm going to coach Lally to coach the witness about how to answer what should be his answer to the question, who is the Canton cop involved? That was the last text. Who's the Canton cop involved? And you told him, Brian Albert.
Okay. It's a HTML link. What?
Can I see what you have for a second, please?
Yeah, sure.
Mr. Lally, it's on there. Why don't you go show your witness? Why don't you just read it, Mr. Lally, and tell us who you attribute it to?
So just go ahead
sir,
and
what
lead
I'm
him.
asking you about is the bottom of page 2535. Excuse me, 26.
Sorry about that.
2535. You indicated biffed him, correct?
Correct.
What did you mean by that?
That Miss Reed had struck Mr. O'Keefe with her vehicle.
Now, sir, if I could direct your attention to page 2537.
This is just bizarre.
Now, do you see a response
Jury
towards the
is
bottom of the
going,
page from yourself, January 29, 2022 at 11:04 p.m.?
Yes.
And can you read that response for the jury?
Yeah, but there'll be some serious charges brought on the girl.
And what did you mean by that, sir?
That throughout the course of the day, we had compelling evidence that Miss Reed struck Mr. O'Keefe with her vehicle.
And you have two responses from friends, the same friends at the bottom of that page, 2537. Is that correct?
That's correct.
And what are those responses?
Keep your voice up loud, please. Trooper Proctor, jurors can't hear you.
Yes, Your Honor. Number ending in 5051. Got to be, I could only imagine what internal affairs of the BPD are trying to get out there. The second response, same number. She hot at least.
And turning your attention to the next page, 2538, at the top, if you could just read a number series of responses from yourself, correct?
Yes, sir.
Read from those, sir.
Yep, so these came from me. From all accounts, he didn't do anything wrong. She's a whack job. CUNT.
Objection.
Read it. Say what it says.
So don't spell it. You have to, so these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Cunt. Yes, she's a babe. Weird Fall River accent, though. No ass.
Fall River accent, though.
And sir, what is it that you were referring to there, or why would you text that?
These were, from all accounts, he didn't do anything wrong. Is talking about the homeowner, Mr. Albert. I had mentioned the compelling evidence against Miss Reed at this point indicated that Mr. Albert had nothing to do with Mr. O'Keefe's death. The rest of the unprofessional and regrettable comments are something I'm not proud of, and I shouldn't have wrote in a private or any type of setting.
But you did. So what did you mean?
Sure.
Why did it matter?
At some point, if I could turn your attention to page 2540.
Why does her Fall River accent matter?
And there's a photograph that's shared within this text communication, is that correct?
Yes, sir.
And does it indicate who shared that photograph? From the prior page, possible.
The number ending in 5051.
Jackson's going to go
And
all
who is
over this with
depicted
him
in that
again.
photograph that was shared within the group text?
It's Miss Reed being escorted out of the State Police Milton Barracks.
And these are all from February 1st of 2022, around that time frame, is that correct?
Yes.
Now, sir, if I could direct you to page 2543. And sir, if I could direct you to the top of the page and ask you to read through that page, indicating who's speaking and what the content of those communications are.
Okay. Number ending in 4146. Question is that chick a smoke? Again, 4146 question mark. I respond EH. I respond again, not bag, as Chief would say.
Oh,
I
Chief
also
would say
respond
that?
with she's got a leaky balloon knot, leaks poo.
Oh, God.
And what, if anything, is that in reference to?
Again,
Okay. That's bad.
to
Talking
Ms.
about her
Reed's
personal
some
medical
medical
stuff.
conditions there. Again, unprofessional
Mhm.
comments I should not have made. That I'm not proud of.
As far as attitudes expressed within these text messages and other text messages, what, if any, impact did that have as far as your investigation was concerned regarding this?
No,
These
no,
juvenile,
nothing.
unprofessional comments have zero impact on the facts and the
Zero
evidence
impact.
and the integrity of this investigation. They said these are unprofessional comments, but they absolutely do not detract from the integrity of the investigation or the facts and evidence of it.
Your Honor, may I approach this retreat?
Yes.
Except to the extent that so much of this evidence depends on your credibility, Trooper, your judgment, your decisions.
Now, Trooper
Kind of does
Proctor,
affect those, doesn't it?
you've seen within, you've seen text messages amongst yourself and a variety of different people from that same sort of iCloud area of your personal phone, correct?
Correct.
And among those, are there communications that you had with members of the Canton Police Department?
Yes.
And how would you characterize, or what was the general content of communications that you had with members of the Canton Police Department?
One communication was to coordinate interview times for firefighters and police officers and to set up a conference room where those interviews could be conducted. Obviously, the presence of Canton detectives or any police officers were not going to be sitting in on these interviews. Another communication was to inquire of relevant security videos that are in the area. Their local department, they know the area very well, so I reached out and asked if there's some good cameras in the area that I had of kind of interest in.
And did you collect that video?
Your Honor, may I approach the witness?
Yes.
Did you collect those videos?
I'm showing you another document, just asking if you recognize that.
Yes, I do.
What do you recognize that to be, sir?
Text communications between my sister and I.
That's your sister Courtney, is that correct?
That's correct.
And similar to what I'd asked you about the prior packet, as far as a first message sent, date and time, last message sent, date and time, what is indicated on this first?
First message sent, date, time, December 10th, 2021 at 9:33 p.m. Last message sent, 8:30, 2022 at 8:48 p.m.
And 8:30, that's August 30th, is that correct?
I'm sorry, yes, August 30th, 2022.
And similarly to the other messages, is there an indication as far as how many number of messages were sent between yourself and your sister over that time period?
2,865.
And fair to say that the documents in front of you do not contain 2,865 messages?
Correct.
Now,
So
just in
quite a lot
reference
fewer
to
than your
the
group chat.
first message on page 2662, the first page in this packet, do you see that from December 10th of 2021 at approximately 9:33 p.m.?
Yes.
And what does that indicate?
A text message from my sister.
What does it say?
I called earlier, Dolph earlier, and mom was puking in the background.
And do you recall what that was in regard to?
From the sounds of it, my mother had the stomach bug.
All this taking out the sting, and he never even got to the nudes. Didn't even bring out the
Sir,
nude.
if I could direct your attention to page
Of course we're going back to
2667.
them.
And these are text messages from January 29th, 2022, between yourself and your sister Courtney, correct?
Correct.
And if you could read from the top of the page through the end, and please indicate to the jury as far as who's talking and who's saying what.
So I texted my sister at work, "What's up?" She responds, "What? Why?" I respond, "Oh, just found it frozen to death on a front lawn in Canton this morning. Actually just interviewed Jen McCabe, said she knows you."
And the knows you, who are you referring to?
My sister.
And how did your sister respond to that?
Cut the shit. I responded, "You." It was a typo correction with my response to you. She responded, "Yeah, she knows Jack very well. She's really good friends with Julie." My sister continues on. Her sister is married to Brian Albert. My sister asks, "You still working?" ? I says, yeah, gonna be out for a while. Homicide.
And as far as your answers to those questions, or as far as your communications that you had with your sister at this time on the afternoon of January 29th, what were those in regard to, or why were you communicating that to your sister?
At that time, it was just kind of in the news. I was just kind of letting her know I was out working. She didn't share anything specific. I wouldn't share anything specific on cases with my family or anyone. It was just kind of an overall innocent conversation.
Now, turning your attention to the next page, 2669. Again, if you could read from that page as far as who was talking and what the content is.
All right. My sister starts off, "The Canton thing is a homicide." I respond, "This is at 3 p.m. on the 29th. Don't say a word to anyone." She said, "Of course not." I respond, "In the very least, it's suspicious." She responds, "This is your livelihood." And then I would never miss with that. 3:07, I respond, "Julie and Chris were at the bar with the victim and girlfriend. Got to interview them."
You'd never say anything about the cases. You just have innocent conversations, except for the details you're going to tell her about your
Attention,
investigation.
page 2672. These are messages from February 1st, 2022. Is that correct?
Correct.
And the one at the top starts about February 1st, 5:57 p.m. Is that correct?
Yes.
And again, if you could read through as far as who's speaking and what the content of those messages are.
I texted my sister, "What's up?" She responded, "Nothing. I just saw Julie, and she said when this is all over, she wants to get you a thank you gift." And I respond, "Get Elizabeth one." Elizabeth's my wife. And my sister responds, "Because I guess her and Chris were friends with John, and she's so proud of you for leading this." And then she writes, "Elizabeth ? I respond, "She's been stuck with the kids for the last 10 nights. My sister responded, "Yeah, but she knew what life is like married to a cop."
And sir, as far as the gift that's mentioned, as far as Julie Albert, is that anything that you have received at any point in time?
I never received a gift. I never asked for a gift. My wife never received a gift. She never asked for a gift.
So how would you describe this context of this conversation, or why that's being discussed at this time?
Again, I don't know the thought process of my sister and Julie as far as bringing that idea of a gift into play. Like I said, I didn't ask for one. I never received one. The same with my wife.
Why would that even
Sir,
be
if I
on
can
her
direct your
mind?
attention to page 2676. And again, if I could ask you to start at the top of the page and read through and just indicate as far as who is saying, who is speaking and what they're talking.
I start out, we write like 8 to 12 warrants on each case. My sister responded, no, I have no idea what the hell you do or how it works. I responded on the 10th at 7:36 p.m. I'm starving, but I also just want to go home. Thanks, though. My sister responds, yeah, but is dinner going to be waiting? She responded with, ha, ha, ha. And then I responded, yep. And then my sister responded with, okay, it's fine. Mom and I just don't want to go home.
May I approach her?
Yes.
Thanks, Lally. That was really important when we have all this time-sensitive stuff. We need to talk about their meal plans. Give it to Elizabeth. Give it to Elizabeth was your
May I
answer.
approach witness, Your Honor?
Yes.
We know the document, sir. Do you recognize that?
Yep. 100%.
Yes, I do.
100%.
And we
Protect and
recognize that.
serve.
This is private messages between my wife and I.
This is you're supposed to call for help.
Again, what is your wife's name?
Elizabeth.
And what, if anything, does that indicate as far as dates and times and number of messages involved?
Okay, so the first message sent 5/20/2022 at 6:19 p.m. The last message sent 8/31/2022 at 9:16 p.m.
And what, if any, indication does it give as far as number of messages within that text chain?
1,632.
And of those 1,162, there's one message that's listed on that, is that correct?
Correct.
And what is the date and time of that message, and what does it say, and who's speaking?
This is me speaking on June 9th, 2022 at 4:56 p.m. I text my wife, waiting to lock this whack job up.
And what are you referring to in that text, sir?
I'm referring to the arrest after Ms. Reed was indicted by the grand jury.
Mm-hmm.
And again, as far as the terminology that you use in that text message to your wife, why is it?
Again, unprofessional messages I should not have sent.
Seems to be a common running
I don't have an
theme, doesn't it?
explanation other than they're regrettable and it's something I'm not proud of, the language I used.
I approach the retriever.
Yes. So Trooper Proctor, the jurors can't hear you. So speak directly into your microphone the way I'm doing, okay?
Yes, Your Honor.
Yeah, this guy. Protect and serve. There it is. This is such a good point. This is what he put in writing. This is what he put in writing. Okay, imagine the chit chat they're having in person. Yeah. We're not even at cross. I mean, I appreciate Lolly's trying to take the sting here. That's what you got to do. But these are his best explanations. Just these are unprofessional. Well, why were you making them? Because it sure looks like you had prejudged this entire thing. We'd come up with overwhelming evidence. You hadn't even been to the scene. You hadn't even been to the scene. You hadn't gotten information from the medical examiner. The autopsy isn't done yet. No, what you mean is you talked to Jen McCabe and Matt McCabe and Brian Albert, and they told you what the story was, and you went, great, sounds good to me. Let's go tow her car and take her phone. And then start chit-chatting with the friends that very night about the investigation that's going on. I mean, this guy tanked himself.
Unmuted.
Where'd our trolls go? Yeah, where are they? Where are the,
Now, Trooper
thin blue
Proctor,
line
familiar
donuts
with
with the top
conversations
now?
that's within the same text communications from your personal phone with colleagues of yours at the state police?
Yes.
And Your Honor, may I approach?
Yes.
Sir.
What's he chit-chatting with his buddies on the force? These are the things you live for as a lawyer. This is going to be so much fun for Mr. Jackson. He is going to be having a great time. To just be handed this kind of ammunition, just handed it. I mean, you don't get an opportunity like that very often. Was it his MSP buddies that he told he was looking for Karen's nudes? Not his other buddies? He told them he was going to do this without a warrant? That's even worse if they told them and none of them said, you should get a warrant to look at her phone. If they're all just like, ha, 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 good one, that's not good. Yeah, the problem here, we're supposed to take Trooper Proctor's word for all this stuff. All this evidence that was in his possession, his control, his responsibility. We're supposed to take his word for all that stuff. Since he didn't follow the procedure, he didn't book it into evidence, he didn't take a photograph. He just says, trust me, bro. Do you trust this guy? Do you trust this guy? You think the jury trusts this guy? The jury does not trust this guy.
Thank you. Your Honor, may I approach the witness?
Yes.
Showing you another document, sir. Before I get into that, though, if I could turn your attention back to some of the comments on the language used in the January 29th and February 1st or 2nd text communications among your friend group. With reference to that particular time frame and the language that you used, what sort of information have you gathered to that point, and why would you say?
When McCabe told you she's a whack job.
Particularly in your descriptions of the defendant.
So this is, 16, 18 hours later. and I conducted multiple interviews.
Speak up.
Conducted multiple interviews. We knew Mr. O'Keefe never went into Fairview Road. We knew there was one
You were
shoe at the
told that.
scene, one shoe at the hospital. Based off Mr. O'Keefe's injuries, Miss Reed's statements when Sergeant Bukhenik and I interviewed her, her broken taillight, the missing taillight, some taillight pieces found at the scene, the compelling evidence pointing directly at Miss Reed that she struck Mr. O'Keefe with her vehicle led me to make those comments.
You're saying it's
like I
compelling?
said, they weren't professional comments, but
Doesn't make it
based
compelling.
on the day's investigation, it was clear that Miss Reed had struck Mr. O'Keefe with her vehicle.
This
So
is
if I
all
could turn your attention
objectionable
to the
commenting on
documents
guilt.
before you, do you recognize those?
I do.
I should be objecting to
And
that.
as far as the participants in that particular conversation, who were the participants listed there?
It's Trooper David DeChico and myself.
And Trooper DeChico and yourself both work within the same unit with the state police, is that correct?
That's correct.
And beyond the professional relationship you have with yourself, between yourself and Trooper DeChico,
Are you guys
how
also
would you characterize
buddies?
your relationship, generally speaking?
We're buddies, we golf
Buddies.
together, hang outside of work, our kids play together. So I'd say, we're friends.
Now, within the, again, as far as the first message sent, date and time, and last message sent, date and time within this conversation, if you could describe that for the jury.
First message sent, date and time, March 17th, 2022, 11:08 a.m. Last message sent, date and time, August 18th, 2022, 6:08 a.m.
And again, the number of messages listed within this text chain.
87.
And fair to say the documents before you do not contain 87 text messages, correct?
That's correct, sir.
Now, just in general terms, if you have an opportunity to just look at the first couple pages there, fair to say those are just sort of jokes that you have going back and
Fair
forth
to say
between
they're
yourself and
jokes?
Trooper DeChico. Is that fair to say?
Yes.
Now, if I could turn your attention specifically to page 2632. And these are text messages starting on April 28, 2022 at 10:52 in the morning. Is that correct?
I'm sorry, what was the time again, sir?
April 28, 2022, 10:52 a.m.
Yes, correct.
And again, sir, with reference to this page, if you could read the content to the jury and please indicate whom is speaking at each respective times.
Okay. I start out without a doubt. He's got diarrhea of the mouth too. Trooper DeChico, rookie move, not going into a meeting with the ME and getting that homicide determination. I respond, Yuri and I had two conference calls with her, sent her numerous photos, etc. We laid out the entire case for her. Trooper DeChico responds, not good enough, should have had me or Jeff do it. I respond, if you two did it, she would have made it accidental or natural causes.
And can you explain the context of those communications or what exactly is it that you and Trooper DeChico are talking about in that communication?
Okay, so the ME is the medical examiner. They conducted the autopsy of Mr. O'Keefe.
Should have leaned on her harder.
Our office, it's kind of a
Should've
little
leaned
bit
on her
of a
harder.
locker room.
Hold on, wait for the ambulance and
Didn't
then
back you up, huh? That
speak up. The
undetermined,
jurors can't hear you way back where the
undetermined
court
cause of
officer's
death?
standing.
should have told the injuries were, shouldn't you? Because I mean, you saw it. You saw it on him, so it's compelling evidence.
So like I
that
said,
Karen Reed hit him
the
with a
ME
car.
stands for medical examiner. They conducted the autopsy of Mr. O'Keefe. I guess I'll address the conference calls Sergeant Bukhenik and I had with the medical examiner. The doctor had some questions as to the facts and evidence, kind of what had transpired, which is common. You know, even if it's a homicide, I've had many calls with the medical examiner's office, even if it's a suicide or overdose, always with a homicide, the doctor wants to know what transpired. Trooper DeChico and myself, we kind of like to bust each other's chops, go back and forth. So that's what he meant by saying, rookie move, not going into a meeting with the ME and getting that homicide determination. The original determination came back.
Sustained. Next question, Mr. Rowley.
Now, as far as attending the autopsy, is that something that typically someone within your office would do, within your unit would do with regard to any sort of death investigation?
Yes.
And do you know who attended the autopsy of Mr. O'Keefe in this specific case?
Trooper O'Keefe.
And so as far as Trooper DeChico's reference to you not going in, or Sergeant Bukhenik not going in, is that what you believe Trooper DeChico was referring to in that message?
Objection.
Leading.
Sustained as to the form.
You indicated that you and Trooper DeChico bust each other's chops. Is that fair to say?
Yes.
And can you describe a little more, expound upon that as far as the nature of your relationship and sort of the text messages?
Yeah,
that you
we
exchange
joke
in this
about
and
waiting
other
on witnesses to
communications?
give us the information we want. Ha ha, it's hilarious stuff.
Basically just, kind of needling each other, and him doing that is by texting me, rookie move, not going into meeting with the medical examiner. So that's a perfect example of him kind of just needling me, which we do on a daily basis.
And as far as your interpretation of that, did you interpret that as a serious comment or something said in jest?
I interpreted that as a typical joke from Trooper DeChico.
Joke.
May I approach to retrieve?
Yes.
Alan Jackson is going to admit his own version of these texts. That's why he's not getting on Lally for the exhibit not being admitted. He's going to admit his own version, I bet. Watch.
May I approach him?
Yes.
Another
God, who
document.
else is this guy
Asking, do you
texting?
recognize that?
Yes.
You recognize that?
Text messages between myself and Trooper DeChico.
And again, what is the first message sent, date and time, last message sent, date and time, and number of messages contained therein?
First message sent, date and time, April 28th, 2022 at 1:09 p.m. Last message sent, date and time, April 28th, 2022, 4:45 p.m.
And the number of messages, sir?
4.
And if you could read the contents of those messages contained therein. Please indicate who's speaking.
So I started out, of course, it's undetermined. She was a whack job.
What? What does that have to do with anything?
Trooper DeChico responds, "Dear God, WTF, what the hell is inconclusive about the whole thing?"
And as far as your indication there, as far as she was a whack job, who are you referring to there?
Miss Reed.
Now, as far as the undetermined of what you're talking about, what is sort of the content or the context of this conversation?
That would be the manner of death was determined to be undetermined by the medical examiner's office.
And so I ask you again, as far as your reference there in the bottom of the first page, as far as she was a whack job, whom do you believe you're referring to there?
Again,
Reed or the medical examiner?
Miss Reed.
Nice try, Lally. Trying to get him to say it's
Yeah,
the
Proctor.
medical
Yes.
examiner that was the whack job. Does that refresh your recollection? No, it didn't. He's not bright enough to take that lead. Look at all these whack jobs around me. Everyone's a whack job. Maybe he was talking about the ME. I don't know. but he said he wasn't. Does kind of sound like it, but I don't know. Of course, it's indeterminate. She was a whack job. Does sound like he's talking about the ME. So let me get this right. Any woman who says what he doesn't like is a whack job. And yet the one person we've seen for ourselves who is clearly a whack job, Jen McCabe. No, she's the one we relied on entirely to tell us what was happened. She was our compelling evidence because it sure wasn't the injuries. It wasn't the scene. The taillight you didn't document. So we're here taking your word. That's what you want.
I take just a second, Phil Council. Going to play approach briefly on this packet.
More problems with the packet. I'm just curious at this point, is there anybody this guy did not talk to about the case? And this is the culture. See, that's what this is revealing. This is the culture. Everybody is totally fine with this. Nobody's like, hey, why would you say that about her? This is the culture. With his buddies, including his buddy DeChico there, who just happened to run the evidence room, just happened to be the one whose initials are on that evidence tape for those plastic pieces that should have never gone to Proctor, should have gone from Tully straight into evidence, but for some reason they didn't. Can't wait to hear Tully's explanation for that. Yeah. His buddy DeChico, who's concerned about he didn't lean on the ME hard enough to give him a homicide finding. Undetermined. Almost like the evidence wasn't that compelling. Almost as if. I mean, she must be a whack job. If she, the medical professional, looks at this guy and goes, yeah, kind of looks like he got beat up. Kind of doesn't look like a car accident. Must be a whack job. Yeah, now I am getting a lot clearer sense of what's going on in Canton and why we're doing this audit of the police and stuff like that. I mean, where's the MSP in this? I mean, I realize Canton alone can't get the MSP audited for the same thing, but I'll be watching Massachusetts outlets and how they report this after today, the Boston news groups. If they're totally fine with this is totally acceptable culture in law enforcement. We don't need to do anything about that. Yeah. Would just kind of tell me the fix is in. This has got to be called out. Yep. See, this is the quiet part. The quiet part out loud. The quiet part out loud. What other police forces are like this? Very concerning. Yeah, exactly. Kind of raises some questions about the culture in law enforcement, doesn't it? Doesn't it? No, I don't want to say all cops. I've said before, and I will continue to say, I've known a lot of good cops. I've known some good departments. I will happily point to Walla Police Department where I used to work. My view, good department. Doesn't mean every cop in it is a good cop. But it's a good department. They're trying to be honest, trying to do a good job, trying to be integrated with the community. That's one of the things with a small town that can be the upside. You got guys that come from all parts of the community. They have those connections. They have those relationships. It's not the same as in the urbanized kind of state where the cop is far.
You are unmuted.
Never runs into the people that he's policing outside of work.
Yes. They're handing you another set of documents. View those, look up when you're finished. Do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Another text thread between myself, Trooper DeChico, and Trooper Kukowski.
And Trooper Kaskowski is another trooper within your unit in the state police, is that correct?
Yes.
And again, if you could read from the first message sent, date and time, and the last message sent, date and time.
First message sent, date and time, 5/24/2022, 9:21 p.m. Last message sent, date and time, 8/24/2022, 4:56 p.m.
And as far as the number of messages indicated within this text chain between yourself, Trooper Kukowski, and Trooper DeChico?
494.
Fair to say the documents before you do not contain 494 text messages, correct?
Correct.
Just in reference to that first page, 2635, first message sent, that's May 24th, 2022, around 9:21 p.m., is that correct?
Yes.
And that's a message sent from Trooper Kaskowski, is that correct?
Correct.
And what is that?
Appears to be a picture of a toy Santa Claus.
Now, sir, if I could direct your attention to page 2644.
Santa? Who was Santa? In
I
this
could direct you to the
conversation.
bottom of the page, sir, and see the text from yourself at June 9th, 2022 at 11:19 p.m.
Yes.
Very bottom of the page. And Your Honor, may I approach just to point it out?
Yes.
Yeah, I see it, sir. Okay.
If you could read what you wrote on June 9th, 2022, around that time, sir.
If you like women who shit themselves.
And again, sir, what is it that you're referring to there?
Again, a regrettable comment I made about Miss Reed's medical condition.
Regrettable.
Now, if I could
Not despicable.
direct you to the following page, 2645. And again, if you could read from that page as far as who is, indicate to the jury who is speaking and what is being said on page 2645.
I'm speaking right now. The statement she made tonight at 8/7 was mental. Thank Christ it was on BWC, which is body worn camera. Trooper Kukowski responds, that's her. Smoke. Trooper Kukowski again, what'd she say? I respond, said the Alberts beat the shit out of O'Keefe, left him for dead, and that's why her taillight was cracked. She's gross. Trooper DeChico, oh, fuck her, bitch.
Thank you, sir. May I approach to retrieve, Your Honor?
Yes.
Mm-hmm.
Sir, with reference to that last bit, as far as June 9th, 2022, what was going on that day in reference to this matter again?
She was arraigned.
Miss Reed was being processed at the Milton Barracks.
Thank you.
I said arraigned. I'm in arrested. That's the Santa Claus.
I may have just a moment, Your Honor.
Yes.
Are you out of time, Lally? And a good 40 minutes left. No, did he text more people you got to get to? Yep, more people, more texts, more texts. Who else? Who else did you text to that she's a cunt? Who else? You and Buke. Where's your guys' texts?
May I approach?
Yes.
I'll give another set of documents to recognize those.
I do.
What do you recognize those to be?
Another text thread with members from my office, troopers.
And who are the troopers that are listed within that?
Trooper Chris Moore, Trooper Jeff Kukowski, Lieutenant John Fanning, Trooper Dave DeChico, and Sergeant Yuriy Bukhenik.
And what is the first message sent, date and time?
That would be 5/26/2022 at 8:19 p.m. Last message sent, date and time, 8/26/2022, 5:36 p.m.
And
Yeah,
what
show
is
us
listed
the
as far
culture.
as the number of messages within this chain?
651.
And it's fair to say the documents before you do not contain all 651 of those messages within this chain. Is that correct?
Correct.
Now, sir, if I could direct your attention to page 2682.
Tell us
You
what
see
you
a
said in
message
front of a
sent from
lieutenant.
Trooper DeChico on August 17th, 2022 at 9:42 p.m.
Yes.
And is that an image contained on the next page, which is 2683?
Yes, it is.
And what is the image of?
That is a picture of Mr. Yannetti, appears to be from quite some time ago.
Now, turning your attention to the next page, 2684. And there's a response from you, August 17th, 2022 at 9:44 p.m. Is that correct?
Sorry, sir, go with the date and time again, please.
So page 2684, 8/17/2022, 9:44 p.m.
Yes,
You see there's like sort of three responses from you.
I have you now.
If you could just read the three responses from yourself, sir.
Okay, so these came from me. Funny, I'm going through his retarded client's phone. No nude so far. I hate that man. I truly hate him.
Hmm.
Now, with reference to the investigation at this point, when you're talking about his client's phone, who are you referring to?
Miss Reed.
And with regards to the phone at that point, can you describe for the jury sort of what's going on during this time period of August 17th, 2022 in regard to Miss Reed's phone?
So after obtaining a search warrant for Miss Reed's phone, we weren't able to extract any data from it until August of 2023. Troopers in my office knew I was going through the phone that evening. I was most interested in location data, text messages, Google searches. That was the update I gave the troopers in the office. It was a distasteful joke. I should have gave a proper update instead of that. I wasn't able to go through the phone as thoroughly as possible because I came across some text between an attorney and Miss Reed, so I had to stop going through her phone, and I made my supervisor aware of those communications.
Now, just in reference to what you had just said, this is in August of 2022, is that correct?
Correct.
So after a search warrant is obtained for the defendant's phone, where did it go? You indicated you gave it to Trooper Garino, and where did it go?
Trooper Garino essentially hooks it up to a device called Gray Key, where it tries every possible combination passcodes in order to access the data contained in the phone.
And at that time, when you retrieved it pursuant to the search warrant, you didn't have the passcode to the defendant's phone, is that correct?
Correct.
So that device is designed to sort of go through numbers and try to find a combination to get into the phone, correct?
Correct.
And so from the time that you had
So you
seized it
broke
in
into the
late
phone
January or on January 29th,
to not
2022,
extract
until
it.
this date in August of 2022, had you been able to get into the phone or see anything in the phone in those intervening months or 7 months between January and August?
No.
And so then at this time that you're sending this text message in August of 2022, is that around the time that you were first able to access the phone?
Objection.
I'll allow it.
Yes, that was the first time we were able to have access to the phone.
And with reference to your access to the phone, were you looking for nudes or anything like that in regard to the defendant?
Objection.
I'll allow it.
Like I stated, I was most interested in Miss Reed's location data, text communications, Google searches, things of that nature. More evidence contained within the phone.
Sure.
And so, sir, you mentioned at some point you came across some information that caused you to sort of freeze your looking through the phone. Is that correct?
Yes.
And so as far as that specific time period in August of 2022, when was the next time that you or any troopers from your office were able to actually look at any extraction of the defendant's phone?
So once I came across that text communication that took place on the 29th between Ms. Reed and an attorney, the phone had to be sent off to what they call a taint team to remove any attorney-client privilege information from the phone, and then it would be returned to us, as well as defense received a copy of that as well. I'm not positive on the time. It was quite a long turnaround for that process to be completed.
Sometime at least in the spring or summer of 2023. Does that sound about right?
That sounds about right.
May I approach to retrieve, Your Honor?
Yes.
Sounds like more warrant problems too. If the warrant is so general that you get to just fish around in all of her text communications, that is not a targeted warrant. That is not specific. Who is she texting to? What time frame is she texting in? Seizing a phone does not give the police carte blanche to look at anything and everything in that phone that they want to. The items to be seized
I have no further questions, Your Honor.
All
must
right, so
be
we're going to see
described
it
with
side by so I don't
particularity.
interrupt your cross.
So they're going to get started. He couldn't run out the clock. Couldn't run out the clock. Oh, man. And we got a whole day off tomorrow. We're going to be thinking about this all day. The jury's going to be thinking about this all day. That's what you chose to end with, Lally. You just left us with that. That's not how you take the sting. That is just not how you take the sting. What a piece of shit this guy is. These are your finest. Was something funny? That girl in the back seemed highly amused. Something funny in all this? Didn't seem very funny to me. Seemed like something, if I were John O'Keefe's family, I'd be pretty pissed about. Yeah, I can see why John's dad didn't want to be here for this. He already knew it. No nudes so far. I hate this guy. His retarded client's phone. You said these things with the lieutenant in the group chat. And nobody minded at all, did they? Did they applaud you for your clever little quips there? Did they think that was super witty? I mean, I'm a little shocked that defense wasn't objecting to all of that repetition about how he is making these comments because of the compelling evidence that she hit John with the car. That's your opinion on guilt. That is one of these pretty crystal clear, bright line rules. You don't get to do that. A witness's opinion on the defendant's guilt is for the jury to decide. The opinion on the credibility of witnesses, these are for the jury to decide. Your opinion is irrelevant and it's prejudicial because you're trying to put your thumb on the scale. Say, look, at me, I'm the important official person. I have access to all the inside information, and I really, really think she's guilty. It's completely objectionable. And the only reason I can think of why they wouldn't be objecting to it is because I guess it just lets the jury see the disconnect between this guy's explanations and the reality that everybody else, including apparently the medical examiner, could see pretty clearly for themselves. This is not a compelling case for guilt. This is not a compelling case for guilt at all. When are you going to get to the body? Huh, Mr. Lally, you putting that off? You trying to avoid getting to that? You're going to just drop that at the very end like you dropped all these bad texts from Trooper Proctor here right at the end. You just left it until you couldn't not deal with it anymore. And then you finally got it out there and you left the jury with that. Is that what you're going to do with John's body too? Wouldn't surprise me at this point. It really wouldn't. Really wouldn't surprise me if the ME gets on the stand and is like, yeah, he looked like he was beat up. That's why it had to be undetermined, because these cops are leaning on me trying to tell me it was a motor vehicle collision. But the problem is that doesn't line up with the physical evidence. I could not make that determination. The medical examiner could not confirm their theory that this is the motor vehicle collision. Even with all this compelling,
you are
they say they have.
All right, so just before you start then, so we'll finish at 4. We're trying to figure out the schedule this time. I'm going to meet with the lawyers and witnesses. We're trying to work all that out, but as it looks right now, I thought it was going to interfere with another date this week. As it looks right now, it may not. At the most, it will be half an afternoon or something, maybe on Friday, but it does now look good that we'll be able to continue with this. We're out tomorrow, but Wednesday, Thursday, Friday will be full days. And we'll be able to keep moving. All right. All right, Mr. Jackson, go right ahead.
Thank you. Trooper Proctor, in the summer of 2022, August 17th specifically, you were sitting at your desk, presumably alone at your office, at about 10 p.m. at night. going through my client's personal cell phone, correct?
Yes, sir.
As a matter of fact, you were sitting there texting with your friends and colleagues at Massachusetts State
Wow.
Police about you going through her personal cell phone. Is that right?
Correct, sir.
And that included Trooper DeChico, is that right?
DeChico, yes, sir.
Trooper Fanning, Trooper Bukhenik, Trooper Moore, and Trooper Kutzkowski.
Kakowski.
Tell me that again.
Kakowski.
Kakowski.
Yes, sir.
All right, all the consonants are silent. Fair enough. Trooper Fanning and Trooper Bukhenik are your supervisors.
Oof.
Yes.
Mm. Yep. Great
And you were
point.
bragging to all 5 of them that you were going through Karen Reed's cell phone about 9:45 at night.
Objection.
I'll allow it.
Is that right?
No, I wasn't bragging, sir.
Uh-huh.
How did you refer to Ms. Reed in that text exchange where you informed them that you were going through her phone?
Retarded
I used
client.
regrettable language. I said going through his retarded client's phone right now.
You were shown a photograph of my colleague, Mr. Unetti, correct?
Yes.
May I approach?
Yes.
Same document. I need a copy. Your Honor, I think the court has the copy that I was going to use.
I thought I gave him back to you.
Yep. Get your copy in there, Jackson. Get yours in front of the jury. And let's go through every single one again so you can get them all in front of the jury. Let's do it. So they can see those texts for themselves and think about them during deliberations.
You'd received a photograph. Actually, Your Honor, if I could, I would ask that this document be marked as next in order. Assuming the witness verifies its authenticity.
So go ahead.
Do you recognize this document?
I do, sir.
Same document that you were shown, copy of the same document that you were shown by Mr. Unetti, correct?
Still Lally.
I've done that twice. Mr. Lally.
Correct.
All right. Is that a true and accurate reflection of the text messages that you were exchanging with Chris Moore, Jeff Kakowski, John Fanning, Vito DeChico, and Yuriy Bukhenik?
I'm going to
Yes.
guess the regret
I'd ask
began
Mr. Moore.
at the time
Any
of the
objection?
extraction
Yes, Your Honor.
when they took his phone.
All right, I'll see you outside down there. Have that, please.
You,
Gonna bet he had a little stomach drop moment when they came and got his phone. Or did they just go straight to his iCloud? Did they never get his phone? Did he get caught by surprise? I gotta look back through. I do think they said his iCloud. Because if they went straight to Apple, he wouldn't even necessarily know. I don't know what the status is with Apple right now. They've gone back and forth with everything's totally encrypted and we can't even access it, to yes, we access it all the time and give it to law enforcement, to we'll notify the person if we're giving it to law enforcement or not. I'm not sure if this is if there's really any official policy or anything like that at all at this point. It says iCloud data obtained from your personal cell phone. So it's a bit ambiguous. I don't know if it's the iCloud data that the warrant was from. You don't get iCloud data from your cell phone. You just get whatever the item is, the text message or whatever. If it's at iCloud, it's because your personal cell phone sent it to iCloud. It's being stored there as the backup. Oh, imagine he was sitting in that grand jury and he didn't know any of this was coming. Think they've got grand jury testimony? I wonder. But this is definitely a classic. Not regretting he said any of it all, is just regretting he got caught. Why do we know that? Because he said this kind of stuff consistently over months. He didn't regret it at all. You only regret that it came out in public and that now everybody knows that you and your law enforcement buddies, including your supervisors, are okay with you talking about the people that you're investigating like this. This makes my blood boil. There was one particular prosecutor that I worked with that I held a grudge against forever because I had a client who'd had her kids taken away, like years and years before, about 8 years before they had gone into a guardianship. And so when I got her case, it was coming back because she had done so extremely well that the social workers and people like that were supporting her petitioning to terminate the guardianship. And basically the daughter is, an older teenager now, basically restore her legal supervision over that child. And I'll never forget the prosecuting attorney before like anything had even really happened in the case, like before there's a hearing on it, just recognizing the name and telling me, oh yeah, that client, she is such a piece of shit. And I just remember looking at that woman and thinking, no, pretty sure the only piece of shit here is you. To talk about somebody who has lost their child, lost their relationship with their child, and has now turned it around, is making you work because she's done such a good job. Isn't this what you're supposed to want? Isn't that the reason why we have this entire system in the first place? So that the relationship can be restored. So I heard so much bullshit about how all of this CPS stuff, it's about addressing parental deficiencies. You offer services, right? It's not like we make you jump through all these bullshit hoops and like Cool Hand Luke, you better get your mind right. That's really what it's about. You better get your mind right. You better start telling these people how grateful you are for all the stuff they're making you do and the changes that you're having to make in your life because they say so, or you won't get your kids back. That's how the system works. And it's all supposed to be so that we can reunify.
You are unmuted.
And your reaction to that is my client's a piece of shit. You are the piece of shit.
I would ask you to give it back to the witness, please.
Thanks.
Why, as a matter of fact, it is sparring night tonight. Look out, boys.
May I inquire, Your Honor?
Yes.
Trooper Proctor, Trooper DeChico had sent you a photograph of my colleague, Mr. Yannetti, correct?
Yes.
Your Honor, because of the technical issue, I'm not going to display on the television. May I display this hard copy briefly? Sure. Thank you. You see that, gentleman?
I do, sir.
Is that the photograph that you received?
Yes.
Is that what you referred to on direct examination with Mr. Lally about receiving a photograph from Mr. Yannetti?
Correct.
And then your response was what?
I hate that man. I truly hate that man.
Actually, your response was, I'm going through his retarded client's phone right now, correct?
Mm-hmm.
Yes, after the picture, sir, yes.
Who's the retarded client?
I was referring to Miss Reed, again, unprofessional language.
I'm asking for who you were referring to.
Miss
I know
Reed.
you got an explanation. Who was it that you were referring to as retarded?
Miss Reed.
Karen Reed, the woman sitting to my left.
Yes, sir.
The subject of your investigation as a professional, correct?
Yes, sir.
As an unbiased, objective investigator,
Mm-hmm.
the person that you were investigating, you referred to your bosses as retarded, correct?
Again, poor language on my part.
Poor language is one way to put it. Completely offensive is another way to put it, right?
Objection.
Despicable, gross.
I've got to sustain that, Mr. Jackson.
After you referred to my client as retarded, then you decided to make a comment about Mr. Yannetti, her lawyer, correct?
Correct.
And what did you say about Mr. Yannetti again?
I hate that man. I truly hate that man.
I hate that man. I truly hate him,
Mhm.
correct?
Correct.
You didn't say I dislike him, disagree with him. You said, I hate it, correct?
Correct, sir.
That's a visceral response to someone who's just doing a job, correct?
Objection.
Sustained. You can ask it differently.
Sure. Let me ask it this way. Were you upset or annoyed or pissed off that Karen Reed had gotten representation, legal representation, to represent her?
No, not at all. That's her right.
Well, let me ask you this. In August of 2022, you said you absolutely hate it, correct?
I don't know if I use absolutely. Yeah, I didn't use absolutely, sir.
You used truly, correct?
Yeah,
Truly, yes.
he didn't use
How do you
absolutely,
feel about it now?
because that would mean
Sit
he
right
didn't.
there.
I still don't care for him now.
Right. I'll let it stand.
What did you tell your colleagues that you were looking for as you sat at almost 10 p.m. at night on a Wednesday night, August 17th, 2022, looking through Karen Reed's phone?
I didn't tell them I was looking through anything. They knew I was going through Miss Reed's phone. I provided a inappropriate joke as an update. They knew I was going through location data, text messages, Google searches. But like I had mentioned earlier, I had to stop.
Except Trooper Proctor, none of that really professional sounding stuff ended up in your comments to your bosses, did it?
Again, it was a poor joke.
Is that yes or no?
Did you not know?
It did not.
No,
As a
sir.
matter of fact, what did you write after you talked about going through the quote retarded client's phone?
Objection.
I'll allow it.
You better allow it.
No nude so far.
No nudes so far, correct?
Correct.
And you said that to your bosses.
Yes, sir.
You were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m., correct?
No, not correct.
Let me ask you a question. Have you ever looked for naked photos of a male suspect that you were investigating?
I don't look for naked photos in anyone's phones.
But you said you were looking for nudes of Miss Reed,
Like I
correct?
had said, Mr. Jackson, it was an inappropriate joke.
So this is a citizen. She's a woman. You were supposed to be objectively investigating. Does your text message to your colleagues at Massachusetts State Police reflect an objective investigation of a citizen?
Objection.
You can get part of that question and ask it again.
Do you believe that your text messages were reflective of an objective investigator?
Objection.
I'll allow that. Do you believe that, Trooper Proctor?
I believe poor jokes have, in unprofessional language, have no bearing on the integrity and the facts and physical evidence of this case.
It's not that they don't have any bearing on the facts and integrity. It's that they have no place in a professional investigation because it shows bias, right?
Objection.
So I have to sustain that as asked. Go ahead and ask it differently, Mr. Jackson.
You weren't so much as objectively investigating Karen Reed as objectifying her, correct?
Objection.
I'll allow that.
Isn't that right?
Rephrase the question, please.
You weren't so much as objectively investigating her as objectifying her in those moments, correct?
Again, Mr. Jackson, it was a poor choice of words and a joke that I should not have texted out. But from the start of the investigation, we didn't know what we had.
And your Trooper Proctor, your point
So
in
that's a
saying
yes.
no nudes so far to your colleagues in Massachusetts State Police was to suggest that you were looking for nudes and you'd update them when you found them, correct?
Incorrect.
Well, let me ask you a question. Did you find any nudes of
Again.
Karen Reed?
I didn't go through the photos, sir.
Did you find any nudes of Karen Reed?
I didn't go through the photos, sir.
You weren't successful in your quest.
I came across text messages from Miss Reed to another attorney on January 29th, so I had to stop looking through her phone.
So you got sidetracked. before
Yeah,
you
we're
could
sure
get
you
to
didn't
the
read a
naked
single one of
pictures.
those.
Is that what you're saying?
Sustained.
To be clear, when you sent those text messages on that group chat, There's text messages included, as we said, or as you said, not one, but two of your supervisors, correct?
Correct.
Were you ever reprimanded for your conduct in sending that text message?
Objection.
So that's sustained. Do we need to go to sidebar based on what you told me earlier?
We do not.
Okay, so,
I'll ask it a different way.
okay.
Did either Trooper Fanning or Trooper Bukhenik dress you down in a responsive text message in that text thread for doing something so abhorrent as looking for nudes or referring to nudes of a female suspect or subject of your investigation? Did that ever happen?
Not that I can recall.
Nope, it didn't. We know it
As a
didn't.
matter of fact, in reference to one of the text messages in this same string, your boss, Yuriy Bukhenik, actually responded to the photo of Mr. Yannetti, didn't he?
Objection.
I'll allow it.
He did, sir.
After you received the photo, that's when you said, I'm, quote, funny, I'm going through his retarded client's phone. Is that right?
Objection.
I'll allow this, but not too many.
Sure. Is that correct? It's on the top of page
Yes, sir.
685.
That's correct.
And Yuriy Bukhenik liked that comment. Funny, I'm going through his retarded client's phone.
I see you laughed at an image here, sir. I can't tell if he liked that comment, sir.
Can I approach?
Yes.
I don't know if it's just because it's faded or. Yeah, my copy's
Can't see
faded.
it, Boomer.
2685. You can use my copy if that helps.
All right. Thank you.
What do you see on the top of that page?
That Sergeant Bukhenik liked it.
Like what?
The going through his retarded client's phone, sir.
Can I approach?
Yes.
I'll take my copy.
There you go.
So your supervisors at Massachusetts State Police not only didn't ride you for making comments like this, he encouraged it.
Objection.
Sustained.
Whatever, Bev.
Trooper Proctor, this is your direct chain of command. Is that right? Yuriy Bukhenik?
Yes, sir.
Did you believe that your conduct was a misuse of your authority and power as you were going through her phone in August of 2022?
Objection.
I'll allow it.
No, I had a warrant signed by a district clerk, Stoughton District Clerk, to go through Miss Reed's phone. I don't think it was an abuse of power. I had every right to go through that phone.
Did the warrant say anything about looking for nudes of my client?
Objection.
Did it
No, Your
say anything about that?
no, Your Honor.
Okay, next question.
So that would be an abuse of the power that was given to you by the court, correct?
Objection.
Sustained.
Trooper Proctor, you'd agree that the hallmark of any good investigation, as you've been taught and others in Massachusetts State Police have been taught, is that the investigation and the investigator have to be fair. They have to be impartial. Would you agree with that?
Yes, sir.
Meaning that the investigation has to be free of conflicts, right?
Yes, sir.
The investigator has to be free of conflicts, right?
Yes,
The investigation has to be free of bias. Is that right?
correct.
You can't be biased against the person that you're investigating. That would compromise the entire thing, wouldn't it?
Yes.
That's quite an admission.
Basically, you follow the evidence. You're supposed to follow the evidence wherever it takes you, right?
Correct.
Good or bad, top to bottom, just follow the evidence and report it back. That's how an investigation is supposed to be run, isn't it?
Yes, sir.
And these are things that you learn early on at Massachusetts State Police Academy and then in your detective training. Isn't that right?
It is.
Literally, it's part of an oath that you took at the academy that you will, quote, faithfully and impartially discharge and perform all of the duties incumbent on you as a Massachusetts State Police trooper, right?
Yes, sir.
You swore that oath.
I did.
When you start an investigation, everybody in that investigation should be treated exactly the same. Don't you believe that's true?
Correct.
Everybody, have you ever heard the phrase, everybody's a suspect until they're not? Right?
Objection.
Sustained.
It's especially
Didn't
important
move to strike.
early in an investigation before all of the facts are known, that the investigator is not compromised by bias, prejudice, right?
Correct.
Most important early in the investigation, because that's when the most things are up in the air. There's the cloud, the fog of not knowing exactly what the truth is, right?
Objection.
Sustained.
In other words, Trooper Proctor, you don't get to pick a suspect and then try to find evidence to support your choice, right?
Correct.
But in this case, it's exactly what you did, isn't it?
Absolutely not.
Absolutely
All
not.
right, Mr. Jackson, why don't we end for today?
This is
Okay.
a good
Oh,
place to
she'd
end.
like
Thank you.
that.
All right.
End on the absolutely
All right,
not.
so folks, we're off tomorrow. Those same 3 cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, read anything about the case, please disregard it and let us know. We'll see you Wednesday morning. So Wednesday, Thursday, Friday, right now, it's anticipated will be full days of testimony shortly. Thank you.
Okay, all right. Jury out.
Biggest favor she could do right there, right? End it at the closest thing he has to a high point in all of this. Karen looks like a combination of exhausted and gleeful and tired and horrified and victorious. I mean, everything all at once.
All right, so one last time at sidebar for scheduling, okay?
So all I caught from that little advisement about the scheduling to the jury is that we don't have to do the voir dire now. Now suddenly Wednesday, Thursday, Friday are going to be full days and they'll all be fine. I don't know. I don't know what the deal is. Are we doing it next week? Are we not doing it? She said maybe it's going to take a half day. I mean, a half day would be a half day this week if we're doing it this week. Don't understand what's going on. Oh, man. I got to imagine the jury is just wanting to go shower right now. So gross. So completely gross. I loved how he framed that question. Yeah, you were objectifying her from the very, very beginning. From the very beginning. From the very beginning of your little text with your friends, all you care about is she a smoke show? Is she hot? But is she hot? I mean, I don't even know what else to say. I really don't. I don't even know what else to say. It's just so disillusioning, you know? Be part of this system. It's supposed to be truth finding, supposed to be helping us all, protecting us all. This is why we give up our monopoly on force, is because the police department exercises it for us. That's the social contract. That's the deal. We don't go out and do our vigilante justice because we have given the power to law enforcement and to the state to do that for us. And this is what they do. You think, do you feel like that deal has been held up? Do you feel like that deal has been held up here? I'm not a real political person. I don't like getting super political. I don't really care about parties and things like that. It's just, to me, it's like the least interesting thing about a person is like, what side are you on with political questions? But I'm very much interested in topics. And I have to say, seeing the way that this feature of law enforcement has finally started to come front and center, broadly recognized over the past several years, I feel like there's an awakening. I really do. I feel like people are starting to see stuff that I have seen for a long time. People before me have seen this for a long time. One of my favorite books about policing that I read in the last few years is called Ghetto Side, a book by Jill Leovy. She's a New York Times reporter. And she went down to South Central Los Angeles. The book is basically written around the investigation of the murder of a detective's son in one of these neighborhoods, and just basically the process of trying to investigate this murder. And she's really trying to examine what is going wrong with this community, and in particularly this Black community, and the law enforcement officers that are there to police them. Because this, when you get into the political side of things, it's just all, there's a lot of just false things on both sides. There's cases that are put up as instances of police misconduct that really aren't. There's situations where people are blamed for it's your fault crimes are not being solved because nobody will talk to police. There's all this vitriol and heated emotion and stuff. And what I particularly loved about the way that Ms. Leovy broke it down is she broke it down in these terms about the social contract. That's supposed to be the deal. The reason why there's been a breakdown in these communities is because from time immemorial, police have not held up that end of the deal. Police have not been there for Black people who were victims of crime. They just haven't. Going all the way back to before we had like civil rights legislation and stuff like that, continuing into the modern day, it's just not something that has been of interest there. And so there's a vacuum then when it comes to that monopoly on force, because you're supposed to have ceded it to the state, but the state isn't holding up their end of the deal. And so what happens? Well, in a lot of these communities, there's competition then for who's going to exercise the monopoly of force. And who is that? It's the gangs. A lot of the times it's the gangs, because you know what? They don't have a great moral system. I mean, from my perspective, a lot of bad things about the moral system of the gang, but it is a system, and it is there, and it is consistent, and it is working, and it is predictable. And they know they can count on it because they've never been able to count on the police. That's the problem with a lot of these communities. And so I'm just glad to see that people are becoming more aware of these types of problems, and that, it isn't just Black communities. Okay. It's anybody who isn't part of the club. It's anybody who isn't part of the club. You need to be very, very careful about whether you can rely on the police or not. So that's my philosophical rant for the day. Just disgusting. Just absolutely, absolutely disgusting what we heard. It's inexcusable. It's regrettable. Yeah, great comment there. At which point exactly did you start to regret it? That would be a great question. That would be a great question. Oof. Well, guys, let's see what y'all have had to say while we've been enduring this afternoon. Carazola X, surprised that they actually put Proctor on the stand. It's usually a big risk to make the defendant testify, isn't it? I mean, I think this is getting at Proctor potentially being a defendant. I don't know. I don't know to what extent he's the target of this federal investigation or just somebody who's been caught up in it. But yeah, this is pretty bad stuff for him to have to be conceding up there on the stand. Is any of it criminal yet? Probably not. Probably not. So that, answers some of our questions about, well, why isn't he pleading the fifth? Why is he here testifying he's not pleading the fifth? Because nothing they've elicited so far implicates him in criminal activity. So it isn't, it wouldn't put him in jeopardy. It's not the type of thing that imperils him for a criminal prosecution. But, I mean, what else do the feds have? What else do the feds have? Are we to believe they turned over absolutely everything they have on this investigation and on Trooper Proctor and all that stuff? I don't know. Maybe they did. Maybe they did. Cow Palace Dave, I got a fever and the only prescription is more taillight. I mean, how much taillight was there? I haven't had a chance to see it yet, but I saw that Ali Lamada and Melanie Little did a live, and Ali, I guess, has done a lot of work into breaking down the distinct pieces of the taillight and what went where and what's left over and that type of thing. Because yeah, that's been a big question that I had. It seems like a lot more taillight got collected than what ended up fitting into this housing. But I don't know. That's just that's just a guess. That's just an intuition based on like volumes and volumes and volumes of taillight coming into evidence. So I do want to check that out. I am planning on taking a look at her work because yeah, that's a question that I have definitely had and would like to see the answer. Kurt Smith, is it customary? Yes, we talked about this. Is it customary, acceptable to discuss an open case with friends or whoever? My lawyer friends won't talk about anything they are working on. Absolutely not. Absolutely not. Not customary, probably against some kind of internal policy. It's not public information, so you should not be sharing it with anybody outside of the department. Arla 7247, would you deny defending someone because of the type of crime and feeling they were guilty? No, absolutely not. That's not what a public defender does. You defend everybody, including, and frankly, most of the time, the guilty people. And the reason why is because there's a big misconception, I think, in a lot of quarters about what the defense attorney's job is, right? Somebody like Trooper Proctor, who's testifying about how much he hates David Yannetti. It's because in his mind, David Yannetti's job is to get the bad guys off at whatever cost. And that's not what a defense lawyer's job is. That's not what a defense lawyer's job is. Your job is to counsel your client. Your job is to help them understand what the evidence is, what the options are that they have, help them make decisions in a meaningful way. They're the ones who make the decision. Am I pleading guilty or not guilty? Am I taking a plea deal or not taking a plea deal? Am I testifying or not testifying? These are fundamental decisions that the client makes, not the lawyer. And so my job is to help them make that decision. And there is a lot of times when the best thing I can do to help you make that decision is to encourage you to take that plea bargain, because we can sit in the jail and we can look through all the evidence together and I can show you what the jury is going to see. And based on that, I can give you my professional opinion about what I think the jury is likely to conclude from this. So sometimes all you can really counsel a client in a case is about, this is how much prison time you should expect. And, this is what processing is going to look like. Here's how your family is going to be able to stay in touch with you. Here's the type of programs you might get access to in DOC. Defending somebody does not mean getting them off at all costs. So I have absolutely no problem defending people who are guilty, including people who are guilty of pretty much any crime at all. I mean, that's the deal. That's the nature of the role that we play. Bird, AJ has let some witnesses yammer on instead of forcing yes or no, but I do hope he goes scorched earth on P. Well, we're seeing that so far, right? Proctor's already gotten his chance to give all of his explanations. We're not going to let him say for the millionth time, these are distasteful jokes. We're going to pin him down to answer the question. Don't you think that makes you look biased? Don't you think it looks bad that your supervisors are okay with this? You know, not going to be able to wiggle out of it. So far, yeah, he's holding his feet to the fire, not letting him just volunteer those explanations to avoid answering. Kevin Costello, my job is really interfering with my ability to watch this trial. Well, join the rewatch crew. You can catch up. You got a whole day off tomorrow. I know it's addictive. It's been addictive. I completely got sucked in. So I feel you. You have my sympathies. Greg, this being the only time Lally has made an effort to get ahead of bad facts is very telling to me. Yeah. I mean, these facts are so bad. He can't just pretend they don't exist, right? The only other time I remember him sort of trying to get ahead of the bad facts was with Jen McCabe, and he did bring up the Google search. He brought up the Google search so that she could say, I did these at 6:23 or 6:24 or whatever, and I did not do them. I did not do the search at 2:27. That's the closest he got to trying to get out ahead of that, at least as far as I can remember. So yeah, he couldn't avoid it, knew he couldn't avoid it, knew it had to be dealt with. Frankly, did not come off to me like he really knew how to deal with it. I mean, you just drop all that. You spent like an hour and a half after lunch with the jury going over his bad text where he looks like about the biggest douche that has ever worn a uniform. And then that's it, nothing further. No more questions. I mean, that's not a rehabilitation. That's not a rehabilitation. I mean, granted some things, and I understand this very well as a defense attorney, you're not a magician. You don't get your facts. You don't get to choose your facts. You don't get to choose your evidence. It is what it is, and you just got to deal with it. You just got to deal with it how it is. Maybe this is something there's no way to rehabilitate. I mean, it's going to land on the jury how it landed. Some of those comments, the things about her medical condition, I mean, blood boil. They make my blood boil. They really do. That this is how they treated that woman. And not to always be going back to that case that is the case that defines all cases. But yeah, Johnny Depp. She didn't think he would go anywhere with that case because it would put so much of himself and his privacy and things that are embarrassing to him that he wouldn't want to be out public. He would know that would have to all be laid out in public in front of everybody, in front of the entire world to see his dark secrets. He knew that he was going to have to do that in order to go forward with that case. She thought he didn't do it. That was her game of chicken. She thought he wouldn't do it, and he did. And he did. And what did he say? Never fear truth. Never fear truth. Never fear truth. And I feel like that is Karen Reed's attitude here too. If it's gotta come out, so be it. You know what? She's not the one who comes out looking bad as a result of those text messages. Just like the whole when Jen McCabe couldn't wait to get out. Oh, Carrie Roberts said that John never really loved her and she was just a babysitter with benefits. Karen is the only person who doesn't come out of that looking bad. The only one. Yeah. Not a very impressive effort by Mr. Lally there. RN, imagine being married and crawling. Stop. My eyes, my brain. Oh God, I got to finish reading this. Imagine being married and crawling into bed with this troop. Get the fuck out. Should be fired before the top of the hour. Yeah. Why does he still have a job? Is he even on any kind of leave? I think we heard he's on desk duty. Did we hear that in the pre-trial? Something like that. He got taken off the street, but he's still got a job. He's still collecting his salary, still going to collect his pension. This guy for this service. Yeah, thanks, but no thanks. Charles Argo, it'd be fun for you to cross. Yeah, we saw this one before too. It would be fun. Yeah, it would. Mr. Jackson, he is having fun and he is going to continue to have fun. Carazola X. Prosecution will try to use the bad audio setup to argue a mistrial. $100 on that and another $100 it will be granted. So it won't. And I'll tell you why. The prosecution will almost never move for a mistrial because jeopardy is attached. They've got this jury sworn in now. And so the only way that a mistrial does not end us here, end it for good. Like you can't come back and pick another jury, is if there's a manifest necessity and it cannot be occasioned by the party who's requesting the mistrial. So temporary lapse in the audio, that is not going to cause a manifest necessity. It's not affecting the record. You've got the court reporter right there taking everything down. It doesn't matter if the TV is having sound systems. They are stuck. They are stuck. It would take the defense. It would take the defense doing something so improper, so inflammatory, so inexcusable that it tainted the entire trial. Then maybe they could ask for a mistrial and not be barred by double jeopardy at getting a second bite. Otherwise, they are stuck. They are in it. They got to finish it now. Arla 7247, so low, degrading for Karen, want to cry for her. Yeah. Do you think the jury maybe got a little sympathy for her today? How'd you like how you played that, Lally? You just made Karen Reed look like the victim. You just made her look like the victim. She was victimized by these guys. Yeah, very clear. You just read us the text. You showed it happening. You showed it happening. And so that's how the jury sees her now. She's a victim. You think they're going to vote to send her to prison after that? I'd be shocked. Anspan 65. I am so flipping mad. I am losing track. When and how did Proctor know about Karen's medical issues? Thank you, Andrea. Yeah, that's a great question, right? Because he knew it right off the bat. He's texting about it the very first day. So he must have got it from Good Samaritan. He must have got it from her disclosures during that sectioning. He must have got it from the hospital. It's about all I can think of. Maybe she told him during the interview. I don't know. Maybe she told him during the interview. I don't know why or how it would come up or how it would be relevant, but maybe it did. Maybe it did. Maybe she told him. But no, I kind of suspect that it came from the medical records. I don't know. Alyssa Ramirez, I missed arguments this morning, but I just watched. Maybe you answered already, but why didn't prosecution bring up the dog stuff after opening arguments? Why so late? Well, yeah, who's lying in wait here? Who's playing the gamesmanship, right? The prosecution wants to say we were surprised when the defense went there in opening, but you didn't raise it then, did you? You waited several weeks. You waited several weeks to suggest that things are not as you had been led to expect, that you thought there was some kind of stipulation / concession here. The opening put you on notice that's not the case, and you didn't raise it then. So, yeah, I mean, $1 million question. How surprised were they really? It's bullshit. We know they weren't surprised at all. They've known this for over a year. It was May 2023 when it came up in court. Tim Bionda, is it fair to say, but no objection leading? They have not been objecting to Lally leading these witnesses. He does this all the time. He does this all of the time. Extremely leading questions. And it's only been just very rare occasions when they've raised any type of objection at all. So yeah, that's how he operates. They're letting him get away with it. Some of it maybe lull him into complacency. You don't object so that when you do, it's meaningful, it matters. And he's so used to being able to do things this way that when the objection is sustained and he can't do it that way, what happens? He freezes. He's trying, but can't quite get there. So that I think may be a strategic decision they've made, just to let him stay comfortable. Jargon, am I saying that right? Jargon. Call an ambulance, but not for me. Hell no. I will die in my house before I want these people responding to render aid. No, thank you. Beach Rando. Jen had Karen go back to Fairview, which makes no sense if Jen assumed Karen and John left together. Yeah, that's a good point because that came up in, I think it was Jen's, because Carrie was trying to say that, or was it Carrie? No, it was Carrie Roberts's, because Jen was trying to say that as soon as Karen showed up at her house, she was saying, we need to go to Fairview. We need to go to Fairview. And for some reason, Jen diverted her. No, we're going to go to Meadows instead. They went to Meadows instead. And it's not until after that they went to Fairview. And so my question then was like, well, that's weird. Why are we putting off going to Fairview? That's the last place you saw him. Why wouldn't you start there? And so then I believe it was Carrie who testified that Jen was the one who said after he wasn't at John's house, well, we should go to Fairview. So if that's the case, yeah, I mean, I don't know. I don't know what to make of this. To me, it makes sense that, yes, of course you would go there. It's the last place he was seen. It's the last place anybody saw him. You would start there. But I see your point very much that if she's positive, no, he was never there. He never came in. He was never set foot outside. We didn't see him at all. He must have left with Karen. Then yeah, why would you necessarily think that? I can see a couple ways to look at that one. Our red pen, outstanding coverage and perfect snarky commentary. What a day. Andrea, thank you. No, thank you. Thank you for, you can get a pretty dark sense of humor after some time in criminal justice. It's one of the reasons why, again, I'll just repeat, a lot of cops are good cops. A lot of cops I like. We see a lot of things the same way because we deal with a lot of the same people, same ugly circumstances. And we have to develop coping mechanisms for those. Black humor, super common. The ER docs have a lot of that too, a lot of the time. So I'm glad that you guys appreciate when I kind of lose it a little bit. I just, I can't tolerate some of this stuff. It's just, I don't know how dumb they think I am. Really don't know how dumb they think I am. Elo the Curious. Lally denied Seraph sharing what Jen said occurred. So that was hearsay because Jen had not testified yet. So there's confrontation implications based on the fact that she hadn't testified. So I think the reason why she's letting Lally get into it now with Proctor is because Jen has already testified. She's already been subject to cross-examination. So it could have, they could have raised it during that context if they wanted to cross-examine her about it. It doesn't have those confrontation implications nearly as much now because she has in fact testified. So I think that's why we got those different rulings. Horror Vibe 666, 75% of Proctor's testimony is about his gross text. Yeah, I mean, it's about all anyone's going to remember, right? What was the rest? The rest was just some kind of boring redux of the stuff that Bukhenik already told us, except somehow Proctor managed to kind of dull it down and make it even more boring and unbelievable, like the ring camera stuff. Yeah, I don't know. I really don't know. I mean, frankly, the only redeeming thing out of this entire day today, Nicholas Barros, thank God for him, right? Because if there is anybody who is out there who is going to give us some bastion, some glimmer of hope that there are law enforcement officers out there that we can trust, that are there to just say what they saw, not be on somebody's side, not be there calling the person we're investigating names and degrading them. It was him. Didn't get the memo. didn't get the memo or didn't pay attention to the memo about what was supposed to be in his report. So yeah, I mean, Proctor, this is all anybody's going to remember from Proctor. He didn't have anything new and substantive beyond what we already got from Bukhenik. So it just kind of fades away. It doesn't really matter. We already got those details. So yeah, the texts are what stand out with him. So not smart by Mr. Lally. Greg, oh, they went through all that and want us to believe his morality was enough to stop looking through her phone with a convo with attorney. Yeah, we were on the mind meld on this one. Oh yes, he scrupulously stopped instantly and didn't read any of those texts with her lawyer. Yeah, nobody buys that. Absolutely nobody buys that. You're not supposed to be looking through the person's phone anyway. You already went through this whole description of how once you seize the phone, you stick it in airplane mode, you seal it up, you get it into evidence, then you deliver it over to the, computer forensic lab or whatever it is that you have where they do the extraction. That's because messing around with the phone, yeah, it changes stuff. It adds new information. It can affect what's already there. I mean, you've created a whole new history of things that have been open, things that have been looked into, and so forth. You're not supposed to do that. That's why you don't do that. That's why you don't decide, well, I have my warrant. I'm just going to go ahead and flip through it before they can do the extraction. No, you do the extraction. That's the process. Once again, doesn't matter. The investigation of John O'Keefe, the one place where it should matter, his death, is the one time they don't give a damn about doing it by the book. Love in two lines. Do you know, does O'Keefe's family support Karen or are they against her? So, of course, I don't personally know. And as far as I know, we only know what they've told us, what they've said publicly. They seem to be against her. So far, that seems to be what we've seen. I mean, I know that I saw something about a Facebook group that Jen McCabe put together for Peg O'Keefe, Peg's Angels or something like that. Didn't we see that with Carrie Roberts during her examination? Maybe not. Maybe it's something that I saw after the fact. I just remember because I think she was in it. She was one of Peg's Angels. So it kind of looks like there's been a little bit of this effort to cultivate Peg O'Keefe as part of this whole crew. But yeah, you have to wonder if there's any movement. Gotta notice, I haven't seen Mr. O'Keefe there in a long time. And I remember when he walked out, he did not come back during Jen McCabe's testimony, like midway through Jen McCabe's testimony. He's out, he doesn't come back. And I don't know that I remember seeing a lot of him since then. So I do wonder if they were against Karen initially, are the scales falling from their eyes a bit? Everybody's been telling them, all this social media stuff's been screaming, oh, this is just a conspiracy. They have no evidence. Well, you're seeing the evidence now. This is being brought out in court. Yeah, this stuff really happened. The defense lawyers didn't make it up. It's not all a big lie. It's not all a big lie. They really are behaving like this. I noticed that when Paul and Aaron O'Keefe testified initially too, they didn't seem that negative on Karen, right? They said they liked her. She was great. I think it might have been Paul who said she complained that John wasn't very nice to her, when they would have fights. I think that was him. It could have been Michael Camerano. I could have that wrong. But either way, they weren't like, yeah, she was a nut job. She's a whack job. None of that. They didn't think so. She stepped up and was taking care of the kids so that John could go to his work. She could work remotely from home. And she stepped up and did that for him. And yet we've seen the glares, we've seen him in court just really staring her down, and doesn't look like a friendly stare. Really doesn't look like a friendly stare. So it's very hard to know what to make of the family and what is going on in their minds and what they're thinking. They're seeing the same stuff we are, is the bottom line. And I can't imagine they want to believe that any of this is true. And that can be very powerful psychologically. That can be very, very powerful. You can come up with a lot of reasons not to believe something if you really, really don't want to believe it. You just got to wonder. Duncan, Idaho. I feel that if I were a juror well before now, but especially after Proctor's testimonies, 10,000% not guilty. This is a giant pile that stinks of the departed levels of corruption. Just amazing. Yeah. I mean, we're in the right neighborhood, aren't we? We're in the neighborhood. If so much of the investigation depends on this guy's integrity, it's done. It's over. It's shot. He has no integrity. That's what this has revealed. He has no integrity. So we're suddenly supposed to believe that just because he'll joke about searching your phone for news, just because he'll joke with his buddies about leaning on the medical examiner to get the right finding for him, that he's not above actually doing some of that, actually putting his finger on the scale. Now, he only jokes about it. He doesn't really do that. He would never do something like take busted pieces of the taillight and sprinkle them out at the scene and then mix them up in the envelope so it's not clear what came from where when. Would never do anything like that. With this integrity, not proof beyond a reasonable doubt to me. Kathleen R. Love KR's confidence facing the O'Keefe family at the end of court. Good for her. I mean, she's been waiting for this. She's been waiting for this. This is massive vindication for her. This is massive vindication for her. These are the guys who are running the investigation. And you're supposed to tell us this was unbiased, that they were just following the facts. We already knew that they weren't. We knew that from the time of Sergeant Bukhenik's testimony. We knew it from when Nicholas Barrows came up and told us. They were already calling for the tow before they had ever interviewed her, before they were ever even on the road to Dighton. They had talked to Jen McCabe, Matt McCabe, and Brian Albert, and they decided that's it. We know what happened. Didn't even go to the scene. So we knew the fix was in already. But to just see it spelled out like this so clearly and with all its warts, yeah, I'll bet she is feeling very vindicated. Southern Gigi, thank you for covering this all morning. You do such a great job. Can't wait for Tuesday. Well, thank you so much. It'll be Wednesday. No court tomorrow. I'm going to get to sleep in a little bit tomorrow, but we'll be back on Wednesday for a full day. Wednesday, Thursday, Friday, I'll be here. It's a little bit of a marathon. We're going to get her done. I mean, yeah, can't wait to see where this is going to go next. Segan, sorry, I don't know how to say that. Segan Rose, super sticker. Thank you so much. Very kind of you. Appreciate that. Quite frankly, Samantha Teresa. Why does Lally get to waste the court and jury's time with menu specials from Aruba and hotel lobby? Decor descriptions present manipulated evidence, but Beverly has a problem with defense experts to defend their client. It's the double standard at work. I mean, we're seeing it. We're seeing that in Judge Bev's court, some animals are more equal than others. Some animals are more equal than others. When it comes to the defense's material evidence, they got to justify it. They got to support it. When it comes to completely irrelevant stuff from the Commonwealth, go forth, have at it. I have said before, I completely question this entire decision to bring Aruba in at all. Not seeing the link. Not seeing the argument here. You're letting in Aruba as proof of motive of murder, but you're not giving us third-party culprit evidence where there is much clearer motive. Well, from Brian Higgins, who's been texting with this guy's girlfriend, might have a little hostility towards that guy. Some animals are more equal than others. The double standard has been, we've been seeing hints of it, but I feel like today, really laid it clear, not letting him make his record, making these derogatory comments towards him, suggesting he's playing for the cameras. You're not directing your argument to me. No, as if he's the only one who's out here aware of the fact that the public is watching. You think Lally isn't aware that the public is watching? You don't think Lally was concerned about what would be picked up and reported by the press when he wrote that memo, when he colored those facts in that way to make it look like something happened that didn't, when he presented the law that makes it look like it's something that it's not? But somehow that's just all Mr. Yannetti and Mr. Jackson. Desert Cat, how does Proctor know about her health issues? I find this important. More of his bias. Am I wrong? Yeah, it is. It's a very good question. Maybe we'll find out on cross. Maybe they already know, and it's just not that big of a bombshell. Seems like they would get it from the medical records, or they would get it from Karen during her interview. I suppose another possibility. Could have got it from Jen McCabe. I mean, they had talked about MS, certainly, right? That was the whole reason for them to be brought together to be friends in the first place. They're both younger women who have been diagnosed with MS. So maybe it was her. Maybe she knew about this stuff. Maybe it was her. I mean, couldn't wait to tell us that little thing about the babysitter with benefits. Couldn't wait to tell us that. Yeah. I don't know. Maybe they'll ask. We'll see. Oh, sweetie, no. Andrea is my ethical spirit animal. Thank you. It's very kind. I have some horns. I got some teeth, maybe. Maureen Francis, Proctor has no shame, not even embarrassed. Regrettable. At what point was it regrettable? It was regrettable that he had to get hot on the stand trying to explain it. I mean, he got read. I'll give him credit for that. At least he got read. He knew enough that he understood that the jury is not impressed by this. You know, he had at least that level of shame that this looks bad. But as far as, you know, is he internalized feeling bad about this? I seriously doubt it. You don't make comments like that over months at a time as part of your culture with everybody else in your office and your supervisors. And what, suddenly you saw the light and realized this was embarrassing? You were never embarrassed about it. He's just embarrassed that the jury is seeing who he really is and what he really says when he thinks nobody's going to be looking. Freedom Ring, defense team not objecting to proffer offering opinion on guilt, strategy decision, fits defense theories, bias, tunnel vision, making up mind on day one before much investigation complete. Yeah, that's basically the conclusion I came to as well. I mean, it is definitely objectionable. It's one of the things that, because it's an error of constitutional magnitude, at least Washington looks at it that way. So you don't necessarily have to raise it. Like in my state, you don't necessarily have to raise that on direct examination in order for that to be an issue on appeal. I can raise it even if they didn't object to it, if it's out there, and I can say this is prejudicial. Don't know if that's the case in Massachusetts too. So it could be a situation where there's no losing for them by not objecting. You still get to raise it on appeal if you want to, and you get to argue. You know, it for all these reasons you've pointed out. It just goes to show, just like Trooper Bukhenik is saying, this opposite day video where you thought you were looking at the passenger side, but it's actually the driver. That's accurate. Well, this is compelling evidence. You know, it's just letting the jury see their exercise of judgment and compare it to their own. And do these things line up? And based on that, do I trust these people and what they're saying? So yeah, I tend to agree. I think it's a strategy decision. Gordista, Jackson is from West. Does Cali Bar have reciprocity with Mass Bar? I don't know if they have reciprocity. I'd be kind of a little bit surprised if they do. But he's more than likely pro hac vice. I haven't looked at the court record to see if that's the case, but Yannetti is local. Yannetti is Massachusetts. And so it's pretty easy to, when you're out of state, you have local counsel that basically sponsors you, and you can get limited admission for purposes of practicing on a particular case just from permission of the judge. You don't have to go through the bar association and stuff like that. And typically it's just, you got to show you're in good standing with your own state. You're not like subject to pending discipline or anything like that. And there can be procedural requirements like whose signature, like Mr. Yannetti's signature may need to be on anything that Mr. Jackson also signs, sometimes little things like that. But he shouldn't need to be required to be a full member of the Massachusetts bar to be able to appear for purposes of this particular case. He can just do that through pro hac vice admission. Critical observer, excellent coverages. Thank you, and for your input on this travesty of a trial. Well, I'd like to say it's my pleasure, but it's hard to say that after a day like today. It really is. It's just hard to say that after a day like today, but I'm glad that you find it helpful. Thank you so much for your nice words. Raina, couldn't there have been a better way for Lally to get ahead of the bad facts? I mean, if nothing else, bury it. Put it in the middle of whatever you're doing with him so you don't end with that, and hand him over to cross with that being the last thing that the jury heard and the last thing that they're thinking about before the attack is coming from the defense. They're not coming there to be friendly and to help him and to prop him back up. No, you've knocked him down and they're coming forward now to boot stomp him. Okay. Yeah, there could have been better ways to do that. That's just the obvious one to me. If nothing else, structurally, bury it. Okay. I mean, substantively, that's the $1 million question. I don't know how you get around that. I mean, it's bad. It's bad no matter what. And his only response is no, absolutely not. It doesn't have any effect on the integrity of my investigation. Of course, you don't get to coach your witnesses and tell them how to answer, but a better way to respond to that might be something like, I acknowledge it could look that way. You need to respect how the jury is going to see this. You need to not set yourself up in contrast with the jury's own common sense and the jury's own moral compass, because then you're on the other side. They're not with you anymore. So you need to give that to them. I understand how it could seem that way, and I feel really terrible that my unprofessional conduct could have jeopardized this investigation against John O'Keefe. And all I can say in my own defense is that the evidence that we gathered, it speaks for itself. Something like that, something like that. But this, no, absolutely not. Just again, with the absolutely not, no effect on the case. We don't believe you. See, a common theme I'm seeing out there, I see a lot with the commentary. Oh, the case is like this because a witness said that. People don't have to believe the witnesses. The jury gets to decide who they believe. And just because somebody gets up on the stand and says the words, that does not mean you're stuck with it. You get to say, you're full of shit and I don't believe you. And I'm not factoring that into my decision, what you said. Because I don't think it deserves any weight. That's what they're going to do with a self-serving type of statement, like it had absolutely no effect on the investigation. Well, you were biased. It's quite clear. You demonstrated through your texts that you were biased. So we can infer whether that would affect the investigation or not, given the opportunities that you had for your bias to infect the investigation. Through those decisions, like not even going to ask to go in 34 Fairview, not even going to ask for a consent search. Let's put aside a warrant. I'm not necessarily convinced that there was probable cause to go inside. Not necessarily convinced, although after they talked to Karen, Karen told him she dropped him off and he didn't come back. Yeah. I think at that point, maybe you would. But before that, I'm not necessarily convinced they had PC for a warrant, but you would ask for a consent search. You don't even do that. That was an opportunity you had. The interview decisions, I mean, we already heard about they're interviewing the people from Aruba before they're going and interviewing the people who drove up to pick up Julie Nagel, Julie Nagel's brother Ryan and his friends, the people in the car, the three people who saw the SUV there, saw its condition, saw Karen in there by herself. Months later, before they investigated them, Colin Albert, was it Colin Albert that trial had already started? No, it was Caitlin's guy, the one who came to pick up Caitlin, Tristan Morris. Didn't even interview him until the case is already underway. These are decisions that he got to make. He got to make those decisions. And that's where your bias can color those decisions. So no, my opinion, Lally did an absolutely terrible job of getting out ahead of that. And again, I'm just not sure how much of that can be corrected, but at the bare minimum, you have to acknowledge that's a legitimate concern, that you understand why the jury would think that. That's part of what it means to internalize the effect of your regrettable decisions. And not just, I feel bad that I'm embarrassed that you're seeing them. You need to recognize the effect that it had and acknowledge that. And we saw absolutely nothing like that. Michael Dicha, can you mention that book again? I want to read. Yeah, it's called Ghettoside, Ghettoside, and it's by Jill Leovy. Her last name is Leovy. It's a wonderful book. It's a few years old now. I want to say like 2010, 2015 kind of time frame. But it was excellent. It was a great read. I like books about the criminal justice system that aren't necessarily written by criminal justice system participants. The other one that I absolutely love, one of my favorites ever, Tattoos on My Heart. It's Father, what's his name? He's a Catholic priest, and he's also down there in South Central Los Angeles. He started this program. It started with Homeboy Industries, and basically it's a what's the word I'm looking for? It's just sort of a way to try to help people out of the gang lifestyle by giving them an opportunity to have a different type of job, have a regular work, get some type of work history. Be able to be legitimate, because a lot of these people that are pulled into the gang lifestyle, it's from very young age. They never had a chance, never had a choice. You'll see kids 6, 7, 8 years old. They're being brought to the cookout. They're being taught to throw up the signs. They're being taught to have their flags, their bandanas, all that stuff. Sent out to do work early, never had a chance. And so they don't even sometimes understand how would you even approach an alternative. I gotta Google it right now because I can't remember his name off the top of my head. And Tattoos on My Heart. Gregory Boyle, Father Gregory Boyle, that's his name. So anyway, that's another wonderful one. It's just about his experience with working with these people and trying to provide them with, an opportunity to get on the right path, get out of this lifestyle that's just damaging and destructive for all of them. And I'll tell you what, it's a hard read in a lot of ways. Not to be a big spoiler alert, but it is a really tough read, but just a wonderful book. So yeah, those two are two of my favorites: Ghettoside by Jill Leovy and Tattoos on My Heart, or Tattoos on the Heart by Father Gregory Boyle. AP, I have one of the same medical issues as Karen. It affects me way more than her because I'm a male. The fact that is the main concern of his when texting his friends is disgusting, beyond pissed. He wanted to humiliate her. And for a woman, especially, you know, her beauty, her sexuality, her, dare I say it, fuckability, that's a way some guys like to have control over women. They'll use that to degrade them and so forth. I'm sure every woman in the chat can can attest to this just being something you get kind of used to from a pretty young age. From a pretty young age, you get used to being evaluated in that way. And so, yeah, this is his way. This is his way of denying her just basic feminine attraction, you know, basic value. A lot of people, you know, not, of course, not everybody, but there's plenty of men out there. Woman's only value is how much they want to fuck her. So take that away. Take that away and degrade her. And I want to say that too, because I'm clearly focusing on her being a woman and the impact that had. But at the same time, I also appreciate, had she been a man, yeah, it's still just as humiliating. It's still just as humiliating. And that's the point. That was the point of it. That was the entire point of it, was to dehumanize her, make her seem disgusting, make her seem gross, make her seem like she doesn't deserve anything better than just disgust. That's part of the othering process. The othering process works through disgust. A great book on that, Jonathan Haidt's The Righteous Mind. I've mentioned that one before. Wonderful book. Talks a lot about the relationship between just social groups and the way that groups are formed and the role of disgust and how that gets policed. So that's what all of that is about. Be disgusted by her, and that will make it harder for you to sympathize with her, to look at things her way. And that would be the same whether she was male or female. Duncan, Idaho, look at how the state behaves, or how it can behave with relative impunity, with only as much power and oversight as they have now today. Just think about this next time you vote. Yeah, this is what they did when they thought nobody was watching. They thought nobody was watching. Should people not be watching police? I mean, to a lot of police, they would have it that oversight would be detrimental somehow. It would interfere. They'll be so worried about, you know, second guessing their own decisions and things like that. I gotta say, this seems to have a lot of just a real lack of faith in the populace. I don't think most people are looking for cops to be bad. We're not trying to make cops bad guys. We're not out here looking to throw somebody under the bus because they made a tough call under tough circumstances. That happens, and it is very much part of the job. But that's not this, is it? That's not this. There's no tough call about sending these texts or not sending these texts. This is your culture, and you showed it to all of us here on a national stage, global stage. Now we all know. That's how you guys treat the people you're investigating. Not like you're a service provider, protect and serve. You didn't serve Karen Read. You didn't serve Karen Read's family. And quite frankly, you didn't serve John O'Keefe's family either, did you? Because when you treat an investigation like this, when you let your bias infect it, when you decide we're going to get her, she's the one, that's the way we're going to go, you're depriving the victim of that crime. You're depriving them of having certainty over what the truth is, because you haven't investigated that. You haven't ruled it out. You got your tunnel vision and you went down this road. And that's now what we're stuck with. So you didn't serve Karen. You didn't serve the O'Keefes. You haven't served your community as a whole at all. Because here we are in this trial, all these weeks in, and this is your case. This is your case. This is it. I hit him and a taillight that was broken sometime. That's what we have so far. I see you. Proctor should have never been on the case. He lied when he said he got call at 6:50 a.m. His on-call ended 7. There is no way. Was that brought up today and I missed? He repeated today that he got the call at like 6:48 or something like that. So yeah, right before his shift would have ended, he said, yeah, Bukhenik called him at 6:48 a.m., advised that the Canton Police Department had discovered the mail in the snow. It was originally given to me as a possible medical situation. So he contacted Lank to see what exactly had happened. Lank said, mail transported to Good Samaritan with injuries. He then says he reached out to Flamati. He needed to contact the paramedic, so he reached out to Flamati for the injuries. And Flamati told him 10% chance of survival. I don't know how he would get Flamati's name right away. Maybe from dispatch. I don't know. Maybe Flamati had already filed his report. No, he hadn't already filed his report this early. So I don't know how he knows to get to Flamati, but that's what he said. So then he knew from the injuries it was more than a medical situation. And yeah, that's why, according to him, it ended up with him. To me, the timeline kind of makes sense. I think it's more of a question of should he have been recused out anyway because of the relationship with Chris and Julie Albert. They were witnesses. You shouldn't have anything to do with them. You shouldn't be investigating them. You shouldn't be interviewing them. That to me is a problem. That should have been disqualifying. But not what happened. Not what happened, is it? And I mean, of course, that's even before Colin comes into the picture. I don't know if Colin was involved in any of this. I really don't. I hear Karen saying in that statement that she made at the police department, Brian and Colin beat him up. So she's clearly fingering Colin as being part of the beat up crew. We've seen, I don't know if any of you have seen, but subsequently on social media, particularly Turtle Boy has got all kinds of videos that people have sent him that purport to be Colin Albert in a variety of different fights at school, fights in parking lot, fights in all these different places. Just going to tell you if those are legit. Those are in fact Colin Albert. He's not much of a fighter at all. He's not good. I mean, and frankly, even his own pictures, the knuckle pictures that are in evidence. Okay, if you only got one hand, you're not much of a fighter. I don't know that Colin is the one who took John on. I don't know, but is he involved to the extent that he was there and knew what was going on, knew a little bit too much? There had to be a reason for playing around with that Life 360 data. The Life 360 data, is it just wrong? It's just wrong. Just another thing in this investigation that it goes against the McAlbert narrative. So it must be just wrong. I don't know. But that would be, in my view, why Michael Proctor should not have been involved in this investigation. Far too close a relationship with people who are witnesses in the case. Britt Cormier, maybe that is why I get along with cops and defense attorneys. Marines have the same dark gallows, what people call inappropriate humor. Sarcasm becomes a second language when you embrace the suck long enough. Yeah, it's a coping mechanism. I always think of the old Greek masks, the tragedy and comedy, the laughing and the crying. That's kind of your choice for dealing with a lot of this dark stuff in life. You can break down and cry about it, or you can find a way to laugh at it. Me, I've always been a laugh at it type of person. It's just I can't say it's a choice. I can't say I sat and deliberately chose that I'm going to see things that way. It's just I think how I'm programmed to process. But yeah, if I see the absurdity in the situation, that's the choice you have, and that's how you're going to get through it. And I think that's something a lot of people in dark types of professions have in common. The police officers, the defense lawyers, the people in the service, the emergency room people, the psychiatric room people. Oh my God, the psych hospital people, those nurses. Okay, they have seen a lot. They've seen a lot. Deb gifted a membership. Thank you so much, Deb. Very generous of you. We really appreciate that. Z, woman laughing equals, the woman who was laughing in court. Jackie Dougal married to Boston police detective Carl, who said Karen guilty because didn't comfort him when her boyfriend died. Growing stalker list for Karen. Higgins, Proctor, Albert, McCabe, Dougal. Okay, so this is a piece of background information that, I'm not familiar with. I don't know who these people are. I'm assuming that Detective Carl made this comment in like to the press or something, or in an interview online. She didn't comfort him when her boyfriend died. Yeah. She's supposed to reach out to all of his people. When exactly? I mean, when exactly? In the immediate hours before they came and took her car and made it clear they're going to blame her for it? She should have comforted them. Yeah. Yeah, I didn't appreciate that little snicker that I was seeing in that testimony. I don't know if the jury saw it. I think they were out already. Duncan, Idaho. I love seeing the shift in Proctor's body language and posture from a man to an embarrassed little boy as he reads his own texts in front of the jury. Well, he should be embarrassed. I mean, of course, absolutely. He should be humiliated. He should be struggling to get these words out. And to some extent, I think we saw that. I think we saw him fight a little bit, not understanding exactly which one we're asking for. Yeah. D. Pat, if Reed found guilty, will McAlberts sue Turtle Boy? I don't know what they'd sue him for. I don't know what they can sue him for. I think that's going to be more a question of if Turtle Boy is found guilty, right? Defamation is tough, always tough. This is a high profile case. Their witnesses. Does it make them public figures? Well, I would think for the limited purpose of this case, at least, yeah, it does. Because they're in the court filings, their involvement. People were aware of that before Turtle Boy came on the scene. It's been a matter of public record for some time. So I think defamation is a pretty tough hoe to row in that situation, because you got to prove actual malice. You got to prove he's telling falsehoods that he knows are false at the time that he tells them, not that even if he's just putting stuff out there that's not true, that he's speculating about it. That's not going to meet the standard. It's not going to meet the standard. You got to prove he actually knew it was false and ran with it anyway. It's, extremely difficult, especially when you're dealing with a member of the press to meet that standard. So I don't see them suing him for defamation. Can they sue him for something else? Again, I think that's going to come down to if he's convicted or not. He's supposedly, facing trial, supposedly intimidating them. I haven't paid attention to this side of things, not because it's unconnected. I don't necessarily think it's unconnected, especially after we heard that voir dire of Lenk, where Lenk pulled this same little victim intimidation ploy to lean on those guys that were in the fight, that he got in the fight with them, and they didn't get charged for assault or anything like that. So he goes and leans on him and charges them with witness intimidation over some crap they supposedly said at a gas station. Okay, I see the game now. Okay, I see the game and I see how this works. And that, makes me a lot more suspicious that there's more of a connection here than just incidentally this guy is reporting on this particular case. Incidentally, is what is he doing? What has he done that is not speech activity? That is witness intimidation. I don't know. I haven't seen. So let's say he's convicted then yeah, they're definitely going to sue him because it's already been established that he did. Now, I'm assuming that they're the victims, of those charges. I don't know that for sure either. Like I said, I haven't followed that one close enough. But if that's the case, yeah, because it's a done deal, it's already litigated. He may not even be able to contest it in a subsequent civil case. If he were acquitted, they could try. But you know what? If the prosecution couldn't prove it, you have a lower standard of proof in a civil proceeding, so it doesn't mean you can't still win, right? We saw that with OJ. He got acquitted in the criminal proceeding, but Ron Goldman went and sued him civilly and won. It's a lower standard, so that does sometimes happen. But you'd have to think that the acquittal, if that happened, that would be pretty discouraging for your ability to go forward. How much money do they have, and how much do they want to throw at it? I don't know. I got to think Turtle Boy's got insurance. I don't know. He's independent. Maybe he doesn't. But it is pretty standard for a journalist to have defamation coverage. I mean, that's the main liability you're going to be exposed to as a journalist. So his lawyer is paid for by insurance, and theirs is not. Theirs is out of their own pocket. How much do they want to throw at it? I don't know. Bex BZ, I was surprised with info allowed in by text, like how they treated the ME. They didn't object, right? They didn't object. It wasn't particularly damaging for the defense that it came in that way. It also wasn't particularly damaging to the defense to make him read them, make him say them, make him say it with his own words, make him say it. And I honestly, I'll give the kudos to Judge Bev. She made him say the words he used. No, you don't get to tiptoe around that and play all shrinking violet, all shy wallflower with the jury right there. Oh, I can't say it out loud. No, yeah, that's what you said. So you need to say the word. I appreciated that. But I think the bottom line is it didn't hurt them. So they don't care if it comes in that way. The medical examiner she didn't agree with your conclusion that there was compelling evidence of a homicide here. She clearly did not agree with that. And your text messages are about you now again degrading her because she didn't agree. She's a whack job, just another whack job who happens to not agree with you in your view of the case. How many women on the jury? Have I seen 10 women on the jury? Think they're all going to be whack jobs when they vote to acquit Karen Read? Yeah. So I think that was a strategic decision. It didn't hurt them, so let it in. But like I said, I would like to see them get the physical paper document into evidence because it never got into evidence. Lolly never admitted it. He just let him read it on. Never put it in. It's not the way you're supposed to do things. You're supposed to put the document into evidence before you tell the jury what the contents of the document are. So I would like to see that be corrected because I want the jury to have those in their hands back there in deliberation so they can read them over as many times as they need to think about that. Tina T. This unbelievable. The fact the lead investigator is calling her all this names. I am outraged and I wonder what the jury feels. Yeah. Yep. That's what they thought about her when they thought nobody was going to see what they had to say. Retarded client. Not good. NJ Kathy with a super sticker. Thank you so much. Very kind of you. Gal Cohen, can AJ ask TP about their team's culture and if this language is the norm? Or is this too far beyond the scope and will be objected to? Love from Germany. So no, I think this is well within the scope and he certainly could ask about it. I think what he's doing though is a little bit better. It's going to be a better alternative than just putting that out there directly, because you're giving him the opportunity to wiggle out if he just sees, if he has an opportunity to try to come up with an explanation. Well, no, this wasn't the norm, but it's just, this case was so overwhelming and we were all so convinced of how guilty she was, whatever. You give him a chance to excuse it. And so instead of that, he's just established the facts. these are your supervisors and your other coworkers here on this text chain, and nobody had any problem with what you had to say. And in fact, your supervisor liked it. Your supervisor liked it. That shows the jury that this is the culture. This is that show, don't tell principle. That is the best way to present your case. You don't have to get somebody on the witness stand to agree with your interpretation of what the evidence means. If you get the facts out there and there's only one reasonable way to interpret those facts, you get to make that argument to the jury. The jury is already going to be there. They're already connecting the dots in their own minds as they're listening to this. So they've heard all that and they already know, oh my God, this is the culture there. The supervisors are in on this. They know it's the culture. So I'd be surprised if he asked him directly, just because it's not necessary for him to do that. Brenda S. Andrea, you get it. He wanted to humiliate her, and Brian Higgins was being passive aggressive with the text in the bar. He also treats women with contempt also. Thank you for calling this out. That's how I see it. That's how I see it. They wanted to try to hit her where it hurts, and that's clearly what they're focused on. Is she hot? Is she hot? That's her value to them. So anything they can do to undermine that to them is probably the most humiliating thing that they could possibly do. Haley Wolf, who would be the right person to bring in the voicemails from Karen that she left that night? Proctor, since he's the case leader, Celebrite guy, or whoever physically looked through his phone. I think it's going to have to be the person who did the extraction from Celebrite. Trying to think of a way it could be Proctor. I mean, theoretically, we know it's not Proctor because we're done with direct, right? We're done with direct, and they're not going to go back there during redirect to try to get it in from him. So I think it's going to be from the Celebrite guy, because he's going to be the one who has to authenticate it as this is the process. This is a valid process. It's accepted by everybody in the profession. And this is what I got out of it, and it's not been modified in any way, et cetera, et cetera. Those basic things that they need to do to authenticate it as being accurate, even though accurate in this world apparently may mean the exact opposite of what it is you think it is. That would be the logical pathway to me, is the guy who did the extraction. And he told us, didn't he? He told us who that was. It wasn't Dicio. It was it Brent? I can't remember. Got it in my notes here somewhere. But I'm taken up with a lot of texts. There's a lot of texts in my notes. So that whole explanation too, he got the phone at Canton Police Department. I got to think we're going to get some follow-up on that. Who at Canton Police Department gave it to you? You want to triangulate Canton Police Department on the phone? Then go all in, name the names, and then we'll ask that person. Oh yeah, did you have the phone? Where did you get it from? Why didn't you book it into evidence? How is it documented? Is it documented? Let's see here. He talks about the warrant for the Ring camera. Thought this is when he talked about some of the Celebrite stuff. He talked about the digital footprint, but they cut him off and wouldn't let him get into that. Yeah, then we got into all of his text messages. So I just might not have written it down. But anyway, I do think he gave us the name of who it was who would do the extraction. But I just can't find it real quickly flipping through here. So was it Garino? He said had the passcode. He had the passcode breaker thing. If he's the guy with the passcode breaker, he's probably the guy that's getting into the phones. So he's probably the one that's doing extractions like that. So that's my guess now, Trooper Garino. Kyle Cowden, one of my first shootings, a 12-year-old popped in a drug deal, begged me to save him. I couldn't. I'm really sorry. I'm really sorry because I'm sure that has stuck with you forever and always will. It's awful. It's really horrible stuff that happens. Very cruel world sometimes. Raina, makes you wonder why they hate Karen so much. She's the one being step up and they're treating her like a viper. Yeah. Yeah, what's the problem? What do they have against her? I gotta tell you, just gonna be honest, say what I really think. Hopefully I won't regret this. I just gotta tell you, I'm always gonna kind of look a little side eye at a man who's chronically single, late into his, into his 30s, into his 40s, and he's never had a committed long-term relationship with a woman. I'm going to look side eye at that because I'm going to wonder why that is. What is it about? I agree. It's maybe a little Freudian. I'm not blaming mom, it's mom. But environment, environment does matter, and people's ability to form relationships later in life is often a product of what's modeled for them early in the home, their own experiences with attachment with their parents and things like that. This is a guy who seems to be unable to attach long-term, strongly with a single woman, right? Karen's just a babysitter with benefits. That's kind of what tends to be reflected by a pattern of somebody who just, goes through relationship after relationship after relationship. So not saying I blame John's family, but I got questions. The biggest complaint about Karen and all of this has been what? Has been she buys people things. She buys people things and makes them uncomfortable. That was the beef in Aruba. Oh my God. The nerve. It was so weird the way she picked up the tab for the entire table. That's what you got. That's what makes her so terrible. I mean, to me, yeah, that reads like somebody who is insecure and maybe a bit of a people pleaser. She has the ability to do that, so she does it. And, that might go well with somebody who's a little bit emotionally unavailable. Relationships get toxic like that. You get caught in the chase. Somebody who desperately wants to be loved paired with somebody chronically unable to. Yeah, that can be quite toxic. So just saying, these are things going through my mind as I'm watching all this, and I don't have a good answer. I don't have a good answer for why would they hate her based on what we know? Don't know. Charles Argo, why not just think that he was drunk and fell on the fire hydrant? That should have been the starting point. This piece of shit Proctor is disgusting human. Yeah, agree completely. Isn't it strange? Yeah, how they jumped immediately from he's out front to Karen did it. I mean, instantly, that's where it started. And they never really went anywhere else. Even according to Bukhenik, well, it was domestic at 10:41 a.m. Okay. According to Proctor, they get to Canton Police Department at 10. Okay. So in 40 minutes now, they have somehow figured out it's domestic, which means it's Karen. They just don't know the mechanism yet, right? Maybe he was hit in the face with a cocktail glass. Maybe she did it that way. No, it's later on they have to settle on she hit him with the car. But yeah, that's a great question. Why would we not start from the standpoint of he slipped, something else happened, it was an accident? I don't know why we started with, oh, it was domestic. How did we get that? There was no evidence of any type of domestic before this point. They didn't have Karen Reed's phone. They didn't have these Aruba witnesses. They didn't have the angry voicemails that we've heard about but haven't yet heard in this case. They didn't know any of that stuff. So what did they know? They were all lovey-dovey in the bar the night before, like so much so that the Kolakithises commented on it. Wish you'd be like that with me. We see it on the video ourselves. You know, they're hugging, they're happy. And at least according to everybody who testified from the waterfall, yeah, perfectly normal, no conflict. So why are we thinking there is a domestic now? Where did that come from? Why was it Karen who threw a cocktail glass at him? Why did it have to be her? Don't think that it did. But when you went to ask Jen and Matt and Brian, they told you a story and you just took that at face value and ran with it, didn't you? Last one, guys. Z, Turtle Boy's findings have been shown in court and lawyers have duty of candor to court. What happened to First Amendment? Isn't cover up beyond harassment? I mean, the First Amendment implications in the Turtle Boy stuff to me are quite obvious. I mean, without even knowing anything about it at all, other than just the general, he's been charged with witness intimidation based on these what appear to be protest types of events, right? These aren't situations, as far as I know, where like he's calling people to, you know, threaten them with violence, you know, you better watch your back types of things. He is expressing his disapproval of what he believes to be their course of conduct. And yeah, that's a First Amendment protected activity. That's not witness intimidation. If a witness doesn't like that people think you're lying, well, then testify truthfully. Okay. I mean, that's pretty much the bottom line. You know, life is hard sometimes and you got to have a little bit of a thick skin. That's just how things land. You know, you're in the middle of this. Maybe you didn't ask for it. Maybe you really think it's completely unfair. But he has a right to have his opinion to the contrary, and he has a right to voice his opinion to the contrary. So the whole dividing line between protected First Amendment activity and things like harassment and stuff like that can be prosecuted as criminal conduct is conduct. It's conduct. You can't just penalize somebody because their speech is bad. It has to be because of either the effect that it has in the sense of like, you know, it's okay. Let me backpedal. Content wise, to punish somebody for speech has to be a true threat. Okay, has to be a true threat. This has come out through the recent Supreme Court decision. Counterman v. Colorado clarified kind of what all this means. Harassment requires a true threat. You're intentionally trying to communicate to somebody, or at least recklessly. That's what Counterman told us. You're at least recklessly communicating to somebody a series of expression of an hint of intent to inflict death or serious bodily harm. That is what is not protected under the First Amendment. And so you had to do that at least recklessly, knowing that they were going to think this was a threat. You don't have to intend it was a threat, but you know, if a reasonable person, it's bad enough that you know, outsiders looking at it would be likely to think that this is probably a threat. Then that's going to be good enough, according to Counterman. So that's the kind of content you need to have if your speech is going to be punished just on the basis of it being speech. If that's not the speech that you're dealing with, then you have to look at the course of behavior, and that's what it is that can be criminally punished. So it's not the content of what you're saying. It's the fact that you're doing it repeatedly. You're doing it knowing that it's unwanted. You're doing it at odd hours. You're doing it with a specific intent, either to harass the person or to coerce them into changing their testimony or something like that. or you're doing it, what was I thinking? The day is catching up with me. The early morning is catching up with me now. You're doing it without any type of lawful purpose, you know, without, you don't have a good reason to do it. You're just doing it to torment them or to harass them. The reason why it came back to my mind is because old Alice Evans, if you saw any of those videos way back when on my channel, that case seems to be wrapping up. Don't know if I'm going to have anything official to report about soon, but long convoluted divorce and custody case. Not real pretty. Anyway, hundreds and hundreds of text messages from Alice to her now ex-husband, Yohan Griffith, that she admits in the text, I'm just tormenting you. Like, these are not things, she's just, you know, texting abuse at him, calling him names, things that have no legitimate purpose except to cause him anxiety, you know, cause him discomfort. So it's the course of conduct that gets penalized in that type of situation. I mean, where is the similar course of conduct here? It has no lawful purpose. His lawful purpose is being able to exercise his First Amendment activity and to draw public attention to something that he thinks is an injustice. Yeah, that's a right that citizens have. It's protected by the First Amendment. So, I mean, I know there's going to be a lot in the details that gets fleshed out in court, and, you know, probably he said, she said kind of stuff about what happened to. I don't know all the details about that. But yeah, when I first heard that this is what he's being charged with, and this is why, this is the basis, yeah, of course, there's going to be major First Amendment implications with all that. So the lawyer's duty of candor to the court, yeah, that's a whole other thing. They do have a duty of candor to the court. But, you know, a lot of judges sure seem real tolerant of attorneys that like to play around in the gray area. Lally plays around in the gray area. He did that today. He did that today with this motion. And the truncated quotation, this is the same thing, the same weasel stuff that we saw from Bukhenik, right? Where it's probably technically true. It's probably technically in the transcript like that. But you just present it in a way that's out of context, that presents it as misleading to suggest it means something other than what it does. Some judges would not tolerate this, okay? They would at least give him a warning. You know, Mr. Lally, if you're going to persist in coloring the facts like this, it's going to cost you your credibility of the court. See, I need to be able to rely on what you tell me the facts are. And when you make it clear that your representations are not reliable, you put me in a situation where I have to go and double check everything you say, which I don't appreciate because I got other things to do. Some judges would not tolerate that, but Bev seems okay with it. Weird. Doesn't seem to mind it at all. One more came in. WM Penguin. Have we considered that the cover-up is just with the Alberts and that Proctor is just that much of an ass that he trusted what they said? Maybe, but we still got to get to the tail light. We got to get to the tail light. And unless we're going to get to, you know, Kevin Albert did it, you know, then he's got to be involved. He's got to be involved in it, at least to that extent. He's the one that had the custody of the evidence. So if there was planting of things and manipulation of things and stuff like that, hard to see a situation where it's just the Alberts. Now, having said that, would it make sense that the Alberts were kind of running the show and they simply gave him his marching orders? Here's what the story is. Here's what you're going to run with. Make it happen. Yeah, I could buy that for sure. You know, I don't know that Proctor is the brainchild of any of this. Having seen him testify, I'm not sure that brainchild would have survived infancy. But you know, would he be a good lieutenant? Would he be a good lieutenant and just, you know, carry out his orders? Yeah, he might. He might. Get the message. This is where you're supposed to go with it. I could totally see that. All right, guys. That was quite a day. I don't know that I was prepared for that roller coaster, but man, we got it. And I'll tell you what, I didn't get sleepy. Never once throughout the whole course of that did I feel like, you know what, I need to take a nap, even with all those lally directs. Even with all those lally directs, it really kept me going all the way through it. So it looks like we are coming back Monday morning at the normal time. So I will be back on at 5:45 Pacific, getting ready to start at 9 a.m. Eastern. So we got the day off tomorrow, but back Wednesday, Thursday, Friday. Don't know at this point if we're going to get this voir dire or not. It kind of sounded like she was saying Friday. I don't know, because then she's saying they're going to have all the full days. She's being very unclear. I don't know how exactly that panned out, but we'll see if we get it, and we'll see if we get to see it. If it's a voir dire, it should be on the record in open court, so we would get a little preview. Wouldn't that be fun? See, these voir dires, they can be a mistake. They can be a mistake. You know, I kind of thought this before with Lank. We saw that that defense voir dire of Sergeant Lank, because he's got the whole problem with that background with the fight and you know, the covering up, and then we heard about the investigation of was it Tim Albert, who was in the hit and run and had to track his car over to where it was parked at Brian Albert's house, you know, follow the trail of the leaking transmission fluid or whatever it was. Heard a lot of bad stuff. But the problem is it gave him an opportunity to practice how he was going to answer. And I mean, there's something to be said for spontaneity and just the inspiration of that moment. I didn't feel like Mr. Jackson's questions were as good the second time around. You know, he wasn't as sharp. Lank had already gotten a chance to rehearse. It just, for me, I feel like it probably fell flatter to the jury than it did when we heard it the first time around, even accounting for the fact that we got to hear stuff the jury didn't ultimately get to hear. Just gives them that chance to rehearse and stuff. So that was a situation where I don't think the voir dire helped. Right now, this is Lally getting what he asked for good and hard. We're going to get the preview. If we get to hear this voir dire, which we should be in open court on the record, we're going to get a preview of the defense's technical case, the accident reconstructionist, and we're going to hear all this before we hear from the Commonwealth's witnesses. Are they going to get to the medical examiner and all that before we have this voir dire? I don't know. Maybe we will, but I kind of doubt it. Have we been stuck at over 30 witnesses for like forever now? I mean, I know we're still at a lot because it's taking forever to get through all of the law enforcement. Let me see if I can do a quick count here, because we heard from Proctor now. We heard from Bukhenik. Haven't heard from any of those people. There's Nicholas Guarino on the list. He's the one that I think probably did the extraction. We heard from Nicholas Barros. Okay, so on the first page of their witness list, we still got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 people just on the first page. 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. We're still at 30 witnesses to go. Okay. No guarantee they're going to call anybody. And, you know, in particular, they could certainly choose not to call some of these people. And that may end up, you know, being the case. Like there's a guy here from the crime lab they haven't called yet. He must be DNA or something like that, because we haven't heard anything from DNA. There's actually 2 of them from the crime lab I see that they haven't called yet. So that must have to do with DNA, because we haven't Haven't heard anything about that yet, but we're told that that's coming. He told us that in opening. So yeah, I mean, who knows? Who knows what order we're going in, what we're going to get to? He's not going to get through all of those witnesses before Friday afternoon if that's when this voir dire happens. So imagine that scenario. The entire world knows the defense theory of how this doesn't work before they hear your theory of how it does. I mean, this is own goal stuff. This is own goal stuff. Yeah, okay, the jury's not hearing it, but just as well as everybody else does, this case is being tried in public. The public is watching. The public is judging you. The public is reaching its own conclusions about what's happening here. So not sure that from a strategic standpoint, this is a great call from Mr. Lally, but, when have we seen him? When have we seen him being a master of strategy up to this point? Doug Murphy came in with a late super chat. Thank you so much, Doug. Really appreciate it. So we'll be back Wednesday morning for more cross. I mean, it's gonna take a while, right? It's gonna take a while. Surely they have a lot of stuff to cover. Surely they have a lot to cover. But I'm gonna look forward to it. We know there's texts in there that they haven't even got to yet. I hope she kills herself. I remember that one coming up in opening. Hope she kills herself. Yeah. Real impartial, that one. Why would you hope that she killed herself? So that your little investigation here doesn't come under scrutiny? Same reason you might lean on her with excessive charges so that she would plead and none of what's happening now would ever happen. That's my theory. They thought they were going to lean on her and get her to plead. That was why they did it this way. That was as far as they thought. They didn't think it was ever going to, go any further than that. Never thought they were going to have to back any of this up in court. Never thought it was going to be under this type of scrutiny. And certainly never thought that the things that they were saying behind the scenes were going to be uncovered by the FBI and turned over to the defense. Never in a million years did they think that was going to happen. I sure wouldn't have thought it was going to happen. And I've said from day one, that's what really grabbed my attention in this case. TUI, the feds are involved and the feds handed this all over to the defense during an active investigation. Unheard of. Completely extraordinary. Well, guys, enjoy your day off tomorrow. I'm going to enjoy my day off tomorrow. I'm going to enjoy my afternoon off today. See if maybe I need a little nap before we go spar tonight. But it's okay. My blood pressure is back down. I tend to regulate my emotions pretty well. So I'm not gonna take out my feelings about Trooper Proctor against anybody at the gym. I mean, unless I feel really motivated to. But plan to see you back bright and early on Wednesday. And we'll see where this goes. We'll see what they have to bring. See how much fun Mr. Jackson has with this cross-examination. Yeah, this is the stuff where you envy other lawyers for their cases. You really do. Like, oh, how lucky is this guy to have this one fall in his lap? But I'll say too, it's a mixed bag because the pressure he is feeling, believing his client is innocent and that this prosecution is a complete injustice, and yet there is a risk that she will go to prison. To prison. The pressure is enormous. So I know that he is very stressed. He is losing sleep. This is his reward. He gets to have this cross. So I hope he thoroughly enjoys it. So guys, take care. Appreciate you all being here. Thank you so much for your support. Thank you so much for all your comments, your chats, the great culture that we have going on here in this chat that I really appreciate. All of your kind words, your support. I'm just very grateful to be able to share what I've learned from my experience for whatever it's worth. You can, I'm nobody special. I'm just one more defense attorney out there who's been doing the job for a long time and seen a lot of stuff. So the fact that so many of you are interested in what I have to say, it means a lot to me. I really do appreciate that. So thank you so much. And I'll look forward to seeing you on Wednesday morning. Take care, guys.